Court officer. Sir, court officer.
ಹೇಳಿ ಸರ್.
ಇಲ್ಲ ಮೈಕ್ ಚೆಕ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಅದಕ್ಕೋಸ್ಕರ.
ಸರ್ ಹೇಳಿ.
ಇಲ್ಲ ಏನಿಲ್ಲ, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಹಾಲ್ ಮೈಕ್ ಆಫ್ ಆಗಿತ್ತು.
ಮೈಕ್ ಆಫ್ ಆಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಮಾತಾಡೋದು ಅಷ್ಟೇ.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗೋವರೆಗೂ ಮ್ಯೂಟ್ ಎಲ್ಲ ಇರುತ್ತೆ ಸರ್, ಯಾಕಂದ್ರೆ ಅನ್ನೆಸೆಸರಿ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಆಗುತ್ತೆ, ಅದು ಲೈವ್. ಏ ರವಿ, ಇವತ್ತೊಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದು ಮೇಡಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಪೆಂಡಿಂಗ್ ಫೋನ್ ಮಾಡಮ್ಮ. ನಾಳೆಗಾದ್ರೂ ಅಟ್ಲೀಸ್ಟ್ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ, ಮೇಡಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಅದಕ್ಕೆ. ನೋಡಿ ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ನೋಡು ಮೇಡಮ್, ನೀವು ಆ ಕಡೆಯಿಂದ ಬಂದಲ್ಲಿ ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ನೋಡಿ ಡೇಟ್. ಮೆಮೊ ಬುಕ್ ಕೊಡು ಅವ್ರಿಗೆ, ಯಾವ ಡೇಟ್ ನೋಡು. ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ರು.
Your Lordship, one humble submission, Your Lordship. This is a pending matter, Your Lordship. I am for the petitioner. Respond number 1 to 3, there was a status quo against them. They have alienated the property. I filed a 39-2A that has been dismissed, my lords. Your Lordship had directed me to serve it on the respondents. I have
All those kind of mentions, write the reason and give it to the court officer.
Please.
I will look at it and assign a date.
Please.
Except 2:30, no other mentions to be made.
grateful.
Yes. I said only 2:30 to be mentioned, remaining, giving the reasons. If the memo doesn't contain reasons, I'll write on that. It doesn't contain reason, I'll not give any date. If you
my
write
lords,
the
this
reasons,
is
I'll
to-
consider. Give it to the court officer. First of all other memos, give it to the court officer. Then I'll hear the 2:30 matters.
My lords, this matter, my lords, this is for settlement, my lords.
ಇದು ವೆರಿಫೈ ಮಾಡಿದ್ರು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಕಳಿಸಿ.
Notification with regard to the nursing course malad which is commencing from September malad, the years you are actually has disposed of the matter. And not one time after hearing the other parties malad, I have stated that I will produce the notification copy malad. Last week it was listed malad, but it is not reached malad. In fact, today it is posted for orders for with regard to police protection.
How many times I should hear that matter then? How many times the matter should come? One for the disposal, then again IA also has to be heard out of turn. Give it to the court officer, will see.
My lords, one submission, my lords, list 2, serial number 13, my lords. The matter in trial court has been posted for judgment on tomorrow, my lords. Kindly have it at the end of the list, my
When
lords.
did you file that?
In the year 25, my lords.
25 matter will obviously be posted
My
for
lords, it is
judgment.
continuously listing, my lords, but it is not reaching.
It is only 2 months. 25 is like it about, this court's roster has started only in the month of June. What has happened before that? You have never obtained a stay. If
No,
there is no stay, the court will pass orders.
My lords, it has not been listed at all, my lords.
That is not
Whenever
the
it is
problem of
listing,
the
it is
court.
being adjourned, my lords. My lords, kindly have it at the 2:30, my
I
lords.
have a submission to make, my lords.
My lords, the judgment is on tomorrow, my lords.
Let it pronounce. When there is no stay, the court will do it. Why should we stop it?
My lords, I have a
But it will be
submission to make,
arbitral
my
order
lords.
judgment, my lords.
Then what are you doing from the last 25th, in which month you filed?
Not aware about the month, my lords.
This
Well,
is
let's kindly
what,
have
this is
it.
what, because the court is accommodating, everybody wants it to be heard today, afternoon, and in the tomorrow morning. And all the while you people have kept quiet, by filing the matters in 25 and waiting till now. Yes.
My lords, kindly have it, my lords.
After filing of this writ petition, my lords, the sixth respondent has.
Is it necessary to take up this matter at 2:30?
No, my
If
lords,
not,
tomorrow
don't
matters.
mention.
My lords,
Whatever the reason you want to say, write it on a paper and give it to the court
To
officer.
paucity of the time, it was adjourned on 6/8 of 26, my lords.
Hmm?
Kindly may have it on, due to paucity of time, it was adjourned on 6/8 of.
Why are
26,
you
my lords.
mentioning? I think I'm very like, I'm speaking in English. Isn't it? I said, other than 2:30, don't mention. Write the urgency on the paper and give it to the court officer. I'll look at it in the afternoon and I'll assign the dates. Yes, next.
Lord, serial
My
number
lords.
61, my lords, was listed on Friday. My lords had directed the registry to list up serial number 1 today. It's not listed, my lord. We were led by senior counsel in this matter.
What is urgency today?
My lord, it's an execution matter, my lord.
Huh?
Deposit of withdrawal of money, my lords.
No, if it is not listed, it will come tomorrow. What will happen now? Not necessary that we should take up.
Serial number 1 today, my
If it has not come, we will see. Give it to the court officer. I will see.
Number
Write the reason on that and give it to the court
my
officer.
lords,
ಮೆಮೊ ಬರ್ಕೊಟ್ಬಿಡಿ.
Serial
Memo
number
ಬರ್ಕೊಡಿ.
105, your lordship. The matter was listed on Thursday.
And the curator had sought for an adjournment stating that the name was mentioned wrong. Today the matter is listed, Your Lordship, but it's under B group hearing. The matter may be taken up today or tomorrow or day after under preliminary hearing, Your Lordship.
What is the serial number today?
10.
If it is 103 today, if the court completes 50, 60 matters today, it will come after as a immediately in the priority.
No, Your Lordship,
So-
listed under B group, it may be taken.
Still
up
it will list, still it will come, we'll see. Yes.
My lord.
My lord, 39, 35 ಇದೆ serial number ಅಲ್ಲಿ. So extreme emergency ಇದೆ so that trial court ತುಮಕೂರಲ್ಲಿ ನಡೀತಾ ಇರೋದು proceedings ಗೆ stay ತಂದಿದೆ vacate ಮಾಡಬೇಕು ಅದಕ್ಕೆ first list ಗೆ consider ಮಾಡಿ ಅಲ್ಲಾದ್ರೂ proceedings
Why you should be taken? Why you should be taken in the first list? Why it should be taken up in the first list?
ಅಲ್ಲಲ್ಲ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗುತ್ತಾ ಇಲ್ವೋ ಅಂತ ಒಂದು
That is everybody's problem. You are not an exception.
My
Yes.
lords, the
The part-heard matter, and the senior citizen, petitioner is a senior citizen. For past 26 years, they have not paid the rent file. So this.
Yesterday one mentioned, the other day one mentioned. I gave the memo. Now it will come in the list. For that again another mention saying that you take it out of turn. That is unreasonable. Please don't make that kind of request. Yes.
My lords, the parties before the trial courts, they have settled the partition suit, my lords. And for
Asking why are you, is it at 2:30?
no, my lords.
Write it on a paper and give it to the court officer. If anybody.
My
in
lords,
spite
it's
of
only
me,
to refer to
thinks
the mediation, my lords.
So what is to be done? It has to be listed or not?
Please, my lords.
For that, what you are supposed to do? I'm telling you, give a memo to the court officer.
It's given, my lords.
Then I will look into it.
Please, my
I can
lords.
read English.
Please, my lords.
But the problem is you are not understanding English.
My apologies, my lords.
Yes,
But the matter is in the trial court for today, my
I'm-
lord, for defense evidence, my lord.
when did you file the writ petition?
My lord, in the last date, the respondents came and told they are ready for settlement, my lord, but because of that, the matter was.
When was the matter filed?
25, my lord.
Yes, I will not take it up at any cost. Yes.
Your lordships heard this matter on Friday and reserved it. One question came up as to what happens if execution proceedings are filed post-award, my lord, post-award section 9.
You can give it
I'm
to the
just
court
giving a
officer.
judgment, my
Yes.
lord, I wanted to
Call the
mention.
list.
My lords, serial number 13, my lords, list 2, my lords.
Lords. 40? In the first list. List this matter in the month of November.
Lordship. One matter 13. One matter 13. Size matter. EC unilaterally passes an order suspending my CL license, which is issued in the year 2004. Government order.
If you take it up tomorrow, what will happen?
But the issue is that now the police officers along with the district officers have been under arrest. But they're
When was the order passed?
Yeah.
When was the order passed?
So the passed on 20th of this month. Within 7 days, just because of political influence, that you're making hectic efforts to dispossess me from the property. The premises is housing 40 to 45 staff members. Everything would be.
Yes, 2:30.
My lords. My lords, list 2, serial
I've
number
rejected your
13, my
request.
lords.
Kindly,
my lord.
Serial number 14, short accommodation. 14, my lord.
Yes.
Next week, any date, 14. 1/4.
No, next week. If it is adjourned, I will
We have a
grant.
fresh matter, my lord.
What is the reason?
Senior is out of station, was an emergency due to his mom is admitted in the hospital.
Does this matter on 4th of August?
Obligation.
Serial number 51, my lord. This is for non-filing of acknowledgement.
Lordships, kindly, my lord.
Non-filing of acknowledgement of hand summons. I have done the needful on 25th Saturday, my lord. Maybe noted and date may be given, date or any other day.
We'll see when the matter reaches. Yes.
For pronouncement of order, list.
My lord, in your list number 2, my lord.
Yes.
The serial number 28, my lord.
Yes. What do you want?
My lords, your lordship is referring to me, my lord. The matter, may I request your lordship to kindly post this matter any date on the first list, my lord. This is the 4th time or the 5th time matter is coming in the second list and not.
Unless and until you tell me the urgency, it can't be posted in the first list.
My lord, my application for amendment has been rejected. My production of document has been marked. Matters posted for final hearing day after tomorrow, my lord. Hence, my lord, I'm making a request. Any date to your lordship's convenience, the first list, my lord.
Yes, tomorrow.
Lordship, serial number 107, Lordship. Settlement talk is going on, Lordship.
Yes.
List number 2, my lord, now serial number 21, I pay for short accommodation.
List it in the month of 20.
Madam, I appear for respondent. I have filed vacating stay.
Vacate is there.
Vacating
Yes,
stay.
I'll not adjourn that matter. Yes, next.
Lordship, Lordship, serial number 107, Lordship. Settlement talks is going on, Lordship. Please, Lordship.
Settlement talks only known to the petitioner or respondent also knows about the
Both,
settlement?
Lordship. Yes, Lordship. Both, Lordship.
Have you
107.
informed the other side?
Please, Lordship.
Shall
I have
I record
informed,
it?
Lordship. Please, Lordship.
Shall I record that you have informed?
Please,
Yes,
please,
it is
Lordship.
submitted. The
Settlement talks.
settlement talks are going on. 106, list this matter in the month of October.
107, Lordship. 107, Lordship.
107 in the month of October. Please call the
Please,
list.
Lordship. Interim order may be extended, Lordship.
Interim order extended.
Cell number 1,
Please,
Lady Narasimhan, petitioner.
I appear for the petitioner.
Dismissed.
Great.
Cell number 2,
Appear for petitioners.
Yes. That petition is dismissed.
cell number 3.
Waiting for the petitioner.
Dismissed.
Cell number 4 for orders matter. Sir, DS.
Appear for the petitioner in this case. I have filed a memo for withdrawal also.
That MMO is filed stating the trial court has vacated the interim order on 21/11. Suit is decreed.
Decreed you.
Suit is decreed on 21/11/2025. Hence, nothing suffices for consideration in this petition. And the
Obliged.
petitioner wants to withdraw the petition. Dismissed as withdrawn. Memo is taken on record.
In the hearing, cell number 5.
I appear for petitioner, my lords. Suit for specific
Yes.
suit for specific performance was filed on the basis of the registered agreement at
Notice
produced at annexed.
2024 matter. 2024 matter. Notice to the respondents. Yes, 6.
Cell number 6.
An
Dilip Kumar.
application has been filed for
Notice
rejection.
to the respondents.
Cell number.
This is with regard to the covered by the judgment of the apex court. This with regard to the nature of the suit, whether the commercial
Whatever it
court
is,
have
it's a
got jurisdiction
2025
to
matter.
entertain.
Nothing to be considered for an interim order now.
But that is in the stage of the
No.
evidence. If the evidence
What
is
are you doing
continued,
2025 matter till now without an interim
immediately the
order?
writ petition is filed, my lord.
Huh?
The immediately writ petition is filed, my lord. Immediately we have moved the matter. Anyway, luckily today it has come, my lord. At least if it is
You that,
proceeded.
let us see what is happening from 25. You have complied with the office objections on 6/7/2026, a writ petition of 2025. Notice to the respondents.
The date may be fixed, my lord, at
Number
least.
7.
The grievance is the jurisdiction the court is
We
proceeding
will
with.
see. We'll see. Notice to the respondents.
The date may be fixed.
This is the month of September.
Cell number 7. Arun KS.
This case I represent the petitioner, madam.
Yes.
My lord, the petitioner has filed a suit for partition.
Yes.
The respondent.
Also a 2025 matter.
Please, my lord.
Notice to the respondents.
Please, ma'am.
Number 8. Aditya Adi.
I appear for the petitioner matters.
Yes.
As the petitioner has filed OS before the Sagar court in OS 6/2022, my lords, seeking for partition on a property that is acquired by the mother. So, in fact, the father of the petitioner.
What is the IA?
My lords, there's no IA, my lords. There's an interim prayer to stay the operation of judgment in miscellaneous appeal 1002.
Just like that, without an impugned order. How come these kind of writ petitions are listed? And what is happening to the registry? No impugned order.
There's an impugned order, my lords.
That is what I'm asking you.
At Annexure A, my lords, but you not filed a separate application to that effect, my lords.
I said, where is the impugned order? This is
Annexure A, my
IA.
lord. I apologize. Annexure A, my lords.
Page number?
Page number 16, my lords.
The miscellaneous appeal filed by the appellant is hereby allowed. Impugned order passed on I number 3 by the trial court. What is the order that's granted by the trial court?
An order of injunction restraining the defendant number.
That is set aside by the appellate court.
Set aside by the appellate.
Please come to the order.
Annexure F, page number 59, my lords.
Please come to para 15.
Please, my lords. The defendant number 9 is the subsequent purchaser of the property, my lords. The prior disputed property.
Para 17, please read. Para 17 of the impugned order at page 29.
Further, it is pertinent to mention here that the concept of joint family and ancestral property is alien to Muslim law. Whatever property one inherits is at Muslim law one's absolute property, whether that person is a man or a woman. In Muslim law, so long as a person is alive, he or she is the absolute owner of his or her property. Nobody else has any right whatsoever in it. It is only when the owner dies and never before that the legal rights of the heirs accrue. There is therefore no question of would-be heir
Oh,
dealing
I've seen this order. What is wrong with the order?
Manoj, but what we are contending is that the name, signature of the defendant number 1 was fraudulently obtained. That is the mother of the.
That's in 2003.
2003.
Several state deeds were executed from defendants 1 to defendant
1
9.
to 6.
9.
9 is the subsequent purchaser.
Purchase. That's what till defendant 9. Several state deeds were executed. That's from 2003. It's a registered document. After that, the title has gone to so many people. So how are you entitled for injunction now? That is what is observed by the court.
Yes.
It's a categorical finding.
Malaj, it may be posted, Malaj. Until then, there may be an interim.
No, I'm not going to post it. I'm going to dismiss it. If your senior wants to come, I'll adjourn this matter. But
Malaj, it may be adjourned for next week.
Yes. This is matter on 5th of August.
Obliged.
Number 9.
Petitioner in this matter, my lord. Seeking a mandamus, my lord, registered owner of the oil tankers, non-use of the vehicles. And now I have submitted my representations, my lord, to reconsider my plea, which has not been taken note of by the registering authority.
Earlier representation was given, my lord, that was considered and the endorsement was issued. Again, my lord, note that.
How many times he will do it on the same grounds?
So, no, my lord.
Once he has rejected it, once he rejected it, you have to avail the appropriate remedy. Why do you want him to again reconsider it?
May, my lord. There are two files maintained in the office, my lord. The two files maintained in the office, one is the registration file and one is the non-use. During COVID period, the vehicles were kept under non-use. The authorities, without looking into the non-use file, my lord, they once for all give your plea will be considered only after payment of tax. Here I have sought for the non-payment of tax for the reason that the vehicles were non-used. So you look into both the files, then pass appropriate orders is the only my plea. If that file were to be looked into, my lord, all the issues will be resolved.
I will secure instructions. I will take notice and secure instructions.
The issue will be
Whatever you
resolved.
want to do, you do. If you don't want to consider, tell him will not consider. Why should you unnecessarily keep it pending for the simple
Let
reason?
them look into both the files
Oh,
and
we
pass
are
orders.
not, I'm not granting any positive direction to you to do something. If you say that it is not, his application cannot be considered, don't consider it.
Please.
I mean, pass orders considering it. The present writ petition is filed seeking the following prayer. It is a case of the petitioner that earlier he has given a representation dated
Well, 17/1/24 and 21/3/24.
21/3/2024, both of them were considered, and the respondents have rejected the representation. It is submitted that while considering the said representation, both registered maintained by the petitioner, maintained by the respondents were not considered. Hence, he has given a fresh representation dated
9/2/2026.
9/2/2026, requesting the respondent to consider the same. It is a grievance that, though it is given in the month of February, the respondents have not considered the same. Next, Parallel Counsel, Leonard AGA, Leonard HCGP, who takes notice on behalf of the respondents, submits that already they have considered the representation and rejected the same. And whatever is a available remedy to the petition, he has to avail the same. And again, question of consulting the second representation will not arise. And it is submitted, the writ petition may be dismissed. Next para, having heard the counsel for the petition, the Leonard AGA, HCGP on behalf of the respondents, this court has produced a material on record. No doubt, the respondents have already rejected the representation. It is a contention that they have failed to consider the two registers maintained by them. Hence, he has given another representation dated 11/2,
Well, 9/2/2026.
9/2/2026.
Different dates.
In the considered opinion of the court, when they have given a representation, whether he is entitled for that or not, the respondents have to consider the same and pass appropriate orders. In that view of the matter, this court is passing the following order. The writ petition disposed of, directing the respondents to consider representation dated 9/2/2026 in accordance with law within a period of
2 weeks, my lord.
within a period of 2 weeks from the date of receipt of the copy of the order.
Presentations are all different dates, my lord. Annexed D to D7 and E to E.
No, E2 E1.
The representations given by the petitioners, that is
Annexed D to D7,
annexure D to
D7
D1 to D7.
D7.
and E to E13.
E1 to E13.
E1 to
What are they?
Different dates, that's all.
Different dates, my lord. That is some.
Makes
We are only issued under.
We are making it complicated. All representations are one and the same. So this is fine. You consider only this. Yes.
Number 10,
It is submitted that by the Leonard AGA that in his contentions that the petitioner has given several representations to the petitioner which are filed before this court, which are running into around 15,
13.
Annexed D1 to
around
D7.
13.
1/3.
Around
Because the 7
13.
vehicles.
Next in the operative, considering the fact that several representations are given, but ultimately the representations are concerning one and the same aspect. Hence, this court deems it appropriate to direct the respondents to consider the representation dated 9/2/2026. It amounts to considering all the
Please.
representations. Yes.
cell number 10, Tera JT for petitioner.
Appealing for petitioner. Praise time.
Why?
Senior is out of station.
This matter on 11th of August. Yes.
Cell number 11, Unni Krishna Net for petitioner.
Minutes. I appeal for the petitioner in this matter, Minutes. Here, the petitioner is challenging the statutory benefit that the LAC order has been made with respect to at the rate of 12% from the date of the preliminary notification. My concern is with respect to an execution petition that has been preferred, Minutes. However, my challenge is not with respect
According to you, what is the interest bill?
9% millets from for 1 year, and later on 15% has been awarded millets. The
How is
total
it bad?
compensation. Yes, millets. I'll can take
Come
my
to
last.
the operative portion of the order.
Yes, millets. Answer page 33.
33 or 37? Operative portion. Award, let's see
33.
the award
The award is,
at 37.
yes, my lords,
Ah.
one,
You are agreed by this?
yes, my lords.
Yes.
Further, it is ordered and awarded at page 37 and last point. Further, it is ordered and awarded that the petitioner is also entitled to a solution at 30% on the enhanced market value with additional market value of 12% per annum on the enhanced market value under section so and so. The act from the date of the preliminary notification till the date of the award. Further, it is ordered and awarded that the petitioner is also entitled for interest on the enhanced market value at 9% for the first year from the date of preliminary notification and thereafter 15% per annum till the date of deposit of the enhanced amount in the court as per.
So what is the law on this?
Melons, I would like to submit that from the date of the possession that is being taken, the computation of the amount has to be calculated. However, I am not with respect to the amount that is being awarded.
No, I
because
understood
MSc, we had also
So you're
prepared
saying
an
interest
MSc.
is bad.
Yes, Melons.
So how I'm saying, how it is like, what is the law on that?
The law and the point is, Melons, I'll appraise my laws with respect to that. But now an execution petition, my only concern now is that an execution petition
No,
is
if I have to interfere with this order,
Yes,
you
Melons.
should first tell me how it is bad.
Yes, Melons.
So judgment is first, order is next.
Yes, Melons.
I'll take it up. I'll take it up tomorrow.
Melons.
I'll take it up tomorrow in the first list.
Melons.
Pass over?
Melons, let it be passed on.
Yes, pass.
Well, Neeraja, Rajiv should.
For petitioner, a connected matter notice was issued. Notice may be
List
issued.
along with, give the number, list
Ah.
along with so-and-so, notice.
Already listed.
Where is that?
12.1 notice has been issued. 12 notice has not been issued. Notice may be ordered.
Notice in 12 also, notice,
And hand summons to the council even in 12. I will take it up on the.
same hands amounts. Why you
Date
have
may be
not
fixed.
filed the memo in the other one in 12.1?
This matter came up the next day. I will serve on both same
Yes,
council.
next, 13.
Cell number 13.
Grateful.
JNTR for petitioner.
Appearing for the petitioner, Your Worship. Petitioner before this honorable court challenging the impugned order dated 15/4/2026, Your Lordship, which was filed under Order 1, Rule 10 subclause 2.
What is the suit for?
Your Lordship, suit for partition, Your Lordship, which is in FDP stage. And the petitioner is the beneficiary of the will which was registered back in 21/9/2025, Your Lordship.
You are not a member of the family.
I am the second wife of the defendant number 1, Your Lordship, which is a registered marriage, Your Lordship.
Second wife.
Please, Your Lordship.
Come to the order.
Please, Your Lordship. The very same fact was observed in Ashwatthama versus Vijaya Raghava case in CRP number 240 of 1994, Your Lordship. I may be permitted to pass on the.
No, we'll read the order first.
Please, Your Lordship. Page number 15, Your Lordship.
Come to the reasoning part, 18.
Page 15, Your Lordship.
Internal, the page, running page
Lordship.
18.
Please, Your Lordship.
Paragraph number 8,
Eight.
the reasoning part, come there.
On careful perusal of records, it is worth to note here that based on compromise entered in RFA number 307 of 2008, present petition filed under filed to draw final decree proceedings and to determine shares of the property parties by meets and bounds. When matter posted for appointment of commission to ascertain feasibility of division of property as per terms of compromise, applicant claiming to be the second wife of Mr. Christopher Ray, who is the defendant number 1, has come up with the petition, present application with specific contention. She is necessary party to the petition, Your Lordship. According to the application, she is married to Christopher Ray on 29/2021 at so and so place, and their marriage is registered on so and so sub-register office, Bengaluru. Along with the application, applicant has produced certificate issued by Office of Marriage Register, Bengaluru, and marriage photos also.
Where is the
along
judgment what is the judgment you're relying on? Take
Your
that,
Lordship.
take that.
Lordship, in the present case, Your Lordship, in Ashwatthama versus Vijay Raghava, there the trial court and Honorable High Court has upheld the order application filed by the respondent, Your Lordship. There the objection by the petitioner was that he is the adopted kid. The adoption procedure was not taken properly, Your Lordship. But the trial court has allowed the order 1 rule 10 subclause 2, which was filed by respondent, who is the son of defendant number 1, also the beneficiary of the will, which was registered by the defendant number 1, your lordship. Kindly peruse page number 2, paragraph 3, your lordship. The objections were filed by the opposite parties denying the allegations that applicant was adopted or that the will was executed in
Between
his
an
favor.
adopted son and second wife, there is a lot of difference.
Please, your lordship, there the procedure of adoption was challenged by the opposite party, your lordship. Here the question was the second wife, your lordship. But the trial court as well as the high court, they have allowed the application.
Forget about this judgment. On facts, you tell the court what is law.
Lordship,
Fact
she is the
is, like,
beneficiary of the.
Forget about the will, the beneficiary of the will. You say that she is a second wife.
Please, your lordship.
Suit for partition.
Please, your lordship.
And there is a first wife. Legally subsisting marriage is there.
Please, your lordship.
Notice the respondents.
Cell number 14 adjourned. Cell number 15. 15.
No representation in the month of September.
Please, ma'am.
Which one?
15.
Yes.
Writ petition, my lord, challenging the order of issuance of emergent notice.
Where is that?
My lord, the impugned order is at page 14. My lord, the suit which is being filed, my lord, by the plaintiff is one for relief of partition. My lord, the trial court on the ground that, please, my lord, that the suit is filed for bare injunction.
Please come. The petition is agreed by the order dated 24/5/2026, whereby the court, without passing orders on IA, IA number 2.
Please, my lord.
IA number 2 seeking injunction has issued emergent notice. It is submitted that the court ought to have passed orders on the said IA. The Land Council has relied on the judgment of the coordinate bench of this court, and so considering the same. Extract that in the light of the same, this court is passing the following order: the writ petition is disposed of, directing so and so to consider IA number 2 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notice is yes.
Cell number 16.
My only submission, my lord, was filed in the petition. Now new number has been given and new court has been allotted. I'll furnish the case number and the court, my lord.
Give it to take it.
Please.
Cell number 16.
Land Council for the petitioner submits that now the matter is allotted to the court and new number is given. That I'll record, give it to the.
16. Puttur Padmavati.
I'm appearing for the petitioner, my lord. Connected matters are already, stay is granted this one. MWP number
That
1.
amount you write it on a paper and give
Yes,
it to them. Yes. What is the amount you paid?
Yes.
What is the amount that is granted?
Yes.
That in connected matters, that order is there, you take it from. Yes, next.
Good.
Cell number 17. Ravi Shankar CR.
I have a petitioner, Lordship. This is the suit filed by the plaintiff for ejectment, Your Lordship. In the meanwhile, I have filed the application for directed to deposit the damages to the of the rent due for 4,93,000. And D1 is the taken by the homes agreement. It is expired on 23, and he has filed the he has sent the one letter to extend up to March of 24. We extended. After that, he has kept quiet.
Come to the impugned order.
Lordship,
Come to
impugned
the
order.
impugned order.
Kindly, Your Lordship. That is page number 36, Your Lordship. And also, defendant is not filed the this one contested for the objection also. The plaintiff filed an IA for 4 under section 151 CPC to pay to praise the direct defendant to pay 4,93,500 the wrongfully occupant of the scheduled premises. So and so, Lordship. In the accompanying affidavit, the plaintiff submits that the plaintiff filed a suit for ejectment, recovery of the rent, and also damages.
What is the order we can pass? No
Order because he has dismissed his IA, Your Lordship.
Notice the response.
Notice and stay for the because he has going down with the evidence and other things, Your Lordship. That will because.
Why you want stay of your own suit?
Correct, Your Lordship.
Then there is something wrong in that. Notice to the respondents, petitions.
The respondent and first respondent can be dispensed because
memo is for secret dispensation of notice.
He has not come for participant.
Number 1.
And date may be fixed for Lordship
Just wait, that's what I'll do. If you hear, you'll understand. For the first respondent, notice is dispensed with, memo is taken on record. Petition is permitted to take out hand summons on the counsel appearing for the respondent.
Yes, Your
Shall
Lordship.
file a memo to that effect if the memo is filed. This is marked on 1st September. Yes.
Then number 18. Shant Kumar SP.
The petition in this matter, please. The last occasion, Your Lordship has directed to produce the judgment passed by the trial court that I am producing for Lordship.
What is this matter about?
It's challenging the order passed by the appellate court under order 1 rule 10, the impleading of amendment of prior.
You are the applicant.
Please, I am the applicant. Yes.
What is the suit for?
Suit for declaration, please, Your Lordship.
What is
Declaration
your,
of the ancestral property. Actually, there was a partition in the year of 1982 between the father and two children.
the suit of the plaintiff is dismissed.
Please.
He sought for
Subsequently gone-
declaration.
Yes, please. I gone to the appeal, which is pending before the district court, third additional district court, Anekal.
Who are you?
I'm for the plaintiff and the appellant as well.
And who is this implead applicant?
It's not impleading, please, Lordship. I seek apology. It's for amendment of the prayer, the inclusion of the prayer.
What was the earlier prayer? It's only
Earlier prayer
declaration.
was declaration and to put me in a position as for the partition deed of 1982. Subsequently, my father has executed 2 wills. One is in 1989 and 1991. Subsequently, please, Lordship, what was happened? Instead of seeking a partition before the trial court, my client has instituted a declaration suit seeking put me in a position as per the partition deed. Same was considered and taken on record by the trial court in the time of considering the my prior as for the plaintiff. Plaintiff also produced before the Lordship. In subsequently, please, Lordship, when I challenge the same order, final judgment passed by the trial court, I come to the court and as for I am the NOC counsel on the record in appellate state. By going to the records and everything which discloses ancestral property, there was a suggestion made by the defendants with respect to my prior and the basic structure of the suit, please, Lordship. As for the same Lordship, that filed an amendment seeking a inclusion of the portion which is, since it's a ancestral property, I have sought only inclusion of the prior to declare I am the entitled of one half of the share of the suitable property.
Come to the impugn order.
Impugn order, may kindly please. Page number 58 to 60, please. The same set of facts and same averment, this honorable court itself has passed a clear order on the said applications, please, Lordship. In the judgment, writ petition 108512 of 2025.
Let us
GMC,
read this order
please,
first.
Lordship. In the order, honorable session court has only considered and passed an impugn order on the basis of that my application cannot be considered on the appellate stage, since I could not file the same application at the time of a trial before the trial court. And the only simple ground the session court has, district court has dismissed my application. And my humble further submission is, please, Lordship, the nature, it is an ancestral property admitted by the both parties. The scheduled property has been purchased by the father of.
Let me read this order.
Please.
What is the judgment?
Judgment. It speaks about the amendment and what stage and when and what grounds it has to be allowed. It's the same case, Lordship. Declaration sought for a partition, inclusion of the same prior. A district court has dismissed on the basis of High Court.
I've seen this judgment, I've seen.
Please, my request, Lordship, my kindly turn to page 14, paragraph 25, please. Before that, please, Lordship, request, Lordship, kindly paragraph 22. Since it speaks about the amendment of Order 6, Rule 17 in the year of 2002. Since the original text of the Order 6, Rule 17, the court retained.
When was the suit filed?
Suit filed in 2006 and judgment passed in 2020, please.
After 14 years, now you want to amend the relief of, from declaration to partition.
No, it's an ancestral property admitted by the both. Because actually, in 1982, please, Lord, it's unregistered. Since it's only unregistered deed, the court did not consider my relief. If the court comes to a conclusion of declaring that one, that I'm entitled indirectly or directly entitled for
What
half
is
of the
that,
share.
what is that you're relying on this judgment?
Relying, please, the amendment which clearly speaks and distinguish how it has to be considered. The next, in the Salem Bar Association, Lordship has kindly, page number 14, paragraph 25. The court has considered the view that in the following instances, illustratively and not explicitly, the application seeking for amendment of pleadings can be allowed with the due diligence test, even in such applications are not filed the post commencement of trial. Applications are, the next page may kindly be please, page number 15, subclass G, please, Lordship, where I am putting the particular, seeking a relief in alternative, which is the nature of the lesser relief on the one day already claimed. Example, which I have already claimed before the trial court as well. Example, they have given in a suit of declaration of exclusive title and injunction, application seeking alternative relief of partition.
Take out hand summons. We shall file a memo to that effect if the memo is filed. Does this matter on 2nd of September?
In interim order may kindly be granted.
I'm not convinced.
Court will pass a judgment in respect to the, without considering the application filed by me. Even the judgment is very clear on the particular part. It's ancestral property. If I am not considered, my
That judgment can't be applied to your case. If you want, I can pass a final order now itself.
please, the same facts also be kindly permit me 1 minute to explain.
I've seen that. That judgment, I'm not accepting. That's contrary to the judgment of the Supreme Court. Yes.
Sir, number 19, Rajesh Rajput, petitioner.
With the court permission, one submission, kindly. Despite of the judgment also, please, Lordship. It's a core objective of the suit filed by me before the
So
trial
the
court.
plaintiff will be sleeping for 20 years. And then the matter, even in the appeal is posted for judgment, at that time you will file an application for amendment and the court should consider it.
My humble submission.
That is not
Even if the court, resume please for a moment, I kindly assume. If the trial court come to a conclusion, yes, I'm entitled for a share, declaring the will is not binding on me, my kindly power. In such case also, on the base of the ancestral property, which my father has bought.
What were you doing for the 16 long years?
The illiterate people, those
Who
not
illiterate?
properly
He is
guided.
led by an advocate and advocate argued the matter.
Agreed,
No,
please.
whenever
Agreed, please.
a question comes, don't say about the illiteracy of the client.
Please. Even if the court come to a conclusion of declaration, declaring
I'm
me
not
as a
convinced,
owner,
Mr. Counsel. I'm telling you, I'm
then
not
I'll be
convinced
put
on
in
the
the
point.
portion.
I can, if you want, I can pass a final order. I'll dismiss the writ petition. That's why I said notice. If you want me to pass, I can pass. Notice to the respondents. Yes.
Sir, number 19, Rajesh Rajput,
And for the petitioner, Your Honor,
petitioner.
I am for the petitioner.
Sir,
Yes.
The trial court in order in page number 14, Your Honor. I filed an IA number 3 under section 151, Your Honor,
Seeking what relief?
to deposit the compensation amount from the KIDB before the trial court as the case is pending before the trial court, Your Honor. Even defendant number 4 has been made as a party, KIDB has been made as a party, Your Honor. Even after taking the summons, Your Honor, in page number 13, Your Honor, the service of summons to the defendant number 4 is called out absent. And later it has been awaited and appearance of the defendant number 4 by 19-2, Your Honor, of 26, Your Honor, 19-26. Later on.
When was the amount released in favor of defendant number 2 and 3?
In the month of March. And kindly, Your Honor, the in-page annexure have produced the order copy of the defendant number 4, Your Honor.
Suit is filed in the year 2025. What is the suit for?
Partition, Your Honor. And I have made representation before the KIDB in the month of August of 25.
What is the case of the defendant? What is the case of the defendant?
Defendant, they have filed an objection stating that the partition has been heard already, and the particular property has been sold to the defendant number 1 daughter and son-in-law. That is defendant number 2 and 3, Your Honor. Have made them also the party. At inspect 65, Your Honor, annexure F, the KIDB has passed the order without mentioning the date, Your Honor, when the order has been passed. and amount has been sanctioned in the month of March 2026, Your Honor, while the suit is pending.
When was the sale? Sale, when was the sale?
Sale is in 21, Your Honor. 2021, Your Honor. Meantime, the KIADB has acquired the property.
Who has sold the property to the defendant?
Defendant number one, the elder brother, has sold the property to daughter and son-in-law, Your Honor.
According to them, the partition had taken place or not?
Earlier, the partition has taken place. With regard to this property, Your Honor, they told that they have.
That's your case. What is the case of the defendant number one?
Defendant number one has filed that the partition has already took place, and there is no, with regard to this property, there is no share. I have challenged that unequal share with regard to this property, Your Honor. The total property 6 has been allotted to defendant number one, and with regard to defendant plaintiff petitioner, Your Honor, 4 properties have been allotted. In page number 49 of the written statement of Your Honor.
Reasoning is correct. Plaintiff counsel filed copy of the order. Release order is passed. Entire property is not acquired. It is less than 10 guntas. Even if the plaintiff succeeds, then more than half share property is available.
Yes, Your Honor. Now, Your Honor, subsequently, Your Honor, another notification has been made by the defendant number 4 with regard to the same
That
property.
you can question.
That same property, in which I have not made as a party, Your Honor. Well, the suit is
No.
pending.
That is a different cause of action. As far as this is concerned, you want them to deposit the amount.
Yes, Your Honor.
You want partition. How many are the parties to the
Only two elder
parties.
brothers and younger
Now,
brother.
out of the total extent, only 10 guntas is acquired, and remaining entire extent is there. If you succeed, you will get that.
No, until Your Honor, meantime, they have for same property, another notification has been made. Another
that is not part of this order.
Yes, Your Honor. That is true. That is true, Your Honor.
Yes.
And Your Honor, my humble submission is when the civil suit is pending, when the respondent has been made as a party,
That you have to question independently against the KDVIB or whatever it is.
No,
But you can't question in this CR.
no, for that reason, Your Honor, I have made a suit before the trial court where the any dispute has to be referred to the civil court, Your Honor, and the compensation amount has to be deposited in the civil court. Even though knowing well they have not deposited that amount.
Is this IA pertaining to the money already taken or the money to be taken, to be given to the? It is about already the money that is taken.
When the suit is pending only, Your Honor. When the suit is pending only.
Agreed with the order dated 4/4/2026.
At least, Your Honor, half of the amount may they deposit, Your Honor,
No.
until the disposal of the case.
No,
If
no.
if I succeed, Your Honor, in the trial
If you
court,
succeed, you have the other share, you give it to the KDB, but that also, you will get the money. Agreed with the order dated 4/4/2026 by the third additional ASCJ.
at least the defendant number 4 may undertake that if they succeed, so that I can.
Not required. The order of the court is very reasonable. We will not call anybody to the court. It is not necessary. Agreed with the order dated 4/4/2026 by the third ACJ, Bangalore. The petitioner, plaintiff is before this court. That is Principal Senior Civil Judge, Bangalore Rural. The plaintiff is before this court. Plaintiff has filed the suit for partition. Now the present IA came to be filed, stating that that there may be a direction to the defendants.
I think page number
2 and
16,
3.
Your Honor. Next step, G. Not to disperse the compensation amount. Not to disperse the compensation amount to the defendant number 2 and 3.
It's already dispersed.
Well, the suit is pending, Your Honor. Behind the back, Your Honor. If it is not.
Not a writ petition we are dealing with. We are only concerned with what is the order
One
implemented.
submission. If I have not made the party to the respondent number 4, Your Honor, I have not made a representation.
You are not seeking any direction to them. You are seeking a direction to the defendants in the suit to deposit the amount before the court,
Yes, Your Honor.
which they have already received. Court gives a finding that it is only 10 guntas. Remaining extent is available, which you will have it once there is a security if the suit is decreed.
No, Your Honor, what happens, Your Honor?
I heard it. I understood. No further arguments are required. Order dated 4/4/2026. whereby the application filed by the petitioner, that is I number 3, is dismissed by the court by order impugned. The court observed that the court, while dismissing the application, the court observed that the plaintiff has placed a release order before the court where the, the, the amount is disbursed to the second and the third respondent. It is the case of the defendant that if the entire property is not, 10 guntas of land is acquired, even if the plaintiff succeeds, then more than half share property is available against the defendant number 1. Defendant number 2 and 3 are the purchasers. They can't be asked to deposit entire amount. And it is the case of the defendant that already there is a partition and the suit is not maintainable. And the entire partition deed dated 3/10/1987 is not challenged. And it is the case of the defendant that the plaintiff's son has already filed another suit 1138 of 2021, which is dismissed and the plaintiff has suppressed the said fact. The court has passed impugned order observing that the plaintiff has challenged the partition deed dated 3/10/1987. The defendant number 2 and 3 are the purchasers of the portion of the suit scheduled property. Therefore, it is not fit case to allow I number 3 at this juncture. However, the defendant number 2 to 4 are governed by the final result of the suit. With these observations, I number 3 is rejected. The learned counsel appearing for the petition submits that when the suit is pending, the respondents ought not to have released the amount in favor of the defendants. Now the fact remains is the amount is all the plaintiff himself has placed before the court. The release order, whereby the amounts are released in favor of defendant number 2 and 3. It is not the case of the petitioner that except this land, there is no other land for partition. Admittedly, only an extent of 10 guntas of land is acquired. And petition is entitled for only, according to him, he is entitled for half of the share in the suit scheduled property. In that case, at this juncture, it is not necessary to pass such an order, and the trial court has rightly dismissed.
Direction that you are on, at least for earlier disposal of this matter.
25 suit earlier disposal. And this court finds no reasons to interfere. Dismissed. Yes.
Cell number 20. Sadita AL.
Appealing for the petition. This matter, my lord, mandamus to direction the speedy disposal, Your Honor. Speedy disposal
Of
because
what?
it of the suit.
Suit is of which year?
This is the 20, my lord. Initially, it was filed in 2011. This is suit per partition and one fifth share, my lord.
Now it is pending on which court?
2011 in Senior Civil Judge Dodbalapura. Initially were filed in the year 2011, Your Lordship. Thereafter,
The writ petition is filed seeking the following prayer. Learned counsel for the petitioner submits that initially the suit is filed in the year 2011. Now it is renumbered as OS number 52 of 2020. The suit is pending before the court from the last more than 15 years. It is submitted that considering the fact that this is a suit for partition and the petitioner is aged about plaintiff is aged about 71 years, there may be a direction to the trial court to dispose of the matter expeditiously. So, in the light of the law laid down by the Honorable Apex Court, in the light of the judgment passed by the Honorable Apex Court, whenever a mandamus is sought, it cannot be issued in a routine manner. However, if the case warrants is of an exceptional case, in those cases, a mandamus can be issued. In this case, the suit is of the year 2011 and the plaintiff is aged about 71 years. In that view of the matter, this court has passed the following order. So and so is requested to dispose of the matter, that is OS number so and so, within a period of 1 year from the date of receipt of the copy of the order. Yes.
Cell number 21.
Macham.
Ganesh Kumar R.
Beg to appeal for the petition, Lord. Plaintiff's writ petition, serial number 22, also arises from the same impugned order.
Yes.
Lord, Order 6, Rule 17 reasons comes from there, my lord.
Para 16.
Para 16, my lord, precisely. On perusal of the entire order sheet, it appears that the matter was posted for plaintiff's evidence on 11/2/2022. As the plaintiff did not adduce evidence, the suit was dismissed. Subsequently, it was restored. Lord, before that, just one aspect of the matter.
Come to, there is a discussion at 17A.
Please,
Item
Lord,
number
17A,
11
please.
is site number 12555A.
Please.
The plaintiff, that is
336.
allotted to the person, not to the
Please.
family.
Please. The
Arise at all.
Learned trial judge gives the prejudges the issue, my lord.
No, it is like on the face of it, after that you have come. When you
Lord,
say that this is a joint family property.
I understand, Lord. My case is that the source of funds is from joint nucleus. That is my case.
What were you doing?
My lord, I didn't know about this sale deed at all. Unless different number 5 brought it on record. When different number 5 filed the return statement, I came to know there is subsequent alienations.
They must have taken it in their written statement.
Only from their written statement, it came to my knowledge that there are alienations.
No, they must have stated so in their written statement. I'm saying not at the time of evidence.
Right? Much before the evidence, I have filed this application. At page number 51.
Page number?
The trial order sheet 51.
Hmm.
I file on that day notice is issued, but even before notice is returned, learned trial judge dismisses my application.
50?
So prima 51, my lord. Page number 51. Learned counsel for the
You filed it on
plaintiff.
3110.
It is filed on 3110, my lord.
25.
31. Notice is issued, but the trial judge.
Oh, I understand. Your suit is of the year 21.
21.
What is the stage at that point of time?
My lord, issues were just framed, my lord. It's still for issues, trial court issues. Evidence had not commenced in because I'm the plaintiff.
So, learn counsel for the petitioner plaintiff submits that. 2 applications were filed, one under order 1 rule 10 to bring the purchases on record, and also an order 7 rule 11 to amend the pleadings. And by amending the pleadings, you have also questioned the sale deed that is executed in favor of the purchasers. The court has dismissed the application. It is submitted that the court at the time of order 6 rule 11, rule 7, order 6 rule 17 itself has prejudged the merits of the matter, which is not permissible. Considering the same, there shall be stay of all further proceedings pursuant to the order dated so and so on the file of so and so. Hand summons and the memo shall be filed by 4th of August, or else a stay granted by this court stands vacated.
Deeply obliged, Lord.
So number 22.
Both the tag,
Lord,
there's a tag on
tagged
22 and 21 and 22.
Deeply obliged.
This 23.
Number 23.
Please, my lord. My lord,
Siddharth Suman.
challenging attachment of, my lord, 3.5 acres in survey number 33/1. Now, this arises out of execution proceedings. I am the judgment debtor, my lord, before the Honorable Trial Court. I was not represented there, my lord, because I was placed ex parte. This arises out of an order, my lord, which was passed by the Consumer Forum. Consumer Forum says that, see, you have collected, my lord, I'm a society. So this is, I've been allotted land by virtue of an acquisition which has taken place. Then land is given to me. Subsequent to that, my lord, there were certain members who have then applied for sites. I could not deliver the sites, which is why, my lord, there was an order passed saying that you have to refund the amount. Now, this, my lord, execution proceedings are all filed before the Consumer Forum. Here, my lord, one person comes before Mayor Hall and files an execution proceedings. In fact, my lord, there's an office note also saying that how is it maintainable before Mayor Hall? Because everything else is before the Consumer Forum and, my lord, execution proceedings. I have already deposited 1 crore 48 lakhs to be precise. It's all there, my lord. So as far as the money is concerned, it's already been put there.
Come to the implement.
Please, my lords may kindly come to page, if my lords were to kindly come to page 34, what they propose to do, my lord, they wanted to attach this property. In fact, the learned trial judge says, see, for the amount is small, it's 5 lakhs. My lords were to kindly see. However, the decretal amount is only 5 lakhs. So without taking other steps to recover the amount, straight away, DHR cannot go for attachment of immovable property more than worth crores. Moreover, recent letter from the sub-registrar, the property is free from encumbrance and the total measurement and description of the property to be sold to satisfy the decree as required under order.
You're on what ground?
I'm sorry, my lord.
You're on what ground before this court?
No, my lord, to say that you cannot attach this property when the money is already available. I'll just pass this on, my lord. My lords were to kindly see. May I just pass this. This is an order which was passed. before the consumer forum. Everything, Manoj, there are about 200 cases there, where 1.4 crores, Manoj, is already deposited there. She and what the
Where is this opposite party, this decree holder, where is he?
decree holder is represented by a GPA holder. GPA holder,
You have given a copy.
Please.
In that, in opposite party numbers are there.
no, it not in that, Manoj, but my lords may kindly see what is recorded in that. The amount which I have deposited in court for everyone to recover is there, is recorded in that. If my lords would
But I
kindly see.
understand, where is it, where this person's name is reflected?
My lord, this is not for that one particular person only. It is for the entire. So there are about
I
200 odd.
understand, he
Please.
should also be a beneficiary out of this order.
Which is why, Manoj, just want to make one submission. The GPO holder, who is the GPO holder, Manoj, she herself has filed an execution before the consumer forum for her side. She knows about it. So the GPO holder here, Manoj, in this particular case, she goes and files, Manoj, a case for her side before the consumer forum. Everybody knows about it because all the cases are there in the consumer forum. Here before Mayor Hall, in a different capacity, she files this, Manoj. Her petition itself is here. If my lords were to kindly see this, S.T. Padmini is the GPA holder. And the entire amount, my lord. S.D. Padmini is one of the GPA holder. She has already gone there, recovered the money and walked. That is a
Either
closure.
here or there, you pay the same amount.
It's already deposited there, my lord. There is 1.48 crores. My lords were to kindly see.
Where did you say so before
My
the
lords may
court?
kindly see. I was not represented before the trial court. I was placed ex parte. I only get to know about this, my lord, when they come to the property. It's 3.5 acres. Property worth about 40 crores. To attach, I wouldn't say 5 lakhs is insignificant sum, but to attach for 5 lakhs recovery, the amount is already ready. It is there before the consumer forum. My lords were to kindly see.
This order is passed on 7/3/2025.
I'm sorry, Manoj.
This order is passed on 14/2/2025.
Not 25, Manoj. Which the one which I gave, Manoj?
No. This attachment order.
Please, no, Manoj. This is on 25 too.
Where is the date?
My lords may kindly see. If my lords were to kindly come to page 38.
30?
38. Sorry, 37. That is the order which is passed, Manoj, by the Honorable Trial Court. Subsequent to that,
Decree holder present and place time.
please, my lords may kindly see 25-2 is written. Counsel for THR filed a memo on guidance value and calculation. It was issue attachment. That's it.
When was the order of the consumer forum?
Consumer forum is in 2023 itself, Manoj. Different times because I've been depositing this, Manoj. 23, Manoj. In 2023, full amount is deposited there. They only have to go and make a requisition and then take it. That's it. Entire amount is there. 1 crore 48 lakhs, not for all these people, because this was before different consumer forums. So all of this was transferred to one particular commission itself, and then this amount was deposited there for them to take it.
Then counsel for the petitioner submits that. The petitioner, the respondent herein sought execution of an order passed by the consumer forum. There are several opposite parties, and the entire amount of 1 crore, 1.5 crore is deposited before the consumer forum. The respondent decree holder is represented by the GPA, and in fact GPA has got an amount, has filed the execution before has record the amount from before the consumer forum. And only this is the only petitioner who has come before the executing court. According to the petitioner, even the amount which is the amount of 5 lakhs is lying before the executing before the state before the consumer commission, and he can withdraw the same from the said commission. It is submitted that for an amount of rupees 5 lakhs, the court has issued an attachment warrant for an amount for an extent of 3.5 acres. Considering the same, there shall be stay of all further proceedings in so and so same hand summons. Memo shall be filed by 5th, or else the stay granted with court stands vacated.
Grateful.
24. Vaishnavi
My lords, the petitioners filed a suit for partition before the court below, my lords. The petitioners have subsequently filed an application for amendment of the plain because they found out
the suit.
My lords,
When is the suit?
it was filed in the year 2014, my lords.
2014. What is the present stage?
It's at the stage of evidence, my lords. It's not commenced, my lords.
You are the defendant.
Plaintiff, my lords.
Wait, come to the order.
Page 15, my lords.
Yes.
My lords, the learned trial judge relies on a partition deed and states that since the partition deed was
Let's read
acted
from the
upon.
reasoning part at para 7.
My lords,
Let's read from para 7,
please, my lords.
page number 15.
This is a suit filed by the plaintiffs against the defendant seeking partition and separate possession of the suit scheduled properties. The suit scheduled properties consists of two items. Admittedly, one, Narayanappa had two sons by name Muni Rajappa and Jairamaya. The said Jairamaya is the defendant number 1 herein. The defendant number 1 is the wife of Muni Rajappa. In para number 6 of the plaintiffs have clearly stated that during the lifetime of the grandfather of plaintiff numbers 2 and 3 by name Narayanappa, there was a panchayat parikat between the husband of the plaintiff number 1 and defendant number 1. As such, except the suit scheduled properties, all other properties were partitioned. But however, my lord, subsequently they found out.
Will read.
It is also stated that the copy of Panchayat Parikat and RTP number 31 of 1989-90 are produced herein. The defendants have also taken contention in the written statement that there was a partition dated 24/4/1989 between the children of Narayanappa. It shows that both parties admitted about the partition between the children of late Narayanappa. The plaintiff has included only two suit scheduled properties and clearly stated that all other properties have been already partitioned. The learned counsel for defendants has produced copy of the alleged Panchayat Palupati. My lords, this is produced by the defendants, my lords, not by the plaintiffs.
Complete
Wherein the
reading
proposed suit schedule properties are also included. Moreover, the plaintiffs have not produced even a single piece of paper to show that the properties proposed to be included in the schedule are the joint family properties of the plaintiffs and the defendants. Moreover, the counsel for plaintiffs remained absent and also failed to address his arguments, which shows that the plaintiffs are not diligent in prosecuting the present case and the present application. Plaintiffs have not stated that what had prevented them from including the suit schedule properties at the time of filing the suit. They have merely stated that through
Then
close
counsel
friends
for
and
the
relatives, they
petitioner.
came to know about the proposed properties and also
Then
traced
counsel for the petitioner
the
submits that.
RTCs pertaining to the same.
The-
My lords, it's a matter of trial, my lords.
When counsel for the petitioner submits that. The court has, when an application is filed seeking amendment of the pleadings whereby certain properties were included, basing on the Panchayat Parikat filed by the defendant, the court has prejudged the issue and came to the conclusion that that it is already partitioned. It is submitted that when considering an application under Order 6/17, such exercise is not permissible. Considering the same, there shall be stay of all further proceedings.
My lords, it's a matter of trial, my lords, as to. Please, my lords.
Pursuant to the order dated so and so and summons. Memo shall be filed by 5th of August.
Deeply obliged.
SK Mithun.
For the petitioner. My lord, the first respondent had filed suit for partition, my lord. Before filing the partition suit, which is pending in Bangalore, my lord, he had filed other suit in 2010 before the Madanpalli court, my lord, including the properties which are situated in Andhra Pradesh. Subsequently, in 2023, he files one more suit saying that the properties which are laid in Bangalore, which is left out, and he has filed one more suit in 2023, my lord. So I filed written statement and that suit, my lord, has been decreed. As against that, the petitioner has preferred appeal and appeal is pending for adjudication before the Honorable High Court of Andhra Pradesh. In this suit filed subsequently in 2023, I filed a written statement. I took a defense saying that it is section 10 of sub judice it applies because the party is herein and everybody are the same, my lord. So I filed section 10 application before the trial court. The trial court rejected the application, my lord. The impugned order is found at page number.
No, what is that you want in the section 10 application?
Well, this suit should be stayed because appeal is pending, my lord. In the Honorable High Court of Andhra Pradesh, that appeal is pending, my lord. So this suit has to be stayed because the parties have the same subject matter is the same, everybody is the same, my lord. So the impugned order is, my lord, found at page number 14, my lord. The reasoning starts at
Suit of the year 2023.
2023. That suit is filed in 2010, my lord. That suit, after a trial has been done, the suit has been decreed. As against that, I have preferred an appeal before the Andhra Pradesh High Court, my lord. That so the appeal is still pending for consideration, my lord. During the pendency of the appeal, they filed this suit, my lord. This suit is only with respect to two properties situated in Bangalore. So I filed application under section 10. This has to be stayed because appeal is a continuation of the suit. So I filed section 10 application, my lord.
Come to the argue. Read.
My lord, page number 17. The reasoning starts, my lord.
You can come to 18. The issue involved in the present suit.
My lord, I'm sorry.
The issue involved at page number 18.
19 and 18, my lord. The issues involved in the present suit are OS 12 and 2000 are one and the same. Therefore, as the present suit is subsequent to OS number 12 of 2010, the proceedings may be stayed till disposal of the appeal. It is pertinent to note that the suit in OS 12 of 2020 was filed by the plaintiff herein with respect to family road situated at Pungnur, Ramasamudram, Chittoor district. The properties situated at Bangalore were not included in OS 12 of 2010. In the written statement, the defendant number 1 himself has admitted the item number 1 and 2 of the suit properties are not subject matter of OS of the suit in OS 12 of 2010. It shows that due to oversight, the properties situated in Bangalore were not included in OS 12 of 2010. Thus, subject matter in OS 12 of 2010 and the present suit are entirely different. However, it is a fact that all the properties should be included in a suit for partition, but item number 1 and 2 of the suit schedule properties have not been included in OS number 12 of 2010. Therefore, the defendant number 1 has raised a defense that the present suit is hit by order 2 rule 2 of CPC. In that regard, the additional issue may be framed and the same has to be adjudicated after the conclusion of trial. One second.
For the petitioner submits file an application in section 10 of the CPC to stay the further proceedings till the appeal is decided. It is submitted that in respect of the between the same parties in respect to the property situated in Andhra Pradesh, they have filed a suit and that came to be declared and against certain appeal is filed. And hence he has filed the present application which is not considered by the court. Considering the submission, there shall be stay of all further proceedings. Same hand summons on the counsel. In all the matters, it is hand summons on the counsel. Earlier matters, all the matters. Hand summons on the counsel appearing before the trial court. He shall file a memo to that effect by forth. If the memo is not filed, stay granted by this court. Stands vacated. It should be stay of all further proceedings with OS number. Yes.
26, Hiramad CS.
Appeal for petition, my lord. The petitioner has filed this presented petition seeking mandamus to dispose of the matter expeditiously. The suit pertaining to 2009, decree passed 16. FDP proceeding pending for the since 17. All the so many people have died and LRs have come record. So many people.
What is the presence? At what stage it is FDP?
Pardon?
FDP. What is happening in the FDP now?
Just notice so some persons are dying and LR.
But what the court can do? There are 45 respondents.
Some reasonable time. Reasonable time.
What is the reasonable time? I don't know what is the reasonable time.
For the past 9 years, it is pending.
That I can understand. Now, any time frame that is fixed by the court should be reasonable.
Please.
We can't make the court to do something, in whatever time this court fixes.
At least.
The mandamus is filed, seeking, the writ petition is filed seeking mandamus to dispose of the pending FDP proceedings. It is submitted that the suit is of the year 2009. The registrar protocol shall, the registrar judicial shall call for a report from the concerned judge. How much time is required to dispose of this execution petition? Does this matter on Friday, 31st? Yes.
Cell number 27, Shiva Reddy. Cell number 27, Shiva Reddy came.
This case, my lord. The plaintiff is before this lordship, my challenging the order passed by the
Yes.
allowing the counterclaim of the defendants, my lord. The reason is there is inordinate delay and the title disputing regarding the my property and the property of the defendant
This counterclaim is allowed?
Allowed, my lord.
Against that you are here.
My lord.
Questioning that order, you are here.
My lord, my lordship may kindly peruse the order passed by the court below in page number 81, ink page number.
Yes.
Merit. Plaintiff absent, counsel present. Defendant number 1 present, counsel for the defendant number 1 to 4 present, counsel for defendant filed an application under section 151 of CPC along with counterclaim in 2 sets and list with documents. Heard and perused the application is allowed. Counterclaim of defendant number is taken on record. For return statement to the counterclaim of defendant number 1 to 4 and reissue notice to IA number so and so, my lord. This is the only reason given by the court below. My lordship, after lapse of 9 years, the evidence has been already started. Issues already have been framed, my lord.
For the petitioner submits that. The court by order
Before
dated
that, my lord, there was
29/6/2026.
another suit. It is clearly mentioned that my property and this property is totally different.
29/6/2026 has allowed the counterclaim and the reason, and it has no reasons or content why a counterclaim is allowed after 9 years. It is submitted that the court only records that the plaintiff is absent, counsel present, defendant number 1 present, counsel for defendant number 1 and 4 are absent, and application is allowed. It is submitted that the order is bereft of reasons considering the same. There shall be stay of all further proceedings in so and so, so and so.
For stay of the proceedings.
Yes, sir.
Notice
Cell
to the
number-
respondents, hand summons, memo.
I take
court-
notice to the council on record before the trial court, my lord.
That also on record.
Yes.
Please, my lord.
Cell number 28, Praveen S.
For the petitioner, my lordship. My petitioner, my lordship, had filed a suit for bare injunction before the court below against the respondents here in my lordship. And also an IA under 39(1) and 2 was filed seeking for injunction against disposition of the property, my lordship.
Yes.
The facts of the case, my lordship,
What happened to that?
the same was not allowed, my lordship, in the sense emergent notice was issued
Where is
and a
that order?
non-speaking order was passed.
Where is that order?
That is in ink page 13, my lordship. That is the operative portion of the order, ink page 13, my lordship.
In page 30?
1-3, my lordship, ink page 13.
Please come. Let counsel, the petitioner is before this court, petitioner plaintiff is before this court, agreed with the order dated, this is dated?
This is dated 24/8, my lordship. No, my lordship. Just wait. This is dated 2/7, my lordship.
2/7/2026 by the third ACJ and JMFC Anekal, whereby the court has issued suit summons on I number 1, which is filed seeking ad interim injunction. Then counsel for the petitioner submits that an application is filed seeking ad interim injunction. Court has to pass orders on the merits of it and cannot issue suit summons. He relied on a judgment of the coordinate bench of this court in so and so. Extract the judgment. You can ask them, they'll give. In so and so. Relying on this judgment, he submitted that the court ought not to have issued the suit summons ex pere, considering the argument of the land counsel of the petitioner and the judgment of the coordinate bench for supra. This court is passing the following order. The writ petition is disposed of, directing the trial court to consider IN number 1 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the summons were not served on the defendants.
Obliged, my lordship.
Cell number 29,
I appear for the
Yes.
petitioners. The rejecting my application for impleadment in the trial court. That on the ground that application has not served to the other party. Then that application was filed before the trial court. Same day that at the instant itself, the application has not served, therefore dismissing the application. And the suit for partition.
Sir, notice on. Notice to the respondents.
Respondents were that 1-2. That 1-6, others may kindly be dispensed. The plaintiff wants-
Hand summons on the council appearing for the respondents 1-6.
1-6.
1-2?
1-6.
Who are the other respondents?
Others are the other dependents. Others are the dependents.
What is the number in this?
The dependents 7-2.
Number, sir.
Respondent 7-2. 18. 19.
A memo is filed seeking dispensation of notice to mute him.
yes, sir.
7-19. Memo is taken on record and respondent to notice to so and so is dispensed with. Yes.
Cell number 30,
For the petitioner hearing, my lord.
It's a suit for a specific performance, my lord, and I'm challenging the order dated 8/6/2026, whereby the learned trial judge has allowed the application for amendment of the written statement, my lord, wherein they want to add the para
Come
6A,
to the
the
order.
application,
Come to
please,
the
my lord.
order.
Page number 48, my lord, please. Page number 48, the reasoning starts at page number 50, my lord. It may be noted that the plaintiff's evidence is already being conducted and the application has been filed after that, my lord. Whereas initially when the suit summons were issued, the written statement also was not filed. It was taken as nil in the year 2021 and thereafter filed in 2023. And the amendment application came to be filed in the year 2025 after the completion of the plaintiff's evidence.
Sir, other persons to mute their mobile, sir. Disturbance.
So, on what ground you are questioning this order?
My lord, in the notice which I have sent him stating that sale deed has to be done, he has taken a contention, he has agreed to the point that a sale agreement was already done between the defendants and the plaintiffs herein. Whereas here he is alleging that there is forgery and fraud created by the plaintiff, which differ, my lord, which changes the nature of the suit as well.
It is, when counsel the petitioner submits that it is suit for specific performance, the respondent, defendants have already filed the written statement and have accepted the fact that they've executed a document, but it is merely as a security for loan obtained by them from the plaintiff. Now, by virtue of this amendment, they want to take a stand that the same is created in order to knock away their valuable properties. The court, without considering all this, where the defendant is taking inconsistent pleas, still has allowed the application. Considering the submissions, they shall be state notice to the respondent.
Grateful.
Serial number 31.
Same in all that fourth, or if not, the stay granted.
For the petitioner, Your Honor.
Stands vacated.
31.
Yes.
Your Honor, this is a petition filed. There is an order. I was before this.
Come to the prayer. Remove the NDBT restriction and blacklisting from the Vahana database.
Your Honor, there was a order that was passed, that is NTBT against my vehicle. I am the user of the vehicle. This is
No,
the
what is the interim prayer you're seeking?
Your Honor?
What is the interim prayer you're seeking?
No,
No interim prayer. Let them come up.
Lord, may I make one submission, Lord? Annexure E, my Lord, page 27 for amendment. Earlier, there was a writ petition was filed for the same relief, my Lord, that was disposed, giving liberty to the petitioner to challenge that order. Till today, my Lord, that order is not challenged. Again, my Lord, he has given a representation.
This is not a challenge of the previous order. Your Honor, there
Please
was a
notice
first.
to the respondents, only the government.
Yes, ma'am.
HCGP takes notice on behalf of respondent number
1 to 3, my Lord.
1 to 3. They shall file their objections. This is matter on 22nd of September.
Serial number 32.
A shorter date, Your Honor.
MC Roshan.
They have to file the objections.
MC Roshan.
Yes.
For the petitioner, challenging the order which is at page number 12, Your Lordship. My written statement, I have filed my written statement after the bar of 120 days. That is on 133rd date, I have filed my written statement which has been.
When the suit is filed?
Suit is filed, my lords, 2025, my lords.
Date?
Date of the suit is, my lords, 29th, 17/10/2025. Notice was
Counsel for
issued
the
on.
petitioner submits that the court has failed to take the written statement on record as it is filed beyond 120 days. It is submitted that the written statement is filed on
33rd day.
and on the date of on 133rd day. It is submitted that the coordinate bench of this court has already stayed operation of the amended provision, and the court ought to have allowed the application. Considering the submission, there shall be a stay of all further proceedings. Notice to the respondents, I am summoned, say more.
Cell
Yes.
number 33, 18 B for petitioner.
Yes.
My lord, an application was filed by the defendant for framing a preliminary issue on the point of limitation, and that has been rejected. The preliminary issue sought to be framed is maintainable suit on the ground of limitation because partition deed, registered partition deed to which plaintiffs are a parties are sought to be challenged on the ground.
So you don't want to adduce any evidence?
On that front, we don't want to, because the question, pure question of law. May beg to take my lord's synopsis. The second date is important. 24/2/2003 is a registered partition deed. After that,
Generally, law of limitation is a question of fact and law.
yes, yes.
That's why it can't be decided as a
Yes.
preliminary issue.
When the plaintiffs themselves are signatories to the registered partition deed, then
That the evidence has to be adduced.
that they themselves admit in the plaint. They themselves say, we are signatories to the partition deed, but the partition deed, what is granted, what is allotted to us very inadequate. This is the exact word used. Therefore, the partition deed itself is illegal. Therefore, set aside that partition deed and all consequent.
Let's see the order impugned. Please
Please.
come to the order.
The order impugned, the Honorable Court may kindly peruse page 173. Please. The reasoning is
4.1.
4.1. Settle law whether a question of administration is a mixed question of law and fact, especially in case alleging fraud, misrepresentation, want of knowledge. Such issue cannot be decided without giving the parties an opportunity to lead evidence. This is the point. Now, kindly see the plaint itself without knowledge. If it's without knowledge,
Look at your application. Have you filed an application?
please,
That it should be
for
taken as-
framing the additional
Yes.
issues.
Or to take up
Please.
as the preliminary.
Yeah,
issue.
please, we have.
Where is that?
Page 110.
Let's see. What did you say?
Kindly see page 111, affidavit. Between myself, second sentence, paragraph. Between myself and plaintiffs, a partition deed. Between myself, plaintiffs partition deed was effected on 24/2/2003 in the scheduled property. Said partition deed was registered in the sub-registrar's office as so and so on 24/2. Plaint refers to the registered document as number so and so, etc. After the said partition deed, I have been developing and enjoying the same from the year 2003 till now, and the family members have been enjoying.
Now please come to the plaint.
Plaint, please. Plaint. Type copy of the plaint, please. Annexure M, please.
Page
That's
number.
at page number 153.
That's in Kannada.
I pray my lord to kindly see page 157.
Where did they mention about this partition?
Please, my lord. I may beg to take the kind consideration to para 2 itself. Defendants 1, 2, 3 are the sisters of the plaintiffs. Then I will not read it. Read other things, my lords. Next page. Top 158 top. Executed registered partition deed. Received the shares due to each of them in accordance with that partition deed. Under the partition deed, property so and so came to Shaila, defendant, etc., etc. Then how it came, etc., etc. Now kindly see the prayer. She is a signatory to that deed. Prayer itself made is.
No, they're referring to a partition day. When they refer, they say there is a party. They don't say that there is a partition among ourselves. It is, they say there is a
Please.
partition among them. They say they execute a registered partition deed and this is a share due to each of them.
Please, my lord, the honorable court may kindly excuse me, my lord. There are the translation appears to be the of another partition deed, my lord. There are two partition. There are two suits. two suits. One is, your lords may kindly peruse the first suit, my lord, which is subject matter here. I am extremely sorry. There are two suits, my lords.
Yes, where is that?
Yes, sorry. Reply notice, first suit. Yes. Order sheet. The plaintiff in 35. Please, my lord, that's page number 153. Sorry, 153, my lord, please. That's it. 35, OS 141.
This is what we read at 153, which is a translated copy at 157.
Please, my lords. So it is in the first document itself. Sorry. First document, page number 16. It's in the first. There are two suits. Extremely sorry, my lords. Typed copy, lords may kindly see page 23. The names of the parties also. Vimala, Jyoti, and Satyavati are the plaintiffs. Page 23. This is OS 41. Pardon me. There are one more suit. Defendants are Shaila. Shaila's son is defendant number 2, Ganesh Prasad. Shaila got the property by way of the partition deed, which she executes by way of a gift deed to Ganesh Prasad. Ganesh Prasad executes in favor of his wife subsequently. Now kindly see, my lords, para 2. Last but one, the scheduled property, self-acquired property of plaintiff's father so and so, defendant so and so had equal share. In the middle portion, my lords. For this purpose, the above name said elders decided the plaintiffs and their mother should register a nominal partition deed in the name of the first defendant. Accordingly, on 24/2003, plaintiffs and their mother registered a deed in the name of plaintiffs and so and so, in the name of first defendant as registered in so and so. Therefore, entire responsibility of construction was entrusted to so and so. Plaintiffs paid a total of so and so in cash, and the plaintiff's mother so and so handed over the first defendant, etc., etc., etc. Next, the allegations. Partition deed, signature, everything is admitted. And my lord, then they say this is only a nominal partition deed.
It can't be decided as a preliminary issue.
It's for this purpose.
Para number 4
One
and
sentence
all.
I beg to submit. Kindly see the date when is the suit is filed.
No, that is just one small aspect. But what about the evidence with regard to all that? When the party who is pleading fraud has
Please,
to
my lord,
show.
my submission is a document on Article 59 can be set aside. Any document, even a partition deed, can be sought to be set aside. One thing is, if there is a person who is not a signatory, then when he comes to know about the fraud, my lord, Article 59 limitation starts. It's 3 years.
Fraud vitiates everything.
But my lords, if a document is obtained by fraud, then the limitation is under Article 59 itself provides. Article 59 is the provision, my lord, for setting aside the document. Now, my lord, that's from the date of the knowledge in respect of other cases. My lord, where a person is a signatory, then the date of knowledge is the date when it's executed, when the person has signed, my lords. It has to be calculated. Otherwise, my lord, there is no end to it. Anybody can say, now I come to know, etc. That's not the pleading here. The pleading is I have signed it. It's not a case of where I have signed without knowledge. Then they say the partition is equitable. Now, my lord, the law is, my lord, at that point, when a person is a signatory to a registered document, then, my lord, the date starts from there. Limitation starts from that date. Otherwise, it will be endless, my lords. Endless. Of course, a situation.
Narrated several other circumstances.
Please.
As a preliminary issue, it cannot be decided.
If the Honorable Court is pleased to permit me, my lords, pass on what this Honorable Supreme Court has done, where the person is a party, my lords.
No, there is no dispute on the law. But the thing is, like, there are to substantiate their case, they have to prove the evidence has to be let in.
Evidence, my lords, allowing the evidence only because a registered document signed is there. There cannot be any evidence opposed to section 92.
Not with regard to that the circumstances surrounding that.
The entire pleading is, my lord, this is partition deed has to be set aside because it's inequitable.
No, what they say, elders decided that the plaintiff and their mother should register a nominal partition. That is what is.
But this itself is a legal bar. On section 92, there cannot be any evidence led, my lord, to contradict the.
But this
one sentence I beg to. Please, my lords. One sentence, my lord, how the Honorable Supreme Court has analyzed this, my lord. Of course, this is guiding principle, my lord, under Order 7, Rule 11, where only the plaintiff is there. I beg to submit the same logic would also be applicable, my lords.
Yes.
Para 24 onwards, it starts, my lords.
Yes.
As far as the point when the knowledge is concerned, my lords, para 28. Read para 28, please.
Yes.
Therefore, even considering the averments and allegations in the plaint only, it can be seen that even according to the plaintiff, the cause of action for the suit arose on 19/9/2005, the date on which the plaintiff executed the sale deed in favor of the defendant. In para so and so, will consider the cause of action. It's further averred that the cause of action is arisen on other dates, my lords, etc. Para 30, even the averments and allegations with respect to the knowledge of the plaintiffs averred in paragraph 19 can be said to be too vague. Nothing has been mentioned on which date and how the plaintiffs had the knowledge that the document was obtained by fraud or misrepresentation. It is averred that the alleged fraudulent sale came to the knowledge of the plaintiffs only when the plaintiff visited the property. Nothing has been mentioned when the plaintiff visited the property. It is not understandable how, on visiting the suit property, these pleadings are also not there in the present case. Date of knowledge of fraud is never mentioned. It's entered into partition is entered, it's a nominal partition, etc. Such a plea in respect of registered document with great respect cannot be permitted unless I was forced to do it or compelled to. That's not the pleading at all. And merely saying that it's by fraudulent representation, that itself would come within Article 59, please, my lords. It does not extend the period of limitation at any point of time to a further date. It cannot. Unless they plead, I came to know now. The fraud is discovered now. The date of discovery of the fraud is not there. Similar circumstances, my lord, para 30, 31, and then that the Aravindam is quoted, my lords, 6.5, 6.6, same, all the decisions are quoted. Then, my lord, para 32. Applying the law laid down by this court, the aforesaid decisions and exercise the aforesaid order 7 to learn to the facts of the present case. On the averments in the plaint, we are of the opinion that both the court below have materially erred in not rejecting the plaint in exercise. The respective suits have been filed after a period of 10 years from the date of execution registered sale deeds. Kindly see, my lord, 10 years. In our case, it's 16 years. 16 years. It is to be noted that a suit was filed so and so, it was filed in the year. So in the, some of the plaints herein were also part said suit and said suit. There was a specific reference to sale deed. So and so said say came to be dismissed in the year, etc. Averment the plaintiff that bundle of facts. So we are of the opinion by a clever drafting, the plaintiffs have tried to bring the suits within a period of limitation, which otherwise are barred by limitation. Therefore, considering the decision so and so and so, and the respective suits are barred by law of limitation.
Yes.
My submission is this, my lords. I am not pressing for interim order for this reason, my lords, that the plaintiffs I am informed, my lord, that themselves seeking time, getting the matter adjourned. Why we are approaching this honorable court is they kept the matter alive without leading any evidence. Now it's posted to 7th of August, I am informed, my lords. If the honorable court is pleased to permit me, my lords, your lord may kindly permit me to take notes on the learned advocate, so that if the honorable court is pleased to, my lord, entertain the petition.
Petition is permitted to take court hand summons on the counsel appearing for the respondent before the trial court. If the memo is petitioner is permitted to take out hand summons on the counsel appearing for the respondent, shall file a memo to that effect by 5th of August. If the memo is filed by 5th of August, this the matter on 6th.
Please.
34.
As for preliminary hearing, please, my lords.
For preliminary hearing.
I am grateful.
Yes.
I represent respondent in this matter, my lord. I represent respondent in this matter.
My lord.
This is second round of litigation, my lord. In fact,
my lord, first round of litigation, my lord, this honorable court has directed to produce the documents. Documents produced, and the document
Let me
was not
understand the present litigation, then we'll go to the first round of litigation.
Same application.
No, my lord, that in this case, what happened, my lord, that
I'm not saying anything, Mr. Muttarna. Where is the impugned order?
impugned order is A, my lord. Page number 22.
To recall the order dated 3/4/2025.
Yes, my lord.
And to
Because
summon
here
the
my
BDA officials to produce the document and give evidence upon the same. What did the court do? Come to the reasoning part.
Reasoning
Para
here.
7.
Para 7, my lord. It is an admitted fact that the plaintiff had filed the similar applications earlier also, which came to be rejected. The said order was challenged in the High Court in the writ petition before his Honorable High Court, which was allowed, and the time limit was fixed to dispose of the suit within the period of 6 months. Now, your lordship may see para 22, my lord. I filed the application in the month of January. Order was passed after 6 months. Next, the suit of the plaintiff is for a declaration that he is the absolute owner of the suit schedule property and for permanent injunction restraining the defendant from encroaching the suit schedule property. The plaintiff has also sought for a recovery of the vacant position of the suit schedule property and mandatory injunction to remove the unauthorized construction as well as for mean profits. When the similar applications were rejected, the present applications are not at all maintainable. On perusal of the entire order sheet, it reveals that the issues came to be framed in the month of June 2010. And since then, the case is being adjourned on one pretext
Where
or
are
the
the earlier applications dismissed?
earlier application order, my lord.
That's what the court says. Just now you have read. When the similar applications were rejected, the present applications are not maintainable.
The similar application, that order is there, my lord. There it's mentioned.
Where is that?
Order is order that page number 83 to 87. Not 64 to 82. 64 to 82, my lord. The page number 81 is operation portion, my lord.
This order was passed on 27th September
Yes, my lord.
2019. Then 14th November.
No,
All sure it's so and so. 4/7/2025.
My lord, that is, this order is 88 to 96, my lord. Sorry, my lord. This order is 25, 88 to 96. That earlier order, my lord, that is the order, my order that was that.
Call the order dated 3/4/2025.
Yes, ma'am.
This is to
Page number.
quash the order dated 4/7/2025. So I'm seeking permission of the court to produce document in the suit.
Yes, my lord.
This came to be disposed of on 4th November.
14th.
Why you are filing these kind of application one after the other?
My lord, that this entire case revolves around that BDA plan approved, my lord.
Then what prevented you from doing all this from 2006?
My lord, 2006, my lord, I came to the picture only, after coming only, I came to know, my lord. I filed only 6 months back. Then only when I saw the records, I found that original, that plan is not there. Without original plan, there is no case for the plaintiff at all.
When did you come to know about this?
That immediately I filed. That is the
There should be dates for that.
That, my lord, that is, I filed the application, my lord, that is one minute, my lord. I came to know, I filed the application 31 months, 25.
There was a direction by the division bench to dispose it off within 6 months. We are in 27 until you are filing applications one
6
after
months
the other.
order was not passed, my lord. That is what my condition, my lord. I filed the application on 31 on 26. Order is passed last week.
When did you come to know about this?
This order.
Information. What made
No,
you to file this IA?
This information, my lord.
Come to the IA, let us see.
Yes, my lord. IA here, my lord. IA is page number 98, my lord.
98.
8, my lord. Number 2, I'll read that affidavit, I'll read, my lord. I stated that the plaintiff in OS had filed an IA dated 16/6/2 for production of the original sanctioned layout plan dated 14/9/78 before his honorable court, which was rejected on 7/7/25. Agreed by the rejection of the IA, the plaintiff filed a writ petition number so and so of Karnataka, praying therein. The honorable high court, after hearing the matter, was its order dated 11/11/25, has set aside the said order on 7/7/25 and allowed the application and directed to take documents on record. I said in the terms of the order passed by the honorable high court, as stated about the documents, namely approved layout plan, Sanction Development Authority on 49/78 has to be produced, and the BDA officer has to be, someone has to give the evidence in the.
What are you doing for 5 months?
That order was passed after 6 months. I filed the application in.
Forget about what the court did. I'm asking about you. This order of this court is on 7/7/2025.
Yes, my lord.
Present application is filed on 13th June 2026. What are you doing from that time?
The certified copy.
8, 9, 10, 11, 12. 5 months. You kept quiet to file this application. In a matter where there is a mandamus to the trial court, you keep on, whenever at your convenience, you're filing applications one after the other. Because it is Canara Bank Association, no special privilege to that.
No, my lord. That is not privilege, my lord, because only that
Only
whatever is allotted is given to the employees.
No, only if it is Canara Bank, then only special privilege.
No, my
But
lord.
Canara Bank
No, my lord.
Association.
Canara Bank is not privilege, but only this Canara Bank Employee Society. This is the entire, that society is formed only for the allotment of sites to the members. Because there is no money making or anything is not there, just allotment. But here what happened, my lord, this only 1 minute.
How many applications you are going to file from now onwards?
No. I will complete the inquiry within 3 months. That is what I'm telling this. Because once this document is marked, my lord, there is nothing. Because now.
I will say, if you come up with this kind of applications again, your suit should itself be dismissed on this.
Yes, my lord, that is correct. I'll agree for that. But the only thing is, my lord, they must allow my application to come on the.
Their intention all along is that they are trying to summon a document which is there in the custody of the BDA.
No.
That has not happened so far.
No. By virtue of the order passed by Justice Arur, no, the document has come on record.
Yes.
No.
Produced it.
Still now they have not produced the certified copy. That is where the difficulty is. They have a copy which is not legible. Previously also they have taken up same contention.
No, they want to summon BDA.
BDA, he is agreeable to come. Because earlier, my lord, BDA has issued.
Sir, my information is that these attempts were made previously also.
No, my lord.
Attempts were made previously also. BDA has not come back with any of the document. They attempted to file one document which is not clear and legible. So that's the reason previously the application was rejected, saying that the document is not legible and it cannot be marked. So that particular observation was
So
set
what
aside
is
by
the
previous
consequence of the order by Justice Arur? What should happen?
Lord, in view of that order, they were supposed to at least produce that document.
Produce
That
it.
itself they have not done.
My lord, produce the document.
According that attempt was made previously, the document was not legible. So the trial court said that since it is not legible, it cannot be marked. So that observation was set aside with the Honorable High Court. It was remitted back saying that he can file an application, marking and not marking of it can be taken up later. Even now, that document is not been produced.
Document has been produced, my lord. I have produced here also, a document has been produced. Now, only thing is the document has
Then
been
what
marked.
was the difficulty to get it marked as per the order passed by this court?
No, that is what, my lord, that is now produced the document, now they have proceeded with the
What were you doing
respondents.
for 5 months?
Respondents, that one is the evidence. 5 months, my lord, now that my consultation with BD and all, now they are agreeable for to come to court to give evidence. Unless the document is produced and.
I'm not convinced, Mr. Muttana. I'm not convinced.
My lord, now, otherwise, my lord, entire this 20 years.
What otherwise? Right from 2021 to 2027, this is going on with otherwise only.
No, now, my your lordship can give 3 months time that will ensure that.
Already the division bench, then Chief Justice has given 6 months.
No, division bench, my lord, what happened? Because the division bench has quashed that modified plan, this problem has come. 2006, that suit was filed. At the time, modified plan was in force. So, produce a modified plan. 2019, that Residents Association filed a writ petition, and this honorable court quashed that.
Oh, he says that document is available.
Yes.
He'll file.
Past 20 years.
Document is available, my BD official will come and produce.
Place before the court.
Yes, produce
You
now.
want to see?
Lord, that particular document they attempted to produce that. According to them, it is illegible. It's not legible. So they could not produce a better copy even after giving sufficient opportunity.
I understand. What is the order of Justice Arur? He said, you place this
Take it on
document,
record.
whatever it is.
Please.
Then you can call for somebody or you can do
Yes,
it.
exactly, Maya. That is what we want to do, Maya.
Let's look at that order. What exactly did he say so? Where is that order?
88-196.
However, under the circumstances when the document is sought to be produced, it is required to be accepted by the court. Later, the admissibility of the document can be considered by the trial court as to whether it is an admissible in evidence or any other order requires to be passed. When counsel for the petition plaintiff submits that they would produce the original layout plan as a photocopy produced not legible. However, the copy of the document produced by the plaintiff cannot be rejected on the ground that it may not be admissible to be marked as an exhibit. And it is for the trial court to decide as to whether the document is required to be considered or not on the basis of its legality subsequently, whether it is required to be allowed to be marked so and so.
That is the only part, my lord. That same document again and again they are producing. Since it was not legible,
First
the
of
trial court
all,
took that view.
Part 1 of this order shall be complied with or not?
Please, my lord.
What did the trial court do? It is taken that record on document on record or not?
Lord, they have not again filed an application. They have again filed an application to summon the official from the BDA. They have not produced this document again.
They have not complied with this order.
No, I filed, my lord. I'll tell
Can
the
you
date.
say- Please don't say that. Show me. When did you file? When did you file?
Yes, my lord.
Give me the date.
The date I'll give, my lord, in the afternoon.
This is matter.
Afternoon, my lord.
No afternoon.
My lord, my lord, this case is
Some
posted for
papers.
arguments the day after tomorrow.
Let it be. This is matter. On 4th of August,
Today afternoon, I'll produce, my lord, only for 5 minutes. 2:30.
pass over.
Yes, ma'am.
Give him papers.
Yes, ma'am.
Yes. So in the afternoon that can be done. Yes.
Cell number 35. Madhukar.
Petitioner is a defendant before the trial court, my lord. Agreed by the order passed by the trial court in appointing the commissioner order 26 rule 9 and before my lord's.
What is the suit for?
Suit for permanent injunction and mandatory injunction for demolition of 2 feet, which the plaintiff says I have encroached, my lord.
At what stage the application is filed?
Trial is completed, my lord. Now, what is the case of the plaintiff? If my lords come to page number 34, my lord.
40?
34, my lord. Para 11, my lord. There are 2 adjacent properties, my lord, belonging to plaintiff, my lord. 14 and 12, my lord. The plaintiff's case is that 14 from south to north, measure 30
No,
feet.
let us read the order itself. We'll
Please.
understand from the order.
I'll go to the
Page
findings.
28.
28 and 20.
Bottom.
In view of the ratio laid down in the above decision, it is very clear that if there is a dispute regarding the encroachment, the extent of the properties and boundaries, the appointment of commissioner, if necessary, if the court commissioner is appointed for the purpose of asserting the encroachment, the boundaries and extent of properties, it does not amount to collection of evidence. In the case on hand, the plaintiff has alleged that the defendant has encroached the suit B scheduled property, which is a part and parcel of suit A scheduled property. As there is an allegation regarding encroachment of the suit B scheduled property, the appointment of court commissioner is necessary to measure suit A scheduled property and defendant property. Unless both the order. Yes, my lord. The suit A scheduled property is the property number 12, my lord. What is the case of the plaintiff is that property number 14, my lord, which is adjacent to the property number 12, that measures 30 feet. Property number 12 measures 30 feet. Totally, there are 60 feet. So now when I measure, it is around 57.9 feet. So his allegation is 2 feet I have encroached. My property is towards the northern side of the property number 12. He has not produced any document with respect to the property number 14, which is not the subject.
What will happen if the
I will tell you. Kindly come to page number 121. This is a document by which property number 14 was allotted to the plaintiff's father.
Case that the court has no power to do it.
No, I'm not on that one, Mila.
Now, if the court commissioner is, whoever is BBMP engineer is appointed, he will submit a report. Ultimately, it's for the court to decide, and you can always place your objections and argue the matter.
No,
how are you aggrieved?
No, my only thing, my lord, property number 14, as per the document, measures only 28 feet, which I have produced, which belonging to the plaintiff, which he has not produced. So when the property number is 28 feet, so he has encroached the added 2 feet from the suit schedule property. So now if the property number 14 is not measured, only suit scheduled property is measured, it will come 28 feet only, my lord. Because he is going under the presumption 14 is also 30 feet, 12 is also 30 feet. When I compositely, when I measure, it comes to 58 feet.
No, the court, basing on the pleadings of the parties, has ordered this. What did the court say, please? What the commission is going to do? Please come to that.
That's what, my lord. Page number 29, my lord. 20.
Yes.
Just before the word unless, my lord.
Yes.
As there is an allegation regarding encroachment of suit B scheduled property, the appointment of court commissioner is necessary to measure suit A scheduled property and defendant property. A schedule is only property number 12, my lord. Property number 14, which he claims 30 feet, as per the document, which is 28 feet. If the property number 14 is not measured and only 12 is measured, the issue will not be sorted out, my lord. Because I have produced document to show.
Filed an application. What was your objection to that?
I have taken objection.
Let's see that. Where did you say what you are submitting before the court now? Where are your objections?
Yes, my lord. My objections are at, my lord, 133, my lord, page number.
Where did you say so?
That is the page number 135, my lord. Is from 10 less from the top, my lord. Hence, the plaintiff alleges defendant has encroached upon 2.4 feet of land. It is submitted, though the plaintiff claims that the property bearing number 58, new kata number 247, new number 14 measures 30 feet from north to south. He has not produced a single document for this honorable court in support of that claim. On the contrary, defendants has produced the regional lease cum sale agreement dated 26/11/1997 pertinent to the property bearing number set number 58, new number kata 247, new number 14, executed by the City Improvement Trust Board in favor of L. Lingappa, the father of the plaintiff. In the said document, the measurement of the property from north to south is 128 feet. The defendant has also.
Then counsel for the petition defendant submits that the court has appointed the commissioner to measure the land of the plaintiff, but unless the land of the plaintiff as well as the land of the defendant is not, it's your country.
Property number 14 also.
14 is yours.
14 is there. Mine is 11.
11 and 14.
11, 14, 12.
11 and 14, unless under property number 11 and 14 are measured, the true facts will not come to the light. However, court has failed to pass such a direction. Considering the same, there shall be stay of all further proceedings, notice to the response and summons. Memo by fourth. Yes.
Cell number 36, Mohan Kumar D.
This petition is filed seeking direction to the trial court, my lord, to consider my I number 2, which is for police protection.
I number
2, which is for police protection, my lord.
When did you file that IA?
18th 14/7/2026, my lord. 14/7/2026.
You file IA on 14/7/2026.
Arguments were heard on both I number 1 and 2, my lord. But emergent notice was issued only on I number 1, my lord. This is a page number, my lord.
No, for police protection, court need not hear the other side.
My lord, page number 34, my lord. Liberty was also given by the coordinate bench, my lord, to approach a civil court seeking police protection, my lord.
No, you have asked. So what do you want the court to do? Without notice to respondents, you grant you police protection.
At least they have not considered, my lord. They have not issued notice also, my lord. Page number
These
30.
kind of orders, the High Court will not interfere. That is not 227.
Or at least they shall consider, my lord. Page number 35, my lord. 34.
Because I am passing orders in respect of injunctions, that doesn't mean that in every IA, court will pass orders without hearing the other side.
Let them hear, my lord, but at least notice to.
No. I'll not. The petition is filed seeking the following prayer.
Lord,
And this court is not inclined to pass issue any mandamus accordingly dismissed.
Cell number 37, Chandrasekhar L.
Plaintiff's petition before this honorable court. IA seeking for amendment was rejected on 2/4/2025. It was rejected on the ground of the amendment application being filed on after a long gap of delay.
What is the suit for?
Partition.
Which year is filed?
2009. 19/9/2009,
Amendment is filed when?
2/9/2023.
29?
2023, ma'am.
When is the order passed?
The order was passed on 2/4/2025.
And you're questioning it now in 2026. Notice to the respondent.
Then
Much-
number 38. 38. Shahbaz Hussain.
Your Lordship, the Advocate General is appearing on VC, Your Lordship. Yes, Your Lordship.
Yes.
Manoj, in this, we are seeking to challenge annexure A and B, Manoj. What we are seeking in this matter is, Manoj, the annexure A, the amendment ought to be, is in the year 2015, Manoj, by CERC and NDL. Your Lordship got it, Manoj, annexure, that is at annexure B.
Setting aside regulation number 70G of the Central
Lordship
Electricity
got it, Manoj, at annexure, regulation is at page 53, Manoj, annexure A.
Norme to parameters. Regulation 10.3. So you're questioning the regulation 70G and 10.3.
Please, Manoj, what we are saying is, Manoj, Manoj, the reason that arises for this is, Manoj, to promote renewable energy, Manoj. What we are saying is, we are giving load compensation insofar as these thermal projects are concerned, Manoj. During which period we tell them to use only partial load, Manoj. By virtue of which certain loss is caused to these people. What we are saying is, what is the actual loss caused to these thermal project companies, Manoj, will compensate them.
Who
But
will,
the
who appears with the Central Electricity Regulatory Commission?
Manoj, central electricity, Manoj, the council for that is,
We'll find out, Your Lordship.
What we are saying is, Manoj, during this period of where there is not actual loss, we are ready to compensate the various thermal companies, but not the notional loss or the nominal loss, Manoj. That's the short point for Your Lordship kind consideration.
We'll hear you. When do you want?
My,
Because we come, when we have to, I mean, you're seeking, you're questioning these regulations. It has to be heard. And then we'll pass an order if interim order if necessary. When can you
Can I
ask?
request this one thing, Manoj? Your Lordship may, I'll serve on the standing council for respondent 1 and 2. Your Lordship may have it next week, Manoj, on consideration for interim orders, Manoj.
So and so. The petitioner shall serve the respondent 1 and the panel councils appearing for 1 and 2 and shall file a memo to that effect by 3rd of August. If the memo is filed, list this matter on 4th August for preliminary hearing in the first list.
Please.
Lordship, this is a mandamus for speedy trial. Is a partition suit. It is instituted in 2007. That's how they instituted the partition suit. 2007, the partition suit is instituted.
Which court is this?
The petitioner evidence agila. Lordship. In the court of Arascote, senior division Arascote.
What is the present stage?
Lordship?
What is the present stage of the suit?
Still in evidence, Lordship. Petitioner evidence still pending.
Please come. Let counsel for the petition submit the suit of the 2000 of the year 2007, and the petitioner is aged about 88 years, and she seeks for a mandamus. The registrar judiciary is directed to call for a report from the concerned court. How much time it requires to dispose of this suit? List this matter on 3rd of August in the first list.
Case number 40.
Great, Lordship.
My lord,
Yes,
this is in
Devaya.
relation to the appointment of a court commissioner, my lord. Here is an instance where, under the guise of executing a decree, my lands, my own lands, where the RTCs are in my name, are being sought to be taken over by the decree holder. That is my only submission before the honorable court was that let that my lands be demarcated and the lands which the ADLR.
Who are you?
I am the judgment debtor, my lord. On the basis of a survey sketch which was prepared in the year 1993, the court, along with the
What
survey.
is the suit for?
It was originally a suit for possession, my lord. I had filed a suit in the year 1991, which came to, 1983, which came to be decreed in my favor. In first appeal proceedings, the court appointed a court commissioner. They found that both parties had encroached certain pieces of land. That accordingly, the appeal came to be rejected. The decree holder today preferred an appeal before this honorable court, and the order was upheld. The first appellate court's order was upheld,
When
and the
was
court
that?
commission. My lord,
When was that?
that was in the year 1999. There, my lord, this honorable court held that the decree holder today could file a separate suit, a fresh suit, to recover the lands which may have possibly encroached upon. Therefore, on the basis of the 1993 survey sketch, he files a suit. The decree holder files a suit, and his suits come to be decreed. First appeal rejected, second appeal also has come to be rejected. Now, on the basis of a 1993 survey sketch, he's come to execute it and to recover my lands. All my request before the honorable court, trial court, was, my lord, that demarcate my lands. If there is any encroachment of his lands, I am willing to give up. But unfortunately, the surveyor and the court,
When was the RSA, dismissed?
the second suit RSA dismissed in the year 2021.
Basing on the same.
The court
sketch.
commissioner's survey sketch of 1993.
You have never objected to that.
I have objected to that, my lord, and that came to be, my lord, that objections came to be heard, and thereafter that suit came to be dismissed. I'm
That's
conceding
what,
to that.
According to you, it was a sketch of
1983,
and you have raised your objection to the sketch.
Correct.
And
both of us have
both
taken
in the
up lands.
appeal and the second appeal, that was rejected. Your
That-
contention is rejected.
Correct. Insofar as the challenge to that sketch, and even he's handed over lands to me, and there has been a closure of all the issues over there. Now he files a suit on the basis of that sketch. From 93, no fresh sketch has been conducted.
Now, what has happened between the earlier suit and the suit of 1999?
There were some lands which he had encroached of mine, which he handed over to me. Then he files a fresh suit. That suit came to be decreed on the basis of the 93 sketch itself. The challenges came to be set aside. I can see that all of those aspects are done. But today, the only position is, my lord, the sketch is not at all in consideration. The only question is, my lands, of which I am undisputedly the owner in the RTC, the possession of those lands are being taken. I'm saying if I'm in possession of any of his lands, I hand it over back. But let the ADLR demarcate the boundaries of my lands. And if I'm
Can you afford to say that if any land is, when both the courts have concurrently held that you are in possession of his land, where is the question of if any?
Again, my only submission is this. There was a sketch conducted in the year 93.
You can say,
my lord,
this is not the land in encroachment. This is the land.
Precisely.
You cannot say that there is no land in encroachment at all.
There was, again, I'm conceding, there was some lands in encroachment.
Where is that final order, which has attained finality? Where is that order?
My lord, 2021
Basing
order.
on which now they have filed the execution.
My lord, may I share the document, the order with you?
Yes.
This is
Take that.
This is the order passed by this honorable court, my lord. May I take, my lord, directly to page number 10, paragraph number 12, which will.
Page number 10.
10, paragraph number 12. It is, may I read, my lord?
Yes.
It is not in dispute that the father of the defendant, Sri Mutana, had filed a suit in OS 48 of 1983 against Bopaya, the ancestor of the plaintiff, seeking recovery of possession of some portion of the land. Admittedly, the judgment and decree passed in OS 48 of 1983, dated 22/2/1989, held that Bopaya had encroached in all 45 cents of land.
Who is Bopaya?
He is the predecessor of the decree holder. In survey number 48/2 and 48/3, that is my lands. Both put together and directed Bopaya to deliver possession of the said 45 cents of land.
Bopaya is you.
My lord?
Bopaya is you.
No. Predecessor of the decree holder. I am the judgment debtor today. My lands are in 48/2 and 48/3, which Bopaya had encroached.
Yes.
It is also not in dispute that by challenging the said judgment and decree, the defendant in the said suit, Sri Bopaya, filed RA 9 of 1991 in the court of the senior civil judge at Virajpet. It is also not in dispute that at the instance of the said Bopaya, Commissioner for Survey of Land was appointed for surveying the properties of the plaintiff and defendant. The said Commissioner's report revealed that the alleged encroachment by Bopaya in the lands of Muttana, that is my predecessor, was only to an extent of 20 cents and 10 cents in 48/2 and 48/3 respectively, whereas the said Muttana had encroached the land to an extent of 2.25 acres in survey number 48/9 and 50 cents in survey number 48/11. The said Commissioner's report was not challenged by the respondents in RA 9 of 1991. It is accepting the said Commissioner's report, the said RA came to be dismissed. The children of Muttana challenged the said judgment and decree passed in 9 of 1991 before this honorable court in 486 of 95. This fact is not in dispute. The court, by its judgment of 1998, set aside the judgment and decree passed in 9 of 1991, restored the judgment and decree passed in OS 48 of 1983. However, as could be seen from the certified copy of the said judgment passed in so-and-so, which is P6, this court in the very same judgment confined the encroachment extent to only 30 cents in 48/2 and 10 cents in 48/3 in accordance with the report of the ADLR. It is also observed in the same judgment that it is open, my lord, the defendants in this said OS 48 to recover any encroached portion said to have been encroached by the plaintiff Muttana by way of a present or separate proceedings. In that background, the argument of the learned counsel that in view of the fact, my lord, this is the objections that have been raised at that point in time, to say that along with the rejection of that application in the report
Yes,
goes.
sir.
My lord, thereafter, my lord, I'll have to take, my lord, directly to, my lord, page number 19, paragraph 19. So that the other ones were relating to adverse possession. I will not bother my lord with that. Paragraph 19. In the instant case, as observed above, even though the plaintiffs can be taken as coming to know about the possession of a portion of their property by the defendants as long as back in the year 1986, as analyzed above, the alleged possession of the portion of their property by the defendant had by then not become adverse to the plaintiff. As has come out in the pleadings of the parties and also through their evidence, an undisputed fact is that the lands of both Bopaya and Muttana were surveyed, and it was revealed by the report of the commissioner that there is encroachment of the property by each one of them to some extent. Accordingly, the plaintiffs in the present suit were asked to deliver possession of 30 cents in 48/2 and 10 cents in 48/3 in accordance with the ADLR's report as held in RSA 486 of 95, in its judgment of 98. So by virtue of the said commissioner's report, which has been considered and accepted by the court, the plaintiffs in the instant case came to know the exact extent of the land under the possession of the defendants by instituting the present suit. And it is the defendants through the written statement have taken up the plea of adverse possession. So in pursuance to all of these, my lord, my appeal came to be rejected, that order came to be confirmed. I'm conceding to all of these.
Hand over the possession of the property.
Precisely. I'm conceding to all of these. I'm not saying no at all. The only position here is that can, by way of a survey, rights in respect of immovable properties be created in favor of the decree holder. All I'm asking the ADLR to do is demarcate the boundaries of 48/2 and 48/3. If the, let me concede for a moment that there is encroachment. It has to be beyond 48/2 and 48/3. The survey cannot create rights in favor of the decree holder. So literally, they're taking over my land on the ground of executing the decree.
No, what is your case? Your case is that there is no land in encroachment.
Not as per me.
That you cannot say. That is what is the.
That is what. For a moment, let me concede that there is encroachment.
And there are two. Finally, that judgment and decree has attained finality, and as per the same, you have encroached an extent of 40 cents. 40 cents?
40 cents of land.
40 cents of land. So that position has to be delivered to the
absolutely only position is not. All I'm asking is demarcate the boundaries and take any portion. Let me concede.
Where did you say so? Let's see.
My lord, yes. My lord, may I indicate, my lord, to the order, the application at page 55.
Yes.
My affidavit is at page 57. May I read paragraph 2, my lord? I state that the decree holders have filed the present execution petition seeking to execute the decree passed in OS 77, wherein it has been held on the basis of a survey sketch prepared in the year 1993 that I have encroached upon lands belonging to them. It is my specific contention that I have not encroached any portion of the lands of the decree holders, and that under the guise of executing the decree in OS 77 or 99, the decree holder is encroaching into my lands in survey numbers 48/2 and 48/3. Even assuming the correctness of the survey sketch being relied upon by the decree holders, using such survey sketch, the decree holders cannot dispossess me from my own lands in survey numbers 48/2 and 48/3. This consequence can be obviated by the boundaries of our lands are fixed and possession of those lands as per the said boundaries are recorded. Considering the same, as it is essential for the court commissioner, being the ADLR, who is the custodian of the survey documents, to fix the boundaries with respect to my lands bearing survey numbers 48/2 and 48/3, as well as my lands in the north of these lands, that is 45/1. This is necessary, my lord. And impugned order is at page number 24, I'm sorry, 22, my lord. And the relevant portion, my lord, will find it at page number 29, paragraph 10. May I read, my lord? Through the present application, the judgment debtor number 1 is praying to appoint ADLR of Ponnamppet Taluk as court commissioner to survey the lands in 44/1, 48/2, 48/3, 48/9 and 11 and 49, and the remaining lands in 48/1 of Nokia Siddhapura village, and to fix its boundaries as per the existing survey records, and to record the possession of the decree holders and the judgment debtors insofar as the said lands. According to the JDR number 1, the present petition is filed to get possession of the lands in 48/9 measuring so and so. The encroachment has already been identified by appointing a court commissioner in OS 77. That is wrong, my lord. That statement is wrong because the court commissioner was not appointed in OS 77. It was appointed in the RA proceedings in the year 1993. The court commissioner has already surveyed the lands in the presence of parties to the list with the assistant surveyor and identified the encroached lands. The said survey sketch has been marked.
Please come. When counsel for the petition judgment debtor submits that, the court has dismissed an application filed I number 3, wherein he has sought for an appointment of advocate commissioner. It is submitted that the court is going to execute a decree basing on a sketch that is exhibit P4.
P4.
Dated
1993, the date, my lord, is...
in the year, in the earlier proceedings, in the year 1993, it is submitted that after the earlier judgment and decree, the properties, certain properties were handed over by the petitioner to the defendant or defendant?
Defendant to the
defendant, the decree holder in this, to the judgment debtor in this petition. It is submitted that in those circumstances, a survey is very much required, but the court, without considering all that, has dismissed the application. Considering the submission, there shall be stay of all further proceeding. Pursuant to the order, same hand summons, memo by 4th. Yes.
Cell number 41, BC, Avinash.
Yes.
For the petitioner, my lord. The impugned order is at page 165. I am the judgment debtor in the...
Page number?
165, my lord. I am the judgment debtor before in the execution proceedings. I am a bank, my lord. I am the bank. Petitioner is a bank. I am a judgment debtor in the execution, wherein the execution court has issued a arrest warrant against the officials of the brief facts, my lord. The respondent had availed a loan, car loan, in the year 2002. Subsequently, he defaulted in repayment of the loan. In the year 2003, the bank was repossessed and auctioned. Subsequent to which, the first he files a first suit, OS 543 of 2003, for bare injunction in the year 2003, which came to be dismissed. Subsequently, again, he files another suit, OS 208 of 2006, for bare injunction, which came to be dismissed. He prefers a regular appeal, which came to be dismissed. In the year 2011, he files OS 906 of 2011, seeking a mandatory injunction against the bank to give the particulars of the auction.
What is this order now? DHR and his counsel present. Where is the order?
Order is at 165, my lord.
Page?
165.
DHR and his counsel present and prays to issue arrest warrant against JDR.
Yes, ma'am.
Can to issue arrest warrant against JDR?
One case called out 165, ma'am. Case called out, both counsels are present. DHR counsel filed IA number 5 under section 151 of CPC and prays to permit the
Petition
JDR
is
to
before
deposit.
this court agreed with the order dated 27/4/2026, whereby the court has issued arrest warrant against the JDR. It is submitted that the JDR is a bank, and when the court issued the arrest warrant, the court ought to have recorded the reasons for issuing the arrest warrant without recording any reasons. Just like that, the court has issued the warrant, and it is submitted that they are all the officers of the bank. Considering the same, stay of all further proceedings pursuant to the order dated so and so.
Much
Notice hand summons. Yes.
Cell number 42,
Okay, for petition in this matter. Suit for partition and separate possession, my lord. My lord, the respondent number 1 to 4 I have filed a application before the trial court, my lord, in FDP proceedings, my lord, under which seeking my lord, sale the item number 11 of the property, my lord, in public action, my lord. My lord, thereafter, my lord, the petitioner have filed a objection before the trial court, my lord. The trial court has not considered the objection.
What is
Filed-
objection?
Objection, my lord, regarding, my lord, not to sell the property in public action, my lord, and also, my lord, the operative portion, my lord, the page number 1112.
Why it shouldn't be sold in public auction?
My lord, the commissioner has submitted the report before the trial court, my lord, under which stating that, my lord, the property cannot be demarcated, my lord. My lord, the property is situated at Tiptur town, my lord. And also, my lord, the total measurement of the property, my lord, 7,168, my lord, square feet, my lord. And he submitted the report stating that, my lord, the property cannot be demarcated. For that reason, place the record before the trial court.
You want to buy the property?
No, my lord. My lord, I want a property, my lord, because, my lord, there is a sentiment, because, my lord, the property is the ancestral property.
Pay the money, then only.
My lord, I am not having a money, my lord. For that reason, my lord, there is a sentiment in the said property, my lord. My lord, petitioners,
Yes. Yes, I'm hearing.
my lord, the property is situated at Tiptur town, my lord. Lord, each,
I understand.
my lord,
If you have a sentiment, the property will not be sold in execution proceedings. If you have a sentiment, you have to pay.
my lord, kindly
And
see
you
the-
don't pay and it shouldn't be sold in the public auction. What is that submission?
my lord, the property value, my lord, more than, my lord, 1 crore 44 lakh 15,000. My lord, the approximately, my lord, each of the parties having a share in the scheduled property in more than, my lord, 1,200 square feet. And also they situated in Tiptur town, my lord.
What is precisely is your objection?
My objection, my lord, not to sell the property in public action, my lord. I'm entitled in the share in the scheduled property, my lord.
Because
But
it is not divisible, the court is selling it. And if you want to purchase those, the property, the already rate is fixed. You're ready, then we'll ask the court to do it.
Not having the money, my lord. Please not having.
But unfortunately, we can't interfere with the order. Please come. Agreed with the order passed in I number 4. In affidavit number 4 of 2021, dated 2nd May 2026, the petitioner is before this court. It is submitted that the court has passed an order basing on an application filed by the other co-sharers to sell item number 11 of the scheduled property and to distribute sale consideration amount among the petitions and among the parties in the interest of justice. When counsel submits that, the petitioner has has sentiment as it's an ancestral property. And the court ought not to have passed an order directing the property to be auctioned in a public auction. The court, by order impugned, has allowed the application filed by the other co-sharers. While passing the order, the court observed that it shows that the said property is having irregular measurement, and also it's a very small property which cannot be distributed by demarcating and allotting shares to the petitioners and respondents, and therefore it's just unfair to put the item number 11 property for sale and to distribute the sale consideration amount to the petitioners and respondents to provide equitable relief as per preliminary decree under section 2 of the Partition Act. Though the respondents have contended the petitions have not filed this application under specific provision of law, but the application of petitions cannot be dismissed only because it is not filed under a specific provision of law. The court commissioner has not demarcated the suit item 11 of the property, and also the measurement of the suit item 11 property shows that it is having abnormal measurements which cannot be divided into 7 parts, and therefore it is not possible to allot the share in the suit property item number 11 property, and as such it is just and fair to pass an order for the sale of the property. Hence, hence the application is allowed, wherein the court has observed that it is ordered for the sale of petition schedule item number 11 property instead of division as per section 2 of the Partition Act. However, any of the petitioners or respondents wishes to purchase the petition schedule item number 11 property, he or she can purchase in accordance with the provisions of the Partition Act. If the shares, that is, petitioners and respondents are not willing to purchase, in such an event, it will be put to public auction, and therefore the sale proceedings shall be the sale proceeds shall be disputed among the petitioners and respondents. Next, parallel counsel appearing for the petitioner submits that it's not acceptable for the petitioner to sell the property in the public auction. The court, without considering the price and other aspects, has put the property to auction. Next, this court has asked and counsel to the petitioner if he is ready to purchase the property. The court has given provision for the same. It is submitted that he do not have enough amounts to purchase the property. Next, for having heard the counsel for the petitioner, there is a material on record. The court has passed an order as per section 2 of the Partition Act, as the property is not divisible, and also given an option to the petitioners, and the petitioners are ready to purchase the property. In those circumstances, the court cannot interfere with the order impugned, as there is no illegality with the same. Accordingly, the writ petition is dismissed.
Next matter, madam. Next matter, may I permitted to take notice to Devaraj, who is appearing for this now.
43, petition is permitted to take out hand summons on Mr.
And
Devaraj.
date may be given for call, because otherwise they will downsize the power supply to my factory. So tomorrow or day after tomorrow, date may be given.
I'll take it up. This is permitted to take out hand summons on Mr. Devraju. Registry is directed to reflect his name. List the matter tomorrow in the preliminary hearing.
Obliged.
HP Devaraj.
Court officer, sir.
HP Devaraj. Sir, 2:30 ಗೆ ಪಾಸ್ 2:30 ಮ್ಯಾಟ್ರಿಗೆ ಒಂದು ಪಾಸ್ ಹೋಗಿದೆ ಮೇಡಮ್ ಯಾವ್ದು ನಾಳೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 86 ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಇದೆ, ಆಫೀಸರ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ. ಫೈಲಿಂಗ್ ಅಲ್ಲಿ ಕೌಂಟರ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡೋದಾ ಇಲ್ಲ ರೀಚ್ ಆಗುತ್ತಾ ಸರ್? ಓಕೆ ಸರ್.
ಇನ್ನು ಕರ್ದೇ ಇರಲಿಲ್ಲ. ಅದ್ ನಾಳೆ ಇಲ್ಲೇ ಕಳಿಸ್ತೀವಿ, ಕೋರ್ಟ್ ಅಲ್ಲಿಗೆ ಕಳಿಸ್ತೀವಿ. ಸೈನ್ ಮಾಡಿಸ್ಕೊತೀವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋದ್ರೆ
ಕಂಟಿನ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲ ಲಿಸ್ಟ್ 230 ಅಲ್ಲ 230
Continue the list. Continue the list. No, this is 24th. That is Thursday. Continue the list.
Next, continued. Serial number 43. Serial number 44. Serial number 44.
44, I am for petitioner. Madam. The connected matter has been the notice has been ordered and I served the notice also. It is posted tomorrow. Let it be also.
List along with so and so. Yes, next.
Serial
Give the
number
number. Number to her. Yes.
The number, sir. Serial number 45, urgent 46. Serial number 46, Pundika Ishwara Bhatt.
Yes.
For the petitioner, I have purchased 3.28 cents of land along
What
with
is the suit for?
suit for injunction and also for damages.
IA?
Please, madam.
What is the IA, interlocutory application?
That is for injunction, order 39 rule.
What
and
happened to
amendment.
that?
That was allowed. First appellate court to reject my appeal.
Please come to the first appellate court's order. Yes. Let's read the reasoning part.
Yes, point number 1.
Yes.
Page number 26.
Yes.
The present contingency cropped between the parties herein on account of granting interim injunction sought by the plaintiff before the trial court upon allowing IA number 2, the defendant being the aggrieved from the granting of interim injunction and free to vary the same through present appeal. Before touching to examine the legitimacy of impugned order involved herein, it is necessary to consider herein that it is well settled law to consider the interim injunction that the court must satisfy with the prima facie case, the balance of convenience and comparative hardship. It is also well settled that establishment of prima facie case is condition precedent to consider two other factors, and prima facie case means neither the case of the plaintiff exegesis nor capricious, and even consider the material at pre-trial stage. It must ensure the court that the plaintiff will ever chances to succeed in the claim made even the full-fledged trial is taken place. In the said position, it required to examine the materials on record. The root cause for the present dispute between the parties is that the defendant has taken up the construction work in the property bearing survey number 131/1A situated at block number 11, new extension so and so, which is situated adjacent to the suit property or property claimed by the plaintiff. The plaintiff has contended that the defendant has violated the building by law and he has constructed his building by causing overlap on the portion of the suit property and portion of projection of building. Defendant is encroached upper level of the suit property. The parties are not in dispute as to the existence of the suit property and the existence of the property of the defendant as adjacent to each other. The plaintiff has contended around origination of suit property that his father has purchased the suit property and after his death, the name of the mother mutated thereon and her mother has bequeathed the property. Whereas the defendant has contended that he has purchased the property to an extent of 3.28.
Yes.
My lord, the trial court has proceeded on the footing that it will affect his light and air, therefore granted injunction. Whereas the first appellate court held that the structure which I have made on the first floor, it overlaps the suit schedule property, on the suit schedule property. On that ground, the injunction order passed by the trial court was confirmed. May I take your lordship to the photographs which I have produced? So far that our, that is the title is concerned, there is no
Where are the
dispute.
photographs?
Please, I have produced, kindly see page number 78, annexure D. Is the first photograph. My lord, this was the building earlier. Before I have got half right, that is the yellow portion is my portion. That is on the southern side virtually. On the northern side, that is on the other side, is the property of the plaintiff.
Come to page 79. 79.
Please, I will come to that.
79.
Yes, that I have demolished my portion of the building. That is the common wall. Even today, it is in existence. I have not disturbed the common wall because we have both of them have got equal right over the that common wall. And then kindly see the next photograph, that is D2 at page number 80.
No, I have to understand what is this? Whose house is this?
This is a new construction. Old house is belonging to the plaintiff.
So the new construction you are
That is
making.
my concern. That is in my portion. There is no dispute with regard to that.
Yes,
I
yes.
got constructed this house after obtaining license from the Madikeri, that is municipal council.
Yes.
And now my submission is that I have actually, after the construction reached this stage, that is as could be seen from the photograph, the plaintiff has filed a suit. Till then, he kept quiet. He kept quiet till then, and comes before the court saying that is it will affect his light and air, and it also encroached his property aerially, and also therefore he sought for damages. Plaintiff has sought for damages. My submission is that when there is a common wall, and the other contention raised by the plaintiff is that I should have left this setback area. In so far as the common wall is concerned, the question of leaving setback does not arise. My submission, I will take your lordship to the judgment of the, that is 1978, Madras, page number 97. May I take your lordship to the judgment, wherein so far as the
Yes.
common wall, that is with regard to the common wall, what could be done, and is clearly a person cannot acquire, that is the in the case of common wall, each co-owner is entitled to a reasonable user of the wall owned in common, and so long as each co-owner uses it reasonably without interfering with the enjoyment of the wall by the other co-owner, or without doing anything which would weaken, damage, increase or demolish the wall enjoyed in common, he is entitled to do what he likes, and the other co-owner will have no cause for complaint. My lord, my submission is that when it is, I have not disturbed that common wall, even today that is in existence.
Yes.
And if he had any objection, he should have raised in the earliest point of time. When I raised the building, when it has reached the first floor, he has filed the present suit, and the trial court has granted the injunction in favor of the plaintiff.
Yes.
Therefore, I have got every right to put up the construction in my property. But the trial court has held that it affects his right and air. That is not correct, because even the finding of the trial court has, I have left that is common passage in between. I have left certain portion till the wall level. Therefore, in view of that, I could not proceed with the construction. It is in a construction stage itself. I have no house of my own, and this is the only where I can reside. I have no other house. Therefore, in view of the granting of the injunction, great hardship will be caused to the defendant, not to the plaintiff.
Yes. Please come. Agreed with the order passed in. MA number 1 of 2025 by the senior civil judge and civil judge at Madikeri and dated 24th April 2026, whereby the court has confirmed the order passed in I number 2 in OS number 45 of 2024, dated 7th December 2024, by the principal judge and JMSC Madikeri. The petitioner, defendant is before this court. The respondent herein had filed a suit seeking the relief of declaration that the construction made by the defendant extending the structure to the scheduled properties in violation of the plan and a direction to the defendant to remove the structure and also for consequential relief of permanent injunction. He sought for damages of rupees 3 lakhs against the defendant. In the said suit, he has filed IN number 2 seeking temporary injunction that came to be allowed by order dated 7th December 2024. Then the petitioner has carried the same in appeal by filing MA number 1 of 2025. The appellate court has confirmed the order of the trial court. While confirming the order of the trial court, the has observed that the defendant observed that the purview of hardship applied to the interim injunction of the trial court has granted with interim relief by restraining the defendant from proceeding with further construction. When the construction of the defendant appears to be illegal by overlapping on the suit property, the trial court has rightly granted interim injunction by exercising its sound discretionary power, and there is no any material from the part of defendant to say that the said order is perverse and illegal. The granting of interim injunction is even avoided the further loss of the defendant. Further, it will be further loss to the defendant. In further, if the interim injunction decline and the defendant continue with his construction to complete, then the delay in justice will happen. In the way, the trial court examined the comparative hardship and balance of convenience in judicious manner and ultimately granted the interim injunction. The court has come to the conclusion that there is no error with the order passed by the court. The court has also observed that the defendant has not at all disputed the construction work, which reached to the first floor. The projection made in first floor is clearly overlapping and encroached the portion of the suit property from the level of first floor. It is clear stand of the plaintiff that when the defendant has shown illegal approach towards this construction by violating the building bylaw, she has lodged a complaint before various authorities. In this regard, the plaintiff has produced documents. In addition to the said stand, the plaintiff has contended that by causing inspection, the CMC Madikeri has issued notice to the defendants to stop the construction work. The defendant has not disputed this aspect by producing any authenticated proof. The court observed that the photos and corresponding material produced by the rival parties clearly demonstrate the prima facie case in the stand of plaintiff, and accordingly, the court has dismissed the appeal filed by the defendant. When counsel appearing for the petitioner submits that the petitioner is making construction within his property, and the trial court has granted injunction that it will affect the light and aid to the property of the plaintiff, and the appellate court has allowed the appeal, has dismissed the appeal on the ground that the that it is causing obstruction to the plaintiffs.
I will read one sentence. Construction, the dispute is construction is
Overlapping.
it appears to be caused overlap
As per
on
the
the suit
photographs,
property.
it is overlapping the construction of the construction is overlapping, and the photographs are clear on that. It is submitted that when he is making construction within his land, question of leaving the setbacks and other things will not arise. He has relied on a judgment of the Madras High Court in case of K. Mohiuddin Ibrahim versus M. Mohammad Abdullah, reported in AR 1978, Madras 97. He relied on paragraph number
8.
Paragraph number 8. Relying on this, it is submitted that the court ought not to have dismissed the appeal. Further, if the injunction is granted, it would cause lot of hardship to the defendant, and in fact, balance of convenience is in favor of the petitioner defendant. It is submitted that when he is making construction, till the construction has reached the first floor level, the defendant has not made any objection.
Plaintiff.
The plaintiff has not made any objection. In view of the same, he is not entitled for the relief. Further, it is submitted that there is the only place where the petitioner is constructing to reside, and because of the interim orders passed by the court, injunction granted by the court, he is not able to proceed with the construction, and that is granting lot of hardship to the defendant. All these aspects were not considered by the trial court as well as the appellate court, and both the courts went wrong in granting injunction. Next paragraph. Having other counsels on either side, peruse the material on record. The whole case of the plaintiff is that because of the defendant is making construction, and by overlapping the property of the plaintiff, the court has perused the photographs, both the trial court as well as the appellate court, and they have come to the conclusion that on the face of it, there is overlapping. Overlapping. Considering that, the court has felt that unless the said construction is stopped during the pendency of the suit, when the relief itself sought in the suit is that it would cause hardship to the plaintiff. It could, and as he is able to satisfy the three ingredients for grant of ad interim injunction, the court has the injunction. The trial court has granted injunction, which is affirmed by the appellate court. This court, considering the argument of the land counsel for the petitioner and the judgment that he has relied upon at this stage, this court is not inclined to go into that aspect. The plaintiff could successfully prove before the court that he is entitled for injunction when both the courts have concurrently has granted injunction, unless the said finding is perverse, arbitrary. This court cannot interfere with the same. In the considered opinion of the court, the order include needs no interference from this court. Accordingly, the writ petition is dismissed.
Number 47, Nagabhushan R.
Yes.
Nagabhushan R.
No representation list in the month of September. Yes, 48.
Say number 48.
For the petitioner, my lord. My lord, the first respondent has filed a suit for partition, my lord.
Yes.
First respondent is the sister of the petitioner, my lord. She has filed an application for deposit of rents, my lord. With respect to Schedule A property and Schedule C property, my lord. Schedule A property, the mother of the petitioner has gifted me that property, my lord. So the rents which has been direction has been given to respondent number 4 and 5 to deposit the rents, my lord. That is the reason I'm before this court.
No, that property belongs to your mother.
No, property belongs to my mother.
How?
She has purchased, she has got it obtained under the will, my lord. Kindly come to the plaint, my
Will
lord.
executed by whom?
By father, her father,
By her father.
her father. Kindly come to the plaint. My lord, plaint is found at page number 25, my lord. Start from page 23, para number 3, my lord, is relevant.
That's the case of the plaintiffs.
My lord, case of the plaintiff.
Case of the plaintiffs.
Yes, ma'am.
Page, para number?
Para number 3, page number 25, my lord.
Hmm.
My lord, the house property bearing number 27 Bharti, that is the Schedule A property, herein was owned by Srimati Chandrakantama, who is the mother of petitioner and first respondent, my lord. The mother of the plaintiff and the first one, she had acquired the said property under registered gift deed dated 16/4/1975 from her father Komarla Narayana Shetty. She D.S. Chandrakantama died on 11/8/23, leaving behind the plaintiff and first defendant as her only heirs and successor. Her husband, T. Satyanarayana Gupta, had predeceased her on 18/1/2020. My lord, later on, and she has bequeathed the said property in favor of the plaintiff and first under registered will dated 8/5/2014. That is the reason she has filed the suit, saying that there is a will executed by Chandrakantama. Both of them are entitled for a share. But there is a
Come to
gift
the
deed.
impugned order. Come to the impugned order.
But it's found at page number 17, my lord. The relevant page is at 18, my lord. Para 3. Perusal of the affidavit filed in support of the application discloses that the title and the share are seriously disputed and suit for partition is pending adjudication. The existence of tenants in suit schedule A property and collection manner of the rents by defendant is not seriously disputed at this.
When counsel for the petitioner submits that the court has directed to deposit the monthly rents payable in respect of the. What about Schedule C?
Schedule C I'm not bothered because they were both are entered. Only Schedule
And
A.
A and C scheduled properties. They submitted that he is only aggrieved as far as the C, A scheduled property is concerned, which is gifted to him by his mother. And admittedly, the mother has inherited the said property, which is bequeathed on her by way of a will by her father. In those circumstances, the court ought not to have passed an order to pay the what is it, the rental income in respect of the A scheduled property, considering submission of the land counsel for the petitioner. There shall be stay of all further proceedings as far as the Schedule A properties are concerned, pursuant to the order dated so and so. Notice and summons memo shall be filed. Yes, next.
Case number 49. Ramesh Chandra, petitioner.
Appeal for the petition. This is
Yes.
defendant's petition. Respondent had filed an application, the petitioner had filed an application seeking amendment of the return statement.
Suit is for
Suit is for ejectment.
ejectment. When
Ejectment.
it was filed?
It was filed in the year 2024.
When was the IA filed?
I filed on 2020, says 5, my lord. 26, 25, 30th of August 25.
Let's see the application in support of the IA.
Yes, annexure C, my lord. 40 page. Because there is a change in council. Subsequently, after this change in council, it was filed. It was.
What was the earlier stand?
Earlier stand, there was no such stand is taken. That is why the court said it was within the time, within your knowledge. That's why it was not pleaded. There is no dispute.
Come to the order.
Annexure A, my lord. Page number order, page number 20. Reasoning parts come in 22 page. Before discussion, this court relied upon provision order 6 rule 17.
Please come. Then counsel for the petitioner submits that when an application is filed under order 6 rule 17 seeking amendment of the claim, the amendment of the written statement, the same was not considered by the court. It is submitted that being a defendant, you can take any number of pleas. And further, the said defendant, the said defense will not cause prejudice to any other parties, as when he is pleading a particular fact, the burden lies on him to prove. It is submitted that now what is the stage?
Now for amendment, right, cross of PW1 is there.
It is posted, matter is posted for cross of PW1. Considering the submission of the accounts for the petitioner, there shall be stay of all further proceedings. Question to the order dated so and so. Same fourth and summons.
Cell number 50. Anasa, for petitioner.
Yes.
Your Lordships kindly, my lord, appear for the petitioner's counsel. My lord, a suit comes to be filed by the respondent plaintiff for partition of 1/8 share. My lord, the trial court, my lord, partially decrees the suit in against which an appeal comes to be filed by the plaintiff. My lord, that decree of the trial court is modified by a judge.
The plaintiff, the trial court said, what is the share?
Trial court said you are entitled for symbolic possession only.
Hmm.
High court says, yes, you have 1/8 share in the property. You are entitled for physical possession. In the meantime, what has happened is he 1/8 share of the suit schedule property. In the meantime, what happens is, Lord, I get a sale agreement from the plaintiff for that 1/8 share. Suit is filed, suit is decreed against which an appeal is pending before this court. He files the final decree proceedings for that 1/8 share, physical or symbolic, 12 years after the judgment of the appellate court, just within the period of limitation, 1 month before limitation. My lord, I file an application in the trial court for permission to, my lord, file objections. The trial court, my lord, takes my wakalat on record, but posts it for orders. Now, what will happen? I only want to bring to the notice of the court that this 1/8 share in respect of which he is asking for to be carved out is a matter in respect of which A, the matter is pending in the High Court, B, I have a decree in my favor. Now, what turns on that is, suppose it is carved out and given to him and he decides to sell it to somebody else, or he decides to encumber it.
No, what is the other suit?
The suit is for specific performance of that 1/8 share. I have produced the judgment copy of the trial court. If your lordship kindly looks at page 30.
Your suit for specific performance is decreed.
Yes.
Hmm.
Against which an appeal is pending. I am only asking for permission to file objections, my lord, that's all. Let him take my objections on record to bring this to his notice and said, please stay your hands till, because the appeal is of 2010, my lord. At any time now it will get heard.
What will the executing court do considering your obligation of objections? It will stay the proceedings till your
RFA is decided. My lord, I'm only saying to take this into account is allow me to file objections, participate in the proceedings. The day I file wakalat, he posts it for orders. I mean, once the 1/8 share is carved out, nothing else further remains, my lord.
Anyhow, you're the plaintiff in the specific performance suit.
Correct. I'm the defendant in this proceeding also.
But
this is not an impleading.
This has attained finality as far as the partition suit is concerned.
I know, but then should I not be permitted to bring on record the fact that I have a decree for specific performance in my favor, and that please you give him 1/8 share, no difficulty.
Ultimately, when you succeed in the property, when you succeed in your suit for specific performance,
Correct.
whatever you're entitled, you will get it.
I know,
that by way of an order of the court.
But in the meantime, suppose he were to encumber it or he were to enter into third party sale with respect to that.
In the appeal, you will be asking for that, or you will.
No, allow me to file objection, participate, my lord. The day I file wakalat.
I'll not stay any of the proceedings. If you want, I can issue notice.
No, but your lordship may say, don't pass fine orders at all, my lord. Your lordship may just see the other. What will happen is, then there is nothing. Just have a look at the order, my lord. Against annexure A at page.
That's what I'm asking. Assuming that a notice is given to you, what else the court will do? Give you a permission to file your objection.
That's all I'm saying. Then he can consider it and pass an order. Then I don't have any grievance at all, no, my lord. Once he considers my objection.
No, that is what a little further I'm asking.
Yes.
What order you will expect from the court?
What,
to stay the proceeding. Will the court do it?
No, what I'm saying is even if it is carved out, that whatever lordship sees, my apprehension is only this, that the decree holder, once he gets that 1/8 share, will either sell it or encumber it, thereby resulting in multiplicity of proceedings to render my specific performance decree, my lord, otious. To avoid that situation, my lord, I may ask for stay, or I may say, okay, give him 1/8 share, but to avoid, it will be subject to the decision in the appeal that is pending in the specific. I mean, I can say many things. He can consider that. Is it something?
The same order I'll pass when once they come, but.
No, I'm only asking myself this question. Is it right that I'm not even allowed to file objections and participate in? He has taken 12 years to file. Just have a look at the. I think that will probably convince your lordships. Please have a look at the FT petition at page 14. When was the judgment passed and what is he, my lord? Please look at page 17. He files 1108 of 1989, and that is decreed on 31/3/1999. Then your lordship would kindly see RFA 654 of 99, about 4 lines later, allowed in part on 31/3/2008. Now please look at the FD petition, my lord, at the last page of the FD petition at page 21. It's filed on 21/1/2020. After 12 years. I'm not saying that because he waited 12 years, you should also. I'm just saying, give me an opportunity. Whatever I have to say, don't prejudge it. He said, what is there for you? I will pass orders and you do whatever you want. You can go to, you can take this also to the High Court. That's not the way, is my respectful submission. If once orders are passed, nothing will remain then. And he has passed it, my lord. He has given it for the end of the week, my lord. Your lordship may just say, don't pass orders till that date. I'll take out notice on all the parties.
Take out notice. I'll take up this matter end of the week, before end of week.
Would your lordship say, don't precipitate at least?
I can take it on Thursday. If you can serve the notice, I'll take it up on Thursday, but I will not stay any of it because I'm not convinced.
Then may I request your lordships to allow the writ petition, permit me to file objections by Thursday?
How can I allow it without the presence of the?
No, they have nothing much. They have not. They are not saying this is a matter between me and.
Principles of natural justice require that you have to. That's why I'm saying I'll have this matter on Thursday. List it on Thursday. The petition is permitted. Take out hand summons and file a memo to that effect by
summons by the advocate representing.
Advocate representing the counsel for the respondent. If the memo is filed on by Wednesday, list the matter on Thursday.
Please.
Sir, number 51, Bhargava D. Bhatt petitioner.
Yes.
Lord, I appear for the petitioner in this case. Suit is one for recovery of money. Petition is preferred by the defendant herein, my lords. Recovery of money suit of the plaintiff is based on a promissory note. That promissory note is for a sum of 5 lakh, and it is stated that my signature is found on that, my lords. I have denied that. In that connection, I file an application to send this document so that the signature.
But the defendant in the suit.
I am the defendant in this suit.
What is the stage now?
My lords, evidence has been completed, my lords. It's going to go for arguments.
No, you're denying it. It is for the plaintiff to prove. Why do you want it to be sent to expert opinion? Why should you?
My lord, it is the only document on which the
That's
plaintiff
what you have
is relying.
denied it. The burden lies on him. Come to the impugn order.
My lord, the reasoning, my lords, will find page 19, paragraph 11 onwards. If I may read, my lords.
Yes.
On perusal of record, it reveals that during the cross-examination of DW1, deposed so and so. The above deposition shows the conduct and credibility of the defendant, who is denying her signature on her own written statement. She is not an uneducated. According to her own affidavit, she is working in the education department. Hence, the conduct of the defendant in denying her signature on written statement makes her version vexatious. Further, record reveals that the written statement.
You're denying the signature on the written statement.
My lord, that in the course of her cross-examination, she appears to have denied the signature on the written statement.
And what is admitted then?
My lord, as far as the admitted is there, my lord, there's a sale deed which is on record, which I have produced, my lord. It is annexure G in this writ petition.
Continuing with the same counsel.
Please, my lords. Please, my lords. Nothing, no action has been taken on that, but page 41 is the sale deed, my lords.
No, we'll read further.
Please. Further records reveal that the written statement has been filed before the court through a counsel. Despite denying her signature on written statement, she has not filed any criminal case against anyone for forging her signature on written statement. Further, if the signature on written statement is denied, then it implies that she has not filed written statement so far, and she has no right to lead evidence also. Well, further, the Honorable High Court of Andhra Pradesh in so and so held that the party seeking expert evidence to compare his signatures on disputed documents with admitted documents shall produce authentic documents like registered sale deed or any other registered document containing his signatures of a contemporaneous or any other period unless he specifically contends that there are no such documents. It is unsafe to obtain the signature of a party in open court and send the said signature and also his signatures on wakalat and written
Of which
statement.
year?
Right. Suit is, my lord, of the year 2022, my lords.
19.
2019, my lords. I apologize, my lords. 2019. Pleadings, evidence, everything is complete, my lord. It's at argument stage. My only grievance is this is the only document on which the plaintiff is.
Document.
The promissory note, my lord.
And what are the, I mean, that is a disputed signature.
That is the
Where is the
dispute.
admitted
My
signature?
lords, at Annexure G, my lords, will find a sale deed, which is a registered
Here,
sale
which year
deed
is the sale date?
prior to the promissory note, my lord, 2014, which has been marked as Exhibit P2.
The contemporary signatures, that is what it means.
Please, my lords, it's a contemporaneous document, my lord.
Which year is the promissory note?
Promissory note date given is 2017, my lord. Sale deed prior to the promissory note.
You deny your signature on the wakalat also,
Not on this wakalat.
before the trial court.
No, my lord, might have been a stray submission that was made. She might have gotten
That's
confused.
what it shows the conduct of your party. That's what court has
My
dismissed.
lord, that should not be a relevant consideration because this will
Certainly
go to the
relevant
root of the matter,
consideration.
my lord.
You deny everything. You deny your written signature on written statement, signature on that means there is something behind that.
We were not there, my lords. We do not know, but
Maybe the signature on the promissory note and in the written statement and all, like they are identical. That's why she doesn't want to, and that is there before the court.
my lords, in any case, that should not be considered because that is the
Any
jurisprudence.
court is competent to compare the signatures.
Yes,
It will
my
do.
lords, very well, my lords.
It will do.
Please, my lords.
Considering it.
That
I'll say that
document is there.
let the court will do it while passing the order.
My lords, my only grievance is this will go to the root. No other document is there to show that there is a financial
Why are
transaction.
you bothered? That is the burden of the plaintiff.
My lords, because otherwise I cannot give any negative proof, my lords. This might be the only
That's
thing that I
what
can
he
rely
has to
upon.
first burden lies on him.
On the plaintiff, my lord.
Yes, so he has to prove his case.
My lords, but insofar as the signature is concerned, there is nothing else that can be done, my lord.
All delay tactics that I can understand from the order and please come. Agree with the orders passed in I number 2 in OS number 135 2019 dated 17 June 2026 with the principal senior citizen JMSC Srirangapatna. The defendant is before this court. The suit is filed for recovery of money based on the fruit of a promissory note and the defendant has denied the signature and the promissory note. After the trial has completed and when the matter is posted for arguments, the present application came to be filed to send the promissory note exhibit P1 for forensic science laboratory for comparing the signature of the defendant. The trial court by order impugned had dismissed the application. While dismissing the application, the court has observed that the party seeking expert evidence to compare his signatures on disputed documents with the admitted document shall produce authentic documents like registered sale deeds or any other registered documents containing the signatures of a contemporaneous or any other period unless he specifically contends that there are no such documents. It is unsafe to obtain the signatures of a party in open court and send the said signatures and also his signatures on wakalat and written statement to an expert for obtaining his opinion. In the absence of such authentic admitted signatures, the courts are not justified in allowing such applications for seeking opinion of experts. In the present case, the defendant failed to produce any authentic admitted documents containing her signatures, whether registered or otherwise, despite it not being her case that no such documents exist. On the contrary, she has gone to the extent of denying even her signatures on written statement. Considering the conduct of defendant in denying her own signature on written statement, the court is of the opinion that the present application is only intended to drag on the proceedings. The court has observed that in the present case, the defendant has The court has observed that IA is intended to delay the proceedings and there is delay in filing the application, and could have filed an IA immediately after the case was posted for defendant's evidence. Further, no authentic admitted documents are produced for comparison, and accordingly, the court has dismissed the application. Then counsel appearing for the petitioner submits that the defendant denying her signatures on the documents cannot be a reason for the court to dismiss the application. It is submitted that it is submitted that the court has gone on a premise that as the petitioner has denied the signatures on the written statement and the applications are filed, is filed to delay the proceedings, then counsel submits that unless and until that is sent for expert opinion, that would cause lot of hardship to the plaintiff, a lot of hardship to the defendant. The suit is filed with the respondent seeking recovery of money based on a fruit of a promissory note. The defendant has denied the execution of the document. In that case, the burden lies on the plaintiff to prove the same in the peculiar facts and circumstances where the defendant is denying the signatures on the written statement. And also the court has observed that the no admitted signatures are placed before the court. The court has rightly dismissed the application. Further, while passing the orders, the court is competent to consider the signatures, to look at the signature, and also can appreciate the case of the defendant. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed. Next. Take.
Case number 2, serial number 7. Case number 2, serial number 7.
Very 10 and 11. Because I represent respondent number 11 and 12.
Yes, for petitioner.
It appears that
Surrender,
my lord's
yes.
petitioner is suffering from health issues.
That's what court officer is.
But suit is one for my lord's partition and separate possession, and also for declaration to declare that my lord's release deed executed by in my favor, my lords, that is responding number 11 and 12 as null and void. But now the parties have settled, my lords, they affirm the execution of release deed in my favor, responding number 11 and 12.
Where is that?
Petitioner is present in court, my lords. Respondent number 11 and 12 are also
Yes,
present.
Mr.
My lords, I am appearing for respondent number 2, 3, 4 and 6 to 9, my lords.
Where is the compromise?
Advocate,
Compromise petitions.
Sir, ಅದೇನ್
Take that.
advocate ಇಲ್ಲಿದ್ದಾರೆ petitioner.
Petitioner ಇದ್ದಾರೆ ಅವ್ರ advocate compromise petition. Now they affirm, my lords, the execution of release deed by receiving some additional amount, my lords. Petitioner before, my lords.
There are about 10 petitioners. There are about respondents or 12 in number.
My lords, they are, my lords, represented by power of attorney holder. He is present before.
Where is the power of attorney?
I have attached to the.
Well, generally in these kind of matters, like in compromise matters, there should be something on record, their signatures and all. It's better.
Signatures
to
are
take
there,
it
my
on the GPA.
Signatures are there, my lords.
Where is that?
GP, my lords, respondent number 2 to 10 are the persons who have signed the execution of release deed itself. Now they are, my lords, the only grievance is for the petitioner who is present before the court. He contends that, my lords, though he is the signatory.
What is the settlement entered into?
Now, my lords, kindly for a moment, my lords, may I request my lords to kindly see the release deed for a moment, which is, my lords, part of the petition itself.
The petitioner accepted monetary compensation of 22 lakhs
Yes.
as full and final settlement.
And the DD also, my lords, I have enclosed.
You already given.
Yes, checks at page 8 and 6, 7, 8 and 9.
These are all the checks.
Yes, please. Now release deed is at page 10, my lords. Release deed executed by, my lords, the family members in my favor. And for that release deed, my lords, the present petitioner before, my lords, is a signatory.
Yes, he has received, checks are received by the client
Satish.
ಎಲ್ಲಿದ್ದಾರೆ lawyer?
for 22 lakhs. Please come. The presented petition is filed. Agreed with the order passed in I number 4 invoice number 1540 of 2022 dated 10/7/2024 by the principal senior civil judge, Bangalore Rural. The petition herein has filed OS number 1540 of 2022, seeking the relief of partition and separate position and declaration and injunction other consequential reliefs. It is submitted that the respondents number, the respondents herein, that is the defendants before the court, respondents 1, 2, to whom they have given
2 to 10 my lords, to respond in number 11 my lords.
they have given
12.
Where is he?
He is present.
They have given the respondents 1 to 11 have given a GPA to 12.
1 to 10 have given GPA to 11, represented by 12.
1 to 10 has given GPA to 11 and 11 is represented by 12. It is submitted that during the pendency of this writ petition.
Are 2 to 10 my lords, not 1 to 10. 2 to 10.
Are 2 to 10. It is submitted that during the pendency of these proceedings, in view of the health condition of the petitioner, they have entered into a compromise. As per the compromise, the petitioner accepted the compensation, accepted an amount of rupees 22 lakhs. And in that regard, they've given checks. They've given 4 checks. They've written at page number 2. Write those check numbers and all. So and so. And they have and the parties are present before the court. It is submitted that, and they have undertaken to report the compromise in the pending suit, that is OS number 1540 of 2022. The same is recorded. The parties are present before the court, and the petitioner submits that he has received the amount of 22 lakhs in the light of the compromise memo that's placed before the settlement arrived at before the parties, by the parties. The writ petition is disposed of, and the settlement memo shall be part and parcel of this or part of this order. The parties shall report the same for the trial court.
Great.
Yes.
Serial number 1, serial number 52.
I am for
Yes.
Ananda Shetty.
Yes.
The sign
Plaintiff's writ petition, the impugned order is at Annexure A 16, a transfer order perpetually under section 24 of the CPC. Without there being an application, there is no reflection of mind of the court simply, and it has matters.
What is it?
Now, section 24, there was no application by either of the parties, neither the plaintiff nor the defendant has filed an application. The court has simply withdrawn the suit from one court and transferred it to another court without there being any reasons assigned in the impugned order, which is at Annexure A. And matter has been referred to mediation. The mediation report is awaited. All of a sudden, this transfer came to pass. And Annexure A, my lord, page 16. Nothing is forthcoming. May I read, my lord?
Page 16.
Page 16, Annexure A.
Yes.
In exercise of the powers vested under section 24 of the Code of Civil Procedure, so and so, pending before the principal civil judge, is hereby withdrawn and transferred to the court of first
Administrative reasons.
Pardon?
Administrative reasons.
No, but there is nothing. It's already transferred to that, my lord. There must be some reason reflect. It has been mediation report is awaited. Unnecessarily, it is an embarrassment. But
from where to where it has gone?
from
OS number pending on the file, the principal senior civil
Yes,
judge.
to the first
Udupi
edition.
is hereby.
But even administration, there is when the matter is referred to mediation and settlement is awaited. I got the order.
No, you please tell the court, what is the prejudice caused to you now? That will be in the same premises. If not this court, you will be appearing in that court.
Still, the order section 24.
Court has to understand what is the prejudice if.
No, court must, it must reflect some reason, administrative reason. If it is recited in the order, one can. No, there is
No,
some,
I'll
all
send,
of a sudden.
No, I'll send it back to the court and court will write administrative reasons and you'll be happy with that.
Because the unnecessary embarrassment.
Nothing will happen that may. That
No,
you
your
will,
lordship may say so. Because at least in future, it can't be withdrawn all of a sudden. When,
Yes.
Yes.
Please come. Agreed with the order dated 9/7/2026 by the principal district and session judge Udupi, whereby the court has transferred OS number 10 of 2025 pending before the court of principal senior civil judge and CJM Udupi and transferred it to the court of the first additional senior civil judge ACJM. Give CPC Udupi for disposal in accordance with law. The court observed that the order of transfer shall come into force with immediate effect. Further, the advocates and litigants are directed to appear before the transferee court on the next date of hearing without awaiting for any notice. Land counsel appearing for the petitioner submits that
Matter is referred to
when the matter is when the court has after the matter is referred for mediation, at that point of time, this order came to be passed. It is submitted that when none of the parties have filed an application seeking transfer, the court ought to have recorded the reasons, and without recording any reasons, the court cannot transfer the case from one court to the other court. This court has heard the learned counsel for the petitioner and peruse order. Before proceeding with the matter, it is appropriate to look at section 24 of the Code of Civil Procedure. It deals with the general powers of transfer and withdrawal as of 24(1) on the application of any of the parties and after notice to the parties and after hearing such of them as desired to be heard or of its own motion without such notice, the High Court or the District Court may at any stage transfer any suit, appeal or other proceedings pending before it for trial or disposal to any court subordinate to it and competent to try or disprove of the same, or withdraw any suit, appeal or other proceedings pending in any court subordinate to it. The order impugned shows that in exercise of the powers vested under section 24 of the Code of Civil Procedure, the court had transferred the suit. This court is not able to appreciate any of the submissions made on behalf of the petitioner. The court on its own motion can transfer the suit from one court to the other court. And even for that purpose, no notice is also required. And that is already, this order is already intimated to the parties in that view of the matter. This court find no reasons to interfere. Accordingly dismissed.
Number 53, Poonam S. Patel for petitioner. Abhishek R. Huddar, respondent.
Yes.
It's Annexure C is the impugned order. It is an order passed once rejecting my application, who is a defendant belongs, to frame an additional issue and to try that as preliminary issue. Suit is one filed by the plaintiff respondent who before lordships for partition loans of 1/3 share. I enter appearance loans, I take a specific contention that it is barred by limitation because part of the shoot real property. Shoot real property measures 3 acres, 5 guntas. 20 guntas of it would have been sold to me by their father way back in 1961. There are categorical averments to that effect in the plaint. And also since I take up that contention in the written statement, that is not framed as issue. What happens when the plaintiff leads evidence he marks certain documents. About 6 or 7 of those exhibits when we examine, it shows that the plaintiff has applied for certified copy of those in 1993. Therefore, my lords, he was aware of all this sale in my favor, and subsequent, my lords, there was other BD, earlier CITB had acquired.
What is the additional issue?
It's addition that whether preliminary issues which I have sought to frame is whether the suit is barred by.
Preliminary issue and another additional issue is.
No, lords, I had sought for framing of an issue, an additional issue, and treat that as a preliminary issue, lords.
Please
In
come to
terms,
the impugned order.
please, but Annexure C, page 37, lords, is the order. From page 43 onwards, lords, the reason is assigned by the learned trial court judgments. May I read, lords? Page 43 at the bottom, para 8, lords. On perusal of the accompanying affidavit of defendant number 11, objection of the plaintiffs and the materials on record, defendant number 7, 8, 10, and 11, that is petitioner, lords, contended that framing of additional issue as sought will assist the court in effectively adjudicating the real questions in dispute between the parties and will not cause any prejudice to the other side. And the issue of limitation goes to the root of the matter, requires to be tried as a preliminary issue. The plaintiffs have contended that the concealment suppression of material facts and procurement of documents by defendant number 7, 8, 10, and 11 from survey and land record authorities, followed by illegal attempts to elude the social property without any legal right or title, unmistakably discloses their fraudulent intent to usurp the social property, and the matter is requiring full-fledged trial. Para 9 minutes. The plaintiffs have filed the suit against the defendant seeking relief of partition and separate possession of 2/3 share over the social property. The defendant number 7, 8, 10, and 11 have filed written statement. After framing of issues, plaintiff number 3 is examined as PW1 and got marked exhibits P1 to P40. Thereafter, case is posted for cross of PW1. In the meantime, this application is filed with the defendant 7, 8, 10, and 11. The defendant number 7, 8, 10, and 11 have contended that the issue of limitation goes to the root of the case matter, which requires to be tried as preliminary issue. It is well settled that limitation is mixed question of law and facts. So the plaintiffs. No discussion, lords. One line note, it is mixed question of law and fact, and citations are not. In fact, that.
No, is it now there is no issue at all?
No issue at all, lords, in the first instance.
Limitation is framed.
Huh?
No issue of limitation is framed, my lords.
It's framed.
No, it's not framed, my lords.
Lords, your lordships will find the issues.
Why it cannot be framed?
Lords, issue of limitation can be framed, but it cannot be treated as a preliminary issue. Is some.
That's the second question.
Yes.
First question is the court has never said
Please.
that it cannot be decided, but court has dismissed their application itself. Now what we can do is will ask the court to frame that issue.
Please.
Let it not be a preliminary issue. Let it be decided as one of the issues.
I'll make one submission, lords, to persuade the court as to why in this particular facts of circumstances I satisfy order 14 rule 2 subclause 2 lords, where it has to be tried as preliminary issue. I make that attempt. If lordships may kindly permit me to read order 14 rule 2 lords before I begin on the fact.
No, there is no difficulty with that provision.
Please.
Now you have to, and basing on the facts of this case,
please.
Now you will not lead any evidence. Without that, you will be able to prove your
yes, lords, because yes, lords. As I said, lords, if I may take a lords to the plain government, lords, may I submit brief facts, lords, in nutshell. 1961, my lords, the plaintiff's father.
No, where is the plaintiff?
Plaintiff is at Annexure J, page 115.
Yes.
Yes. No, this is filed in 2021, my lords. But part of social property is sold to me way back in 1961 under the registered sale deed. Subsequently, my lords, after 1961, my lords, CITB, City Improvement Trust Board, erstwhile BDA, my lords, acquires it, my lords, in 1964. And then I apply for reconveyance, my lords, part of land is reconveyed to me. There's a dispute between that portion, my lords, between me and my sisters, which goes up till Honorable Supreme Court, my lords. Now Supreme Court has decided something on that issue, my lords. Across all these proceedings, my lords, from 1961, my lords, nothing is, the first ever attempt is made in 2017 by the plaintiffs, my lords, by going to the tribunal of the Court of Land Records, my lords, in 2017, where, my lords, he says, I'll take a lot to that document as well. There, categorical admission is made that let there be a demarcation of what belongs to me, what belongs to defendant.
We'll hear it tomorrow, not tomorrow. We'll hear it day after tomorrow in the first place.
Please.
Next.
Please.
One submission.
So in the meanwhile, my lords, the plaintiffs who are respondents are pressing for the trial court. There is no stay, my lords. Now, if that is not, they have to cooperate to that extent.
I'll hear the matter day after tomorrow. Don't press for them.
No, we are not precipitating.
No, lords, they are not making big noises there. In fact, we have been asked to report back now to trial
not
court.
Making, my lords.
Yes,
so that's my good thing.
In cooperating with them.
Yes.
It's on the same stage, preliminary.
Preliminary hearing. Preliminary hearing in the first list day after tomorrow.
That's a submission. May permit to file my objections and written arguments.
Yes. Yes.
Great.
Cell number 54, Sumana Naganan for petitioner.
Respondent has taken time to file response, my lord.
My lord, I'm not filing my response, but I'm ready for that. I'd moved a memo, my lord.
Lord, the issue.
It is ready, but my lord, as my lord said the other day, the issue is.
Who moved the memo?
I'd moved the memo. My lord, I'm sorry, my lord, it's a
Hold the
very
memo.
in detail. What happened, my lord, is that when I moved a memo, they said in detail very well. So my colleagues made it in detail. That is
So
how.
that's true. What is the urgency that I didn't
My lord,
understand?
my urgency, my lord, is that from 2000.
Where is the interim order?
My lord, in fact, he files an application before the executing court to transfer the matter from the civil court to the commercial court. That IAS rejected. When it came up before this honorable court, my lord, I fairly said, my lord, since it is being heard, I will not precipitate. So, my lord, that matter was not listed at all. Yes, that is how.
Lord, the issue with regard to the jurisdiction. Lord, an execution proceedings is initiated before the trial court. Lord, with regard to a commercial dispute. Therefore, my lord, I made a request, my lord, that the matter should be transferred to the commercial court because that's the court of jurisdiction so far as this issue is concerned. No, my lord,
No, suit is filed before which court?
my lord, the suit is filed. My lord, it actually, my lord, it's a very strange situation where, my lord, the Section 9 petition was filed for interim orders by him before the court. There, my lord, there was some kind of an arrangement that was entered into, and the Section 9 petition was disposed of, recording the, my lord, arrangement between the parties.
What is the arrangement?
Arrangement, my lord, is that, my lord, there is an agreement between the parties, Annexure A, page 25. Lord, my company was to be taken over by them, Lord, by Lord, the entire company and its operations were to be taken over. That's for a price. And there, and also, my lord, the shares had to be transferred. That, my lord, the government will, my lords would find at page 28, the second whereas paragraph. Yeah.
Yes.
Lord, this, my lord, was sought to be, I was supposed to return some money to them, and my lord, reversing the entire transaction. That was the, my lord, arrangement that was arrived at in Section 9 proceedings. Then, my lord, the issue arose as to whether what has been decided in a Section 9 proceedings, whether that's a decree or whether it could be construed as an award, or what is the nature of those proceedings, because that's an interlocutory application and not a final adjudication of any issue. Now, my lord, therefore, two aspects. One is, my lord, this issue arises out of an arbitration proceedings. And also, my lord, the underlying transaction is a commercial transaction. If that is the situation, there are judgments, my lord, of courts which have considered this aspect and come to a conclusion, my lord, as to which is the court, which is the court of competent jurisdiction to either, my lord, entertain any proceedings or even, my lord, this very issue as to whether execution is something which is also to be a part of that, because it's an execution petition or an application. All that, my lord, has been considered by courts. Now, that is the background in which, my lord, a request was made that it should be sent to the court of jurisdiction. Lord, that application was heard elaborately.
What was the execution file?
2013.
2013.
2013.
When did you file the application?
I didn't. He filed it in 2026.
26.
After 13 years.
No, 25. But
25.
Date on which application is filed on 21/11/2025.
Why the petition realized then that it should go to the commercial court?
Possibly, my lord, what happened? Why the execution has been pending?
Counsel. So that's what happened. So
Why the?
Because previous counsel was appearing, then my friend appeared, and then that application was filed.
Yes.
My lord, why there was delay, my lord, in the execution is in the meanwhile, my lord, this issue as to whether the order passed under 9, whether that would be a decree or would it be an award, or what is the nature of that order, my lord, is something with regard to which there were proceedings and matter went up to Supreme Court, my lord.
What did the Supreme Court say?
My lord, they said that it is an executable order, and that list has come to an end with that order of the Honorable Supreme Court. So the delays because of not the pendency of those.
No, why the petitioner wants it to be transferred to the commercial court?
Lord, because this court, my lord, where he has filed the execution, my lord, after the notifications of my lord, commercial court, it's a court without jurisdiction.
In the notes.
Therefore, my lord, I have sought for a transfer. Not that, my lord, it will give me any other great benefit, but my lord, it's a
If it is
court
in
of
the
non.
commercial court, the procedure will be all the more fast.
No,
which
no,
is not
it's
good
it's
for you.
quicker. It's quicker, in fact. Therefore, my lord,
Which is not good for the client.
it may not be in my favor, but still, my lord, it's not a court of competent jurisdiction. The only reason why, my lord, the court
Please
rejects
come to
my
thought.
application is, my lord, it holds that this the finding begins, my lord, at page 97, paragraph 16. It begins there, and my lord, notes the provisions of Commercial Courts Act, and my lord, the transaction between the parties. But crux of the reason, my lord, as to why it rejects it is at page 101.
Yes.
It, my lord, in the middle of the page, it's part of paragraph 18. Hence, middle of the page.
Yes.
DHR entered into a share purchase agreement dated 28/3/2008 with JDR. Thus, one thing is very clear, that the document from which the case in AA number arbitration application number 343 of 2008 arose, not due to shareholders agreement, but it was due to share purchase agreement entered into between JDR and DHR. Hence, it can be safely held that provisions of 2C12 of the Commercial Courts Act does not apply to the present case. Judgment of the Honorable High Court of Karnataka, which is on the direct point in writ petition number 2985 of 2024 in so and so, is applicable in view of the statement of provisions of 2C12, that is shareholders agreement, does not apply to this case, as the present case, as in the present case, it is not shareholders agreement, but was a share purchase agreement. So this is one finding, Lord, that misconstruction of the fact as to whether it was a shareholder agreement or a share purchase agreement. That is one. And my lord, second contention that was raised, my lord, shares have been held to be goods and transferable goods. And this transaction, even if, my lord, it is to be construed as for purchase of shares, which is goods, I am covered by, my lord, section 21C 18. And that, my lord, has not been appreciated by the trial court. These two contentions were negative, and, my lord, that has resulted in rejection of the application. Now, kindly see, my lord, the provisions of Commercial
No,
Courts
no,
Act.
before we go to that, we'll ask it.
May.
Yes.
My lord, I shall be filing some documents, my lord, because the entire crux has not been captured in the documents filed with the petitioner. My lord, just in a nutshell, I'll let to first start off.
Yes.
My lord, firstly, I would submit, my lord, that the order which sought to be executed is not an award at all. The transaction between the parties was one of purchase of shares. My lord, it is like this, my lord. These respondents wanted to buy a company. So they entered into a purchase agreement. My lord, may kindly see the annexure A at page number 1, page number 2, my lord, sorry, in the list of documents. It's a clear share purchase agreement. Now, this particular share purchase agreement, my lord, had an arbitration clause. My lord would find at page number 10.
Yes.
This issue is not in dispute. My lord, I had paid a sum of 13 crores way back in the year 2008. I had to pay some more amount, but my lord, due to certain government regulations, etc., which they claim, whatever it is, my lord, there has been a dispute between the parties. This constraint, and then, my lord, these people started, the petitioners were trying to alienate the company or transfer the share to third parties. This constrained me to file an application under section 9 of the Arbitration and Conciliation Act before the Honorable Civil Court. I get an interim order. My lord, during the pendency of that particular proceeding, my lord, the petitioner comes and files a memo and say, I am willing to return that 13 crores. Can I take my lord to page number 18? It's an order dated 1/1/2010.
Yes. Yes, we'll take it.
My lord?
Yes, he said.
Yes.
Yes.
Sri UK for petitioner present, KVM for PHR R1 to DHR, PHR R1 to R3 present, both the council paid to pass orders on the memo dated 14/12/2009. Heard both the council. In the memo, it is stated by petitioner R1 to R3 had not complied with the contractual covenants of that is the petitioners herein on 2/3/2008 regarding the purchase and transfer of shares of R1 company. They have violated terms of agreement and cancelling the same, etc. Then, my lord, I will just come directly to 19. I don't want to waste the time of this court. The learned counsel R1 to R3 has drawn my attention to clause 11 of the said agreement. As per the said clause, in case the parties of the second part fail to pay the balance consideration as per schedule of payment, then the parties of first part shall have the option to get back the shares show transferred in the name of the parties of second part to the name of the parties of first part by returning the consideration received till then without any interest on the consideration within 6 months of the date of the parties of the second part, notifying the intention of not paying the balance consideration party first part. As submitted by both the council, the above said memo filed by the council for the petitioner is construed to be a notice notifying the petitioner's intention of not paying the balance sale consideration. So we said we don't want this contract. The memo dated 14/12/2009. Hence, as per the said clause, petitioner is entitled to interest on the amount already paid 13 crores. He is only entitled, not entitled, he is only entitled for return of the said amount. KVM submits that he would return the same as per the above clause within 6 months from 14/12/2009. CUK is agreeable. So, my lord, an order is passed. It is not an arrangement. An order was specifically passed in a section 9 application that 13 crores would be returned to me within a period of 6 months. That is in the way back.
When was this order passed?
This order was passed, my lord, on 11/1/2010. And I would say, my lord, till today I have not got a single paisa from that.
No,
Then, my lord, what
no.
happened, my lord, was?
No. Coming straight to the point, according to you, this, whether it's a commercial dispute or not?
No, there is no clear commercial dispute. I'll come, my lord. That is the reason why I produce all these documents. My lord, I'll be able to finish quickly in a nutshell how it is, my lord. This was the doubt entertained by everybody because it was under the Arbitration Conciliation Act. Some people said it's an award, etc. It has gone up to the apex court twice, this very same case. And my lord, then, my lord, what happened was, I filed an application saying that it is not 13 crores, it is 15 crores. It was an error, we said. And we filed an application. My application was rejected. Instead of 13 crores, 15 crores. That happened on 22/11/2010. As against that, my lord, the operative part of that order is at page 33. It says, IA number 4 filed with the petitioner under section 151 read with section 9 of Arbitration Conciliation Act for amendment of the order of this court dated 11/1/2010 to correct 13 crores to 15 crores is dismissed. So 13 crores remains. As against that, my lord, I go before the division bench. My lord, under section 37, my lord, any order refusal or so comes before a division bench of this honorable court. Under 37. My lord, may kindly see page 37. I produced the order of the division bench of this honorable court passed on 5/9/2012. I will just take yet again, my lord, the operative part of that particular order at page 41. I was the appellant therein. They were the respondents.
Yes.
The learned counsel for the respondent number 1 to 3 submits that they have not challenged the order dated 11/1/2010. That's the original order, my lord, granting 13 crores to me. And according to him, they have to repay only 13 crores. There's a clear admission and not 15 crores. He further submits that if the appellant proves payment of difference amount of 2 crores by checks on various dates as on 23/8/2008, the respondent number 1 to 3 would be liable to pay the same. Respondent number 1 to 3 have admitted the receipt of 13 crores from the appellant. Under such circumstances, the court below is justified in directing respondent number 1 to 3 to refund 13 crores to the appellant. There's an arbitration clause in agreement between the parties. Hence, the appellant can raise a dispute with regard to disputed amount for arbitration. So, my lord, as far as 13 crores is concerned, my lord, there is no arbitration. It is only the dispute which I left. My lord, I consumer, I left it. I don't want that. Now, 13 crores. Then, my lord, he did not pay this money at all after 6 months. So, my lord, I filed this petition in 2013, execution petition. Went on, my lord, there's attachment of shares, etc. Then, my lord, he would file an application. After admitting payment, after saying admitting the contract, agreeing to pay within 6 months, he says, this is not a decree at all. Go before the arbitrator under section 31 of the Act. He says it is not at all an executable decree. My lord, the honorable trial court, my lord, the civil court rightly rejects that application and says it's an executable decree. Because, my lord, under the CPC, etc., my lord, there are some executable decrees and executable orders. Like, for example, injunction. It can be executed. So this came under that clause. And my lord, on 25/2/2014, the Honorable Civil Court, my lord, would reject this application. And the court clearly says it is held that execution petition is maintainable and decree holders entitled to recover the decreed amount shown in the execution petition by one of the more shown in 21 CPC. My petition was under 21. It was not at all under 36 of the Arbitration Act. Now, my lord, he would file an appeal before this honorable court, challenging the order of the civil court. My lord, I have produced that particular order of this honorable court, which is a detailed order, my lord, runs into many pages, which was passed on 4/2/2016 at page 61. This honorable court would consider an extensive what is a civil court, what is a civil order, what is an order, what is a suit, what is executable order, etc. And this is what, my lord, has been stated at the last page, my lord, at page number 86. Consider this, my lord, consider this decision and the principles enunciated in said decision. I am of the opinion the learned senior counsel of the respondent is right in his submission that the provisions of CPC are also made applicable to arbitration proceedings. Hence, I am of opinion that the order passed with the court below can be executed against the petitioner. However, since the undertaking given by the petitioner before the court below as well as before this court is only for the extent of 13 crores, the court can execute the order as against petitioner for recovery of 13 crores only. That's what the execution petition is now filed. So far as the claim or respondent is paid 15 crores and also entitled to interest, it has to raise a dispute with regard to 2 crores and interest, if any, in arbitration proceedings. So, my lord, there's a clear distinction. 13 crores is not arbitration and 2 crores separate. And I've given up 2 crores yet again. As against that, my lord, they would approach the Honorable Supreme Court. Page 88, my lord. Page 88 also, my lord, it is not just a refusal of SLP. My lord, it is heard in detail. Heard the learned counsel, my lord, gets at 88, my lord. Heard the learned counsel for the petitioner and peruse the relevant materials. We do not find a legal and valid ground for interference, and specially petitions are dismissed. Now, my lord, the execution continues. Then he comes, old wine in a new bottle. He files an application under section 47 of CPC. Says that it is not an executable decree. There is no decree in the eye of law. There is no crystallization of money, etc. All these things happen. Then, my lord, yet again that application is rejected at page 129. It was rejected on 16/123. My lord, all these things, the delay of this filing this application is not because it went up to apex courts and other courts, my lord. It is only because they kept on procrastinating. Now, my lord, this application also got rejected. It was rejected with a cost of rupees 10,000 at page 47. As against that, my lord, they again filed a writ petition before this honorable court. This honorable court yet again dismisses that at page 95 annexurial and imposes a cost of rupees 25,000. This honorable court, my lord, has taken into consideration everything, the attitude of the parties. My lord, whenever he comes to, he's in a situation where he's cornered, he will file such application. He just promises, shoots and scoots away. This right from the arbitration proceedings. My lord, as a result of my money, then in 2018 being stuck, I'm not able to buy raw materials. I'm almost finished. No, my lord, kindly see. This honorable court will reject this application. Then as against that, again he goes to the Honorable Supreme Court. Honorable Supreme Court, page 120, again dismisses it. Now, my lord, there's nothing much to be considered. All that has to happen is execution of what has already been adjudicated. Now, when this was happening, my lord, he comes up with an application stating that he is willing to pay back this money in 6 months once again. That he files on 10/11/26 at page 121. Sorry, sir. 26 or 25, sorry. 10/11/25. 25, no? There he says, my lord, yes, see, now the government has changed its policy. I will be able to pay, etc. He says, last page he says, I state the great hardship will cause to JDR number 1 and 2 if the application is not allowed. On the contrary, no hardship. So it's respected to honorable court may be pleased to enlarge time for payment of rupees 13 crores up to 10/10/26 interest. So the court again allows him, gives him adjournment. When this being the factual situation, he files his application stating that now it is a commercial dispute and then this matter has to be taken and before the commercial court for fresh adjudication. Now, my lord, kindly see the defense. The application has got 2 grounds. filed by them. One is that it's a commercial dispute because it is a shareholders agreement. That is what it says in his application. Second thing, he says under the definition of sale of goods that shares, stocks, etc. are also goods, and hence it's a commercial thing. My answer to both this thing is as such. My lord, kindly see the heading of this document which I produced at page number 2. It is agreement for purchase and transfer of shares of Mysore Manganese. It is an agreement for share purchase and not a shareholders agreement. A shareholders agreement, my lord, is that when all of them are having shares and they will have an agreement, okay, who will run the company? Should we get some external people who are professionals to run us? It may be a family-owned company. So they might not be very good in a business, like film industry. So they will get people. So that is an understanding between the parties, how much they share. But a share purchase is totally different. I am an outsider. I want to buy that company. So now my lord may kindly see the definitions of a commercial dispute under the Commercial Codes Act. Commercial dispute B2C means a dispute arising out of ordinary transaction of bankers. All that, my lord, he doesn't come. He says 12, next page, shareholders agreement. Then he also says that agreements for sale of goods or provision of services. Now, I would read this definition once again. It says commercial disputes means a dispute arising out of the honorable, the parliament has been very conscious by using the word means a dispute, which means it cannot trammel more than this. The definition of these 1 to 22 clauses only will be a commercial dispute, because, my lord, now we are in a commercial. There are so many business transactions which will run into crores. For probably, let us say, sale deed, a real estate transaction. It doesn't come under this. There's so many hundreds and hundreds of or vending of a huge quantity of milk, for example. It's a commercial transaction. So the parliament has been, otherwise everything will go before the commercial code. So now, in fact, the meaning of this particular word has been, my lord, can I give this letter? Sorry, my lord, without memo. My lord, we come to paragraph 23.
Yes.
Section so and so, introduced by Act so and so, means and includes, was confined to a banking company as defined under Section 5. My lord, may kindly see 1, 2, 3, 4, 8, 9th. It is tried to say that when in the definition clause given in any statute the word means is used, what follows is intended to speak exhaustively. When the word means is used in definition to borrow the words of so and so, it's a hard and fast definition, and no meaning other than that which is put in the definitions can be assigned to the same. So my friend cannot now import and say that a shareholders agreement is a share transfer agreement. It has, if the parliament wanted, they could have used even that word. When they can use 23 different categories, why not here? So, my lord, it cannot go. In fact, my lord, our High Court also had an opportunity to interpret. I'll also file it, my lord. The very same issue. A page, I'm sorry, my lord, I think my page numbers. Page number. Citation.
Yes.
My lord, sorry. My lord, the citation of which is produced in the second judgment, my lord, I think the page numbers. The second judgment of Bhaskar Naidu versus Arvind Yadav at page 41, my lord.
Yes.
sorry, my lord gets, my lord, I'm sorry. This is a judgment, my lord. Sorry.
I can see that.
My lord gets it, my lord. Yes.
Page 41 it is.
Yes, my lord, that is Bhaskar Naidu versus Arvind Yadav.
Yes.
My lord, in that particular judgment of Bhaskar Naidu versus Arvind Yadav, my lord, the same issue was taken up. My lord. I'll read this order itself. Paragraph. The plaintiff filed a suit for recovery of money on basis of agreement at 9/10/20. On the service of summons, defendant appeared through counsel and filed WS and also filed an application under Order 7 Rule 10 of CPC for return of plaint on the ground the suit is not maintainable before the commercial court since it is not a commercial dispute. By the impugned order, said application came to register. Being agreed by the same, the defendant is before the court. The learned senior counsel appearing for petition contend that the petitioner is a shareholder of the company. The respondent plaintiff is a third party. There is an agreement between petitioner and the respondent for the purpose of sale of shares belonging to the petitioner. Identical situation. The agreement dated 9/10/2010 is only a share purchase agreement and it is not a shareholder agreement. Therefore, suit is not maintainable. He further contended that as per so and so. Then, my lord, kindly see it comes as from paragraph 8. As per the law dictionary definition of shareholder agreement is under. My lord, it is defined. As per Lex Nexus, the definition of share purchase agreement is also defined. Then from the above, it is very clear that Annexure B agreement at 9/10 is a share purchase agreement and it is not a shareholder agreement. The definition of commercial dispute as per the Commercial Court Act is under. They clearly explain, my lord, what is a shareholder agreement. In view of the above discussion, the suit filed the respondent plaintiff before the commercial court is not maintainable. So, my lord, this very same issue was considered. What is the share purchase so and so, and it is not a commercial dispute. Now, my lord, they also try to say under the Sale of Goods Act, under section 2, subclause 7, shares are also goods. My lord, it could be shares are also good. But, my lord, the parliament has been conscious enough, my lord, to keep it aside. So, my lord, assuming without conceding, my lord, that it is a share good, it doesn't come under the definition of a commercial dispute, is my submission. So then, my lord, these issues were also raised before another coordinate bench of this honorable court, which have produced the very first judgment, my lord. Wherein, my lord, in a nutshell, yet again, I would say, this honorable court would say that as far as the disputes are concerned, in executing court, all that is just is to execute a decree, nothing to be decided. Because, my lord, the very objective of enacting of the Commercial Courts Act is for quick disposal of cases. And these cases like this, 13, 14, 18 years, my lord, it keeps going on, it will clog the system. And, my lord, there's nothing to be adjudicated, and more so in also that it's not a commercial dispute, my lord, it had to continue there, is my submission. It's a detailed judgment, my lord, every issue has been taken. Now, my lord, there's another judgment of this coordinate bench of this honorable court, which my learned friend had relied upon the trial court, wherein, my lord, something else is stated. What there again, my lord, there's a distinction which says an application under section 21 is not an application as defined under section 15 and 21. However, execution of arbitral awards under 36 is permitted, means in a commercial court. I also concede to that, my lord. But my submission as showed earlier, this is not an award. It is an order of a civil code. Had it been an award which starts off from section 31, etc., my lord, in fact, section 31 of the Arbitration and Conciliation Act is very straight, my lord. Section 31 of the Arbitration and 31 of the Arbitration and Conciliation Act, it says the form and contents of an arbitration award. So when an arbitration award is passed and when the time given for appeal under section 34 is expired, then, my lord, under 36 it can be executed like a decree, means it's a legal fiction only. It is not a decree for any purposes. It is just an application which is sought to be executed because it's an award, because there should be some mechanism. So that's the only reason, like the originally Consumer Protection Act also we used to execute before the civil court. So, my lord, if it is only under section 36 and if it is an award passed to an arbitrator, then, my lord, if it's a commercial dispute, then only a commercial court would have jurisdiction. It had to be transferred. Mine doesn't come under any of these clauses. It is not a commercial dispute. It is not one passed by an arbitrator. It is not an award. It is not filed under section 36 to execute. I only filed an order 21, which has also seen its journey up to Supreme Court and said it's an executable order under 21. Now, my lord, nothing remains. I would submit before this honorable court, my lord, is that these are just a process, my lord, done by these parties just to harass and vex me and to delay me of my 13 odd crores, which has been pending, my lord. In fact, while I even consider that I will not take interest. Others should have been 25 crores by now. So even if he gives it to me after 100 years, I'll only have 13 crores.
Yes.
And my lord is also aware of the dictum of the Honorable Supreme Court, my lord, latest, which says that execution petitions should not even be stayed. It should just be allowed to go.
Yes.
Lord, there has been, my lord, protracted litigation, no dispute about that aspect. Both parties have been litigation resourceful, my lord, and they have taken their chances before various fora. Lord, whatever the background situation may be, Lord, the question of jurisdiction, my lord, is an issue which, Lord, is independent of itself. And my lord, I have raised it by raising specific contention with regard to, my lord, the court which is supposed to execute the decree. Now, my lord, his case now, my lord, is that this is not a shareholders agreement, and therefore it will be out of the definition of commercial dispute. Now, my lord, the basis on which this the coordinate bench, my lord, has considered the case of shareholders agreement and dispute is as to what would be the control of the company and what is the underlying transaction. That is the reason, my lord, I was trying to point out from the agreement itself, which was the basic document, as to what the transaction here really was. Lord, if we see the document, my lord, under which the transaction has taken place, which is at page 25 of my writ petition, Annexure A.
He has filed now.
He has also filed, my lord. I don't.
Yes, I have filed.
Page number.
Page number 2.
Yes. In that document, my lord, it will be.
Anyhow, we'll take it from the book. From
I'll just point out, not from.
Yes, 25.
I've filed the signed one. I think he has filed the unsigned document. So there's some change in the pagination and how.
I'm looking at page 25.
25 minutes. This is the contract.
Yes.
Lord, kindly, Lord, see clause at page 27. The last clause, unnumbered clause, and whereas the parties to the first part as shareholders of the company was inducted into the board, and they have been managing the administering the affairs of the company as 100% shareholders of the company without any claim from any other individual. And whereas in the course of conducting the business of the company had already acquired 3 mining leases which were subsisting with the Department of Mines and Geology and state government, which are more fully set out in Schedule A, and for short hereinafter referred to as A Schedule mining leases. The underlying transaction, my lord, is that these mining leases, my lord, which are in the company's name, they have to get transferred, my lord, to the person who controls the company, because lease cannot be transferred as such from one individual to another individual, my lord. It's only with government's approval that it could be done. Therefore, my lord, the transaction is to take over those mines by taking over the company which has those leases. Over the page, third clause. And whereas the parties to the first part, on account of various other business commitments to be concentrated, had decided to hand over the management and administration of the company by transferring of the entire 100% share to the third parties for considered value. And they made the following representation to the parties of the second part and offered transfer of the right, title, and interest in the share of the company, which as of now, 9,980 shares, which are more fully set out in C schedule. that parties of the first part hereby represent to the previous shareholders who are having 100% shares in their custody and possession without creating charge on these shares. Further, they represent that those individual shareholders transferred 100% shares in favor of parties of the first part for a valuable consideration with all rights to own and possess the company and its business. That by share transfer agreement and by signing necessary transfer applications, they transfer all 100% shares of the said company in favor of parties of the first part on receiving the entire consideration on value of the shares of the said company. The board of directors of the company pass a resolution of transferring 90 shares held by them in favor of the parties to the second part, after which they become owners of the company. That after the transfer of the shares in favor of parties to the first part, they have, in order augment the business, they increase the authorized share capital and not other covenants. Then, my lord, the paragraph page 30, modalities of transfer is mentioned, and continuation of various issues, litigation, etc. by these people, not persons who enter.
No, I
That is
think
at
we
page
don't have to go
35.
further into this.
Pardon me, Lord.
We don't have to go, I mean, each and
No,
every
I'm only
comment, we
trying
don't
to
have to see that.
Correct, Lord. I'm only trying to point out, my Lord, the entire case seems to be now that it is it's a not a shareholders agreement, and therefore it will not be part of commercial dispute. That seems to be the contention that is raised. Now, my Lord, whatever the nomenclature of the agreement may be, this agreement, my Lord, the nomenclature is that agreement for purchase and transfer of shares of so and so company. Purchase and transfer of shares. And the contract provides modalities of how transfer will happen, how transfer of, my Lord, my Lord, management of the company will happen. All those are provided for. And the underlying transaction is with regard to mining. Those schedules are there at page 40 onwards. Therefore, Lord, the underlying transaction was definitely a commercial transaction with regard to a company which deals with mining lease. And, my Lord, they wanted to take over the management of the company by taking over shares, my Lord, in terms of the contract that has been entered into. Now, my Lord, as he rightly pointed out, there is an order which neither is an award nor a judgment or a decree, my Lord. Some order which is passed under section 9. And now, my Lord, it has been decided, my Lord, by after contest that it is something which is enforceable. Now, my Lord, therefore, the only question is as to which is the forum where it could be enforced. Now, my Lord, in this context, there are judgments of various courts, my Lord, which have considered, including this coordinate bench of.
Point out the paragraph numbers, I'll look into it.
Yes, my Lord, I'll just point out those paragraph numbers.
And give it to the court officer. Now, we don't have to look into all that. Whatever you're relying on, that your written arguments you can give, both of you.
Lord, then, my Lord, kindly have it tomorrow. We'll file a short synopsis of submission.
Give it to the court officer. You can give it to the court officer, pass it on.
We'll
I
do that.
understood. What is the compass of this litigation?
Lord, two aspects to this. One is, my Lord,
And
what
one
happens
more
to.
aspect also on the costs to the petitioner. Either way, result may be either ways. How the matter has been prolonged and about the conduct of the party, what do you submit on that? Because that also I'll be considering it while considering the merits of the matter.
Yes, my Lord. My submission, my Lord, is I have raised a question of, my Lord, jurisdiction as a question of law. And, my Lord, there are judgments of this honorable court with regard to, my Lord, if there is an order of a civil court, the specific contention, my Lord, as to whether it is the civil, whether it will be the civil court which will execute it, or should it go to the commercial court, is something which has been considered in some of these judgments. Lord, they have held that, my Lord, execution petition is also to be construed as an application which is contemplated under the notification, and therefore it is something which has to be executed by the executing commercial court and not the civil court. I am basing this entire contention, my Lord, on the basis of, my Lord, provisions of the Commercial Courts Act, which
What
has
is
been
to be
introduced.
decided now? You have at least earlier under section 9 petition, before the courts about 2 times, you have accepted that you will pay the money. What is the executing court going to decide now?
Lord, before executing court, my lord, either I have to deposit that money, or my lord, he has already taken recourse to attachment of certain shares and other properties. My lord, valuation of those and how, my lord, what property has to be auctioned in what sequence, what will be the value, all these will be the, my lord, the court will look at.
Having
That
undertaken
entire
before the
exercise.
Having undertaken before the courts those
Lord,
many
if-
times, why
Lord,
you are not honoring the order?
Lord, the whole problem arose because of, my lord, ban on mining. Lord, while this transaction, my lord, was done in right earnest, because of ban on mining, my lord, which affected the entire country, my lord, this transaction also has gotten into serious trouble. And my lord, both of us possibly are in deep financial trouble because of my entire business, my lord, being completely shut down, my lord, almost overnight. And we were not able to do any, my lord, all the advances given, material which was there in, my lord, various
And
ports,
very
etc.
significant factor in this is no interest.
Yes, my lord, that was what was agreed.
Yes.
Yes. That was because, my lord,
we thought
it
we'll
was
get in
avoided
6 months' time.
litigation.
That's the reason. We thought we'll get it in 6 months' time.
We hope, my lord, so many things will happen. Sometimes they don't turn out like, my lord, because, my lord, this was supposed to be undone, and then, my lord, those mines were supposed to be, my lord, activated. But then the whole thing, my lord, has gone into a spin. The report of, my lord,
Petitioner wants to buy some more time.
Lord, Lord, I'm in a situation where, my lord, I was not able to deposit. He's, my lord, having a security for this amount. My lord, he has to ultimately, my lord, if I'm not able to deposit, ultimately, my lord, and various schedules, my lord, which he has given. Now, to answer my lord's question as to what the executing court has to do, executing court has to, my lord, see the valuation of those assets which he files, and then, my lord, decide as to which is the sequence in which those assets will be sold and how much will be recovered and how, my lord, it will be put into action. Those actions have to be taken. I only pointed out, my lord, that this court may not have jurisdiction because I'm covered by various judgments of this honorable court and various courts which have gone into this issue. Very same issue as to whether a commercial court should decide an execution because the order was passed by a civil court, or should it also get transferred is something which is covered, my lord, by various first.
Mentioning the paragraphs and all, please, both of you submit your written submission.
In his own judgment, my lord,
No, written submissions, written submissions. Yes, heard, reserved. Give it to the court officer.
Lord, kindly post it, my lord, on some day. We will only point out, my lord, we will not take more than 10 minutes instead of reserving it. My lord, we'll leave the synopsis earlier and will not take more than 15 minutes or 10 minutes.
Already today, 1 hour, it's already taken.
Will not take more time, my lord, someday.
You know that our court will go through. Why do you want?
We will have the satisfaction of showing those paragraphs, my lord, at least.
Because court will read, that you will see in the order.
That's true.
Whether the court has gone through that or not.
Some 10 minutes, my lord, someday. Will not take more than 10 minutes. At least I will not.
That 10 minutes is a big thing.
Even at the end of the day, my lord.
End of the day, this is like this.
Someday, any day.
Because he has urgency and I can't accommodate immediately. Tomorrow itself, this is matter. I'll not grant more than 10 minutes. 5
Right.
minutes to you and 5 minutes to him.
Right.
Yes. Tomorrow.
Right.
And the 230 matter that, call that
230
matter.
matter. Cell number 106. Sampatya, petitioner.
Petitioner.
Yes, what is urgent?
This matter, my lord, the defend.
Who has mentioned? You mentioned or you mentioned?
It's my application, my lords, for vacating this stay. This is in respect of the matter registered on 15th of July, where suit was for clubbing of the suit was sought to be ordered, my lords.
Lordship has heard this
This is in
matter
respect-
sometime and my lord posted today.
last occasion regarding the
Now,
clubbing.
what is the urgency? I'm saying that I
So
should
the
take it up
urgency
at
is that the suit
2:30.
is stayed, my lords.
Huh?
The entire suit of the plaintiff is stayed for recovery of money for 1.44 crores, my lord. And the suit is not progressing. He's been extensively cross-examined, recalled, at which stage.
When was the interim order granted?
It was granted on
There shall be an interim stay as prayed for.
21/11/20.
What is the issue?
Let's this matter, Mullah Lordship has heard last occasion. Defend number one is the writ petition. Petitioner is the defend number one. Now the petitioner also filed a suit, Mullards, against the respondents. After 2 years, Mullards, he filed another suit arising out of the same issue. Mullard, he comes and says, Mullards, my suit, Mullard, Lordship find it.
What is IA?
Mullards, it's a
Present
memo
IA.
filed to club the suit, which was filed pending before the same court. Same precedent.
Tell me what are the suit numbers?
Mullards, the suit, Mullards, filed by the petitioner is Mullard, OS number 477 of 2017.
Seeking?
Is a OS number 488 of 2019.
OS 488.
488 of 2018. Sorry, 19. Is the second suit.
What is the first suit?
Well, that's 477 of 2007.
What is a relief sought?
Well, see, relief sought is a declaration
Ah.
to declare that, my lord, the petitioner's plaintiff is entitled for the shares as per the agreement.
Yes. What is the next suit?
The next suit filed by him, my lord, for recovery of amount.
Yes.
Please.
By him.
By him, my lord. We have to pay.
OS number 4.
88 of 2019.
And what is the purpose of getting the suit stayed
It's
for
against,
2 years?
It was not reached, my lord. Many times it has come. Well, it's on the same transaction, well, 2 suits are filed. It's so it's before same court. Parties are same.
Yes. Yes.
If I may submit, my lords, the first suit is not for declaration, it's for partition as well, my lords. The entire transaction that they claim is arising out of an alleged agreement of 3/5/2016, my lords. The brief facts is that in OS 477 of 2017, my lords, the suit that is filed by petitioner number 1, the plaint can be seen at page number 42, my lords. The cause of action, my lords, is said to have arisen out of sale deed of 2/5/2016 as well as 3/5/2016 agreements, my lord.
Yes. The plaintiff submits that dated 3/5/2026. Which suit is this?
We have 477 of 2017.
And then for the other suit?
The other one, my lords, is for recovery of money at page 22. The prayer can.
I remember this.
Please, ma'am.
Yes, I remember
Please,
this.
my
now.
lord, this
Please,
is.
that matter, my lords. The transaction he says, my lord, the amount paid is for some other transaction. Lords, I verified the project he says, my lord, for Honenalli project. My lord, that was the project started in the 2013, my lords. And the amount he now says they are transferred to him. My lord, for that project, for that joint development agreement, my lord, the parties were not, my lord. Yes, transferred to the 4 persons. Document, my lords, only for 2 plaintiffs, my lord, he is transferred the amount. Lord, that project, my lord, I have the agreement, my lord. It is in the 2013. Just to overcome, my lord, the transaction amount says, my lord, though, my lord, the transaction he initially stated that, my lord, the project we are all, my lord, connected to the one project that is at Belgumbai village. Now, my lord, to defeat my suit, he comes and says the amount is transferred to the some other project. My lord, that project, my lords, may just tender the document. It started in the 2013. My lord. So nowhere connected. Just to overcome the proceedings, my lord, overcome the to defeat this. My lord, such a contention that, my lord, he has paid the amount. My lord, he has not even stated in
Who are
my
the
suit.
parties to the first suit?
My lord, the first suit, my lord, the petition number 1 and 3 others. My lord, sir, respond number 1 is the
The red as?
he is a defendant number 1.
And then the next in his suit?
Well, he is the plaintiff.
Who are the defendants?
Well, who are defendant is I and my wife, and my other parties have also been. Who are the parties in the same suit?
What is the stage in this voice number 477?
Well, 477 now, my lord. It was stayed, my lordship, extra that Friday lordship pronounced one judgment on the stamp duty.
Hmm.
So now it has resumed. My lord.
Trial has not yet commenced, my lords. If I may just assist the court. In 477, trial has not yet commenced. Whereas in OS 488 of 2019, plaintiff was completely cross-examined on more than 15 occasions. He was discharged, posted for defendant's evidence. During the course of defendant's evidence, again application for recall was filed and the plaintiff was resummoned for cross-examination. At which
Come
stage,
to the order, let's see.
please, my lords.
May just take 2 paragraphs on the both plaint, my lord, so that it will.
I have already seen on the last occasion. Now I remember. That's what I'm
Please,
saying.
my lord.
Yes. Come to the order, impugned.
Let's order lordship and it
17, my
annexure.
lords.
Page 17, my lord, para 7, 4 lines, my lord, bottom. In this regard, page 19, sorry, 19, para 7.
This is written statement.
Written statement, my lord.
Page 19 is written statement.
Let's see.
Yes.
Para 7. 4 lines from the bottom.
Yes.
In this regard, I have perused the plaintiff and written statement. From reading the same, what I have gathered is that the parties of both suits, which are sought to be consolidated, are one and the same. Now, next aspect which needs to be taken into account is whether
Are you
this
reading para number?
plus para 7 bullets, bottom 4 lines.
Yes.
In this regard, it starts 4 lines bottom.
Para 7 starts with first of all.
First of all,
Yes.
well, first of all, Muller, it instead of application memo was filed, Muller. That's said instead of my I'll read that. First of all, in this case, no application under aforesaid provision is filed. Rather, a memo is filed for that purpose. Since the plaintiff has opposed this memo, it seems that is not agreeable for such a course. Be that as it may, let me see whether by exercising the inherent power suo motu, the suits can be clubbed together or not. In this regard, I have perused the plaintiff and written statements. From reading the same, what I gathered is that the parties to both suits which are sought to be consolidated are one and the same. Now, the next aspect which needs to be taken into account is whether the subject matters of these suits are also one and the same. As I said earlier, the subject matter of the present suit is money, that is a sum of rupees so and so. Whereas, as could be seen from the judgment passed in RSA so and so, the subject matters of the suit in OS number 47717 are landed properties so and so. Thus, it is a crystal clear that the subject matters of both suits are not identical. Not only that, even the reliefs claimed in the both suits are different. This is one thing which has to be countenanced. Apart from the above, it is worthy to be noted that having set aside the judgment and decree passed in OS 47717, the Honorable High Court has remanded the matter for fresh disposal from the stage where it has from the stage where it was before passing the impugned order, and has directed this court to dispose it of within outer limit of 1 year from the date of receipt of the certified copy of the judge. When such being the case, this court has to make all endeavor to comply with the direction of the Honorable High Court and dispose of that suit as early as possible. Having regard to this factual scenario, I am of the view that if these two suits are clubbed together, definitely the consolidation will deal.
Yes.
Well, it's subject land melody. I'm based on the agreement. I say, Mulad, there is a profit. I'm entitled. Please declare. Has he written the agreement? I'm entitled for this share. Mulad, it is my case. Mulad, all of us are jointly invested. Mulad, he comes and says for joint investment. It is not a joint investment. It is a brokerage for Mulad, having the sale deed in his favor. But so that he comes and say, I paid this amount. I want this amount to be repaid. And now Muller, to overcome my suit regarding that landed property, he says this amount I given it for the plaintiff defendants for the purpose of the project at Hondenalli, which was started in 2013, where he was nowhere connected. But he also in his suit, Muller, he also transferred some amount to the one of the defendant. He was not even a party to that agreement. Just to overcome my suit. But the reliefs are different. Parties are same, issues are same. Pleadings also similar to that. He also start with the saying that he owns this property from so and so. It is also my case that he owns the property, wherein all of us are jointly invested and got the property in his name with an intention to convert it, sell it. Out of the sale proceeds, will have the share. But he did not do it, though he has executed agreement. I filed the suit as per this agreement. Give me the share.
Let's file the suit for recovery of money basing on what?
He says for a project, he rendered the financial assistance. He says that project is a Hondenalli project. He did not say what is
it connected with your case?
Not my
Your case is
please.
You have contributed and sale deed is in his favor.
Plus, he also contributed. I also contributed.
That's what all of you have contributed, as he's eligible to take have the sale deed. Sale deed is on his name. And you say that as per your agreement between the parties, so and so should be allotted to so and so land. If they can't allot the land, he'll give the money.
Please.
That is your cause of action. His cause of action is entirely different.
He now comes and says, for that all joint contribution, there is a money transacted between all of us. He has also transferred some amount to my account.
No, no, according to you, there is no transfer from him to you. It is only you to him.
No, my lords, he also transfers, that is his case, my lord. His amount is transferred to me. My lords, my case is for a development. He says, no, I rendered financial assistance. That's his case, my lord. The amount are transferred to me and other defendants and also to my wife account for the purpose of development, my lord. I developed the property.
Which property?
My lord, that Belagumbe property, my lords.
That is the agreement in respect
Please,
in
that is-
respect of which he has a sale deed.
He has a sale deed.
Is it correct?
Please, my
I
lord.
have disputed that fact in my pleadings.
No, no, that sale deed is the same. that
Sale deeds, what I have stated, my lord, the contribution that I have made is toward a different project. That is what I have pleaded in my plaint at para 6.
Sale deed is the same. Contention is that sale deed is I've got my own property out of my own income. That's a matter of dispute.
Sale deed is referring to what you are referring and he is
So one
referring is
sale
one and
deed,
the
my
same.
lord.
Same.
It's only one sale deed. According to them, there's an alleged agreement which I have vehemently disputed of 3-5, my lord. Sale deed of 2-5, my lords.
Yes.
Kindly see, my lords, one crucial fact, if I may continue, my lords. The issues have already been framed. I have filed the issues along with my statement of objections, my lords. Kindly see issue and OS 477/2017 in the suit of the plaintiff, my lord, at page 138. There are almost 9 issues, my lord. An additional issue of 1 and 2 has been framed. The entire gamut of the suit. Statement of objections, page 138, annexure R11, my
Yes.
lords. The entire gamut, my lord, revolves around 2-5 and 3-5 agreement. Kindly note these are the cause of action which the petitioner has pleaded, my lords. Not a single whisper about 12-12, that is after 6 months is when I transfer. On the other hand, my lord, kindly see the
Please
issues.
show me the issues in 488.
Please, my lord, page 142. Annexure
Yes.
R12, my lords. There's only one issue on 1.44 crores. And that plea, my lords, substantially arises out of paragraph 6 of my plaint, my lord, where I categorically state.
No, with
money-
this, what will you prove?
Lords, I will,
Issues.
please, I have to prove that the amount what he has transferred to me, it is for the development. For the
Where are
develop,
the issues in that regard?
let's, the objections, my lord, I'm not.
142. No issues.
I already served it. I'll give my.
But the, my lords, it is his claim that my lord, issues are not framed as to my contention. But my lord, he says my lord, he is entitled for that so that 1.44 crores.
Yes. Dismissed. Will go. Pass order. Huh? No, anyway, that is not the issue before this court. That will be all of you get it decided before the trial court. Yes.
There are few citations, if I may part to this court. I
233 matter.
have few citations which I may part to this honorable court, my lords.
Give it to the court officer. Yes.
Grateful.
I'll write the paragraphs and I'll part.
Matter. Mohan Mahabalesh but for petitioner.
What is this no you called? What is the matter that you called now? 230 matter. It's only one matter. Yes.
My lord, sir, in 2005, I was permitted to shift my license from my predecessor's license from X place to the present place by virtue of an order passed by the Deputy Commissioner of Excise, the second respondent. From 2005, my lords, 2013, I run the business there. But subsequently, the license came to be transferred in my name from my predecessor in interest.
Yes.
Lords, 2012, the government passes an order at Annexure E, my lord. The translated copy is at Annexure. I'll say in nutshell, what 2012 government order says, my lord. Whenever in this palace ground, you conducted temporary gatherings or a programs or conglomeration of the persons or any performance, don't sell intoxicating, don't allow the sale of intoxicating substances. That comes in 2012. That is specifically for temporary occasions, not like a marriage or my lord, party, something where my lord, Occasional licenses are granted by the government for 1 day. So therefore, the government said, don't grant those licenses. Now what they do is, they say, in 2012, this government order came, therefore you shift your license. I say 2012 does not apply to me, because what it says is, in the event you are granting permission for conducting temporary programs, in such programs, liquor or intoxicating substances should not be sold. But all right, they directed me to shift the license, my lord, and the appeal was filed, and then my lord, litigation went on. Ultimately, my lord, when the appeal was pending before the Karnataka Appellate Tribunal, was kindly see annexure N1 and N2.
First of all, come to the appellate tribunal's order. Let me understand what it is.
My lord, now Appellate Tribunal says in 2005.
Come to the order. Let me
Please.
read that. Where is the order?
That is in Kannada, my lord, unfortunately.
You have to, then you have to.
I've translated it. I've translated it.
Where is it?
My lord, kindly come to 126 reasons.
Yes.
The relevant para is page, para 10, my lords. Para 10, at page 127.
On 19/5/2004, Maharani Meenakshi Devi issued a no NOC certificate to Syed Hafiz Ali, that is the petitioner, permitting liquor to be served along with the food in the bar and restaurant attached to the Princess Academy of Equitation. Subsequently, on 21/9/2004, she addressed a letter to the Principal Secretary, Department of Personal and Administrative Reforms, informing that the permission granted on 14/6/2004 for sale of liquor in the refreshment center has been cancelled. However, while issuing the transfer order on 2/4/2005, my lord, this letter was subsequent to shifting of my license. From 2005, my lord, though this letter was there, till 2013, no action was taken against me. Cancellation of the NOC and proceeded with the order making illegal unsustainable. Before issuing the transfer order, the Additional Commissioner of Excise relied upon the opinion of the senior advocate and former Advocate General. The order records that the Maharani Meenakshi Devi had issued no objection certificate. However, it simultaneously acknowledges that the matter relating to the property was pending before the Honorable Supreme Court between Meenakshi Devi and the Government of Karnataka, and that the transfer would remain subject to the final decision with liberty to withdraw the order if dispute arose. Despite this, the Additional Commissioner failed to obtain the government's opinion before issuing the order.
Who gave you license to run this?
My lord, it was a Deputy Commissioner of Excise who, under Rule 23, permits the shifting of license, my lord, on one place.
No. Initially, license was granted to you by whom?
License will be granted by the Deputy Commissioner, my lord.
In your case, I'm asking.
Yes, in my case.
When was it granted?
My lord, it was granted sometimes in 2000. It was in different place, my lord. Under Rule 23, my lord, the licenses can be shifted from one place to another. Likewise, from earlier premises, as per Annexure A, I came to this particular premises in 2005. Till 2013, no objection, nothing. I was running a business. So, the first order came in 2013.
Yes.
No, my lord, our only contention was that, my lord, you cannot give a retrospective effect to a government order because I have already shifted that I am operating. Now, by virtue of dismissal of this appeal, no, there is a threat of closure of the shop now. Now, further, the Karnataka Appellate Tribunal, my lord, Additional Commissioner does not come into picture at all because, my lord, the shifting order is made by the Deputy Commissioner of Excise under Rule 23. No commissioner, no additional, nobody is involved in this. It is purely the jurisdiction of the Deputy Commissioner of Excise. He permitted the shifting in 2005 under his orders.
No, they cannot ask you to shift the license from shift the shop.
Well, there are so many reasons for which they can shift. But solely because, my lord, this government order they cannot. Because this applies to temporary licenses. And, my lord, 2023, 24, 26, they have granted temporary license to a different premises. Kindly look into Annexure N, my lord. During the pendency of the appeal, they granted temporary license.
My lords, the order which is referred by my friend, that is 24/11/2012. This was introduced in pursuance to the Supreme Court judgment, my lords. Madam. So the condition number 10 and condition number 11 was imposed, my lords. That is, no commercial or business activity shall be carried out. And the condition number 11, no intoxicants things or intoxicants drinking shall be used or sold.
Yes.
So in pursuant to that order, we have introduced this condition, my lord. Because of the status quo which has been maintained in this, we have introduced this.
Let's kindly look at Annex N, my lord. They say
What is happening now?
Now he himself has given an undertaking, my lords. One second. I'll give you the copy, sir. One second.
So this is what your instructions are. Status quo, we have given permission.
Yes, my lord.
And what is the next paper you are?
My lords, he himself has given an undertaking that he'll abide by the KAT orders, my lords, for shifting the shop.
When was
Subject
that?
to outcome. Lords, this was given on 17th June 2017.
That was not KAT, appeal was pending before the KAT, so therefore I will abide by the order. My lord, am I not entitled to challenge that order? My lord?
Yes.
My lord, now writ petition is before my lord. My lord's grant come order.
Yes.
That's all, members.
The petition is before this court. Agreed with the order dated 3/7/2026. Land Council for the petition has raised several grounds. AGA takes notice on behalf of the respondent. He shall file objections. And the pending disposal of this writ petition, the respondent shall not take any coercive steps.
Obliged.
This is matter on 15th of September.
Please, brief.
Yes.
My lord, serial number 91 bola.
All the matters shall come in the first list. This one matter.
Serial number 61, my lord had directed it to be listed today as the first matter in the list. I don't know, my lord, though the order also says it should be listed as the first matter, it was listed at 61. My lord.
We know it will continue from that.
Serial
It's
number
in B
70.
group.
List number 2, serial number 20.
List 1, serial number 91.
I have instructed the court officer, all the matters, please.
Restoration of the power connection.
64. In
All the
91,
matters should come, continue in the first list.
76, 3 more has to be extended.
Madam, continue. ನಾಳೆ ಬರುತ್ತೆ.
Continue ಆಗುತ್ತೆ. Madam.
Madam, court officer, madam. Madam.
Court officer? Court officer? ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ಮೋಸ್ಟ್ಲಿ. Court officer? I think she has muted, sir. ಹೌದು ಹೌದು. Court officer? Madam? Court officer? Court officer? Court officer? Court officer, madam? Court officer.
ಹಲೋ ಹೇಳಿ ಸರ್.
97 serial number 97.
ಎಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ.
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್. ನಾನು ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿ ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಅವರು ಮೇಡಮ್ ಹತ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತರಕ್ ಹೋಗಿದ್ದಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್. ವೇಟ್ ಮಾಡಿ ಹಂಗಾರೆ.
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಸರ್, ಸ್ವಲ್ಪ
ಕೋರ್ಟ್
ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಆಫೀಸರ್ ಇದ್ದಾರೆ, ಮೇಡಮ್ ಹತ್ರ ಹೋಗಿದ್ದಾರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತರಕ್ಕೆ.
Sir, when will the matters in first list be posted? Tomorrow? Tomorrow. Okay. Okay. Thank you.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬರೋದಿಲ್ಲ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ, ವೇಟ್ ಮಾಡಿ.
ಹಲೋ ಸರ್ ಹೇಳಿ, ಏನಾದ್ರು ಬೇಕಿತ್ತು? ಏನಿಲ್ವಾ ಸರ್? ಹೇಳಿ, ನಿಮ್ದು ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಹೇಳಿ ಸರ್. ಅದ್ ನಾಳೆಗೆ ನಿಮ್ದೊಂದು ಒಂದ್ ನಿಮಿಷ ಸರ್. ಹ್ಞೂ ಆಯ್ತು, ಅದ್ ನೋಡು, ಅದೊಂದು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಳಪ್ಪ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಅದು ಕೇಳ್ಬಿಡು, 230 ಮಾಡ್ತೀನಿ, 230 ಹಾಕ್ತೀವಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಏನಿಲ್ಲ, ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಲಾಸ್ಟ್ ವೀಕ್ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿ ರಿಕ್ವೆಸ್ಟ್
ಸರ್
ಮಾಡಿ
ಅದು
ಪೋಸ್ಟ್ ಮಾಡಿ.
ಅದೇ ಸರ್, ಅದಕ್ಕೆ ಅದು 17/8 ಮೇಡಮ್ ಡೇಟ್ ಅಸೈನ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ 18/8 36
36 18/8 ಬೇಡ ಮೇಡಮ್, ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನನಗೆ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಅಲ್ಲಲ್ಲ ಸರ್, ಆ ಥರ ಇಲ್ಲ, ನಮ್ಮ ಮೇಡಮೇ ಅದು ಫೈನಲೈಸ್ ಮಾಡಿರೋದು. ನಿಮ್ಗೆ ಇನ್ನೂ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಒಂದೇನಾದ್ರು ಬರ್ಕೊಟ್ಬಿಡಿ ಮೆಮೋ, ನಾವು ಕಳಿಸ್ತೀವಿ ಡೀಟೇಲ್ ಬರ್ದ್ಬಿಟ್ಟು. ಈ ತರ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ನಾಟ್ ರೀಚ್ಡ್, 18/8 ಡೇಟ್ ಅಸೈನ್ ಆಗಿದೆ ಅಂತ.
ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಡೇಟ್, ಯಾಕಂದ್ರೆ ಚೇಂಜ್ ಆದ್ರೆ
ನಮ್ಗೆ ನಿಮ್ಗಿಂತ ಮುಂಚಿನ ಕೇಸಲ್ಲಿ ಆಲ್ರೆಡಿ ಡೇಟ್ಸ್ ಅಸೈನ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ನಿಮ್ಗಿಂತ ಮುಂಚಿನ ಡೇಟ್ಗಳು ಬೋರ್ಡ್ ಫಿಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ ಮೆಮೋ ಕೊಟ್ಟು.
ಸರಿ ಮೇಡಮ್, ಯಾಕೆಂದ್ರೆ ಏನಾದ್ರು ಚೇಂಜ್ ಗಿಂಜ್ ಆದ್ರೆ ಸಿಟ್ಟಿಂಗ್
ಅದು 18/8 ಕೊಟ್ಟಿದ್ದೆ ತುಂಬಾ ಇದು, ಯಾಕೆಂದ್ರೆ ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಎಲ್ಲ. 15 ಸೆಪ್ಟೆಂಬರ್ ಆದ್ಮೇಲೆ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿರೋದು. ಈ ತರ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಅದು ಮೆಮೋ CH ಮೂಡ್ ಅಂತ ಇದ್ದಿದ್ರಿಂದ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಮೇಡಮ್.
ಹೌದಾ? ತುಂಬಾ ಆಯ್ತು ಮೇಡಮ್, ಆಯ್ತು ಮೇಡಮ್.
ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್. ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ.
ಆಯ್ತು, ನೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ. ಓಕೆ
ಓಕೆ ಸರ್, ಓಕೆ.